This is STV Glasgow, so let's find out what's going on. It's our latest STV Glasgow news, live from the heart of the city.
Good morning and welcome to a piece of television history. In 30 minutes' time, STV will become the first broadcaster in the UK to televise a Scottish court hearing live and in full. At stake is the political career of the former Secretary of State for Scotland, Alistair Carmichael. Our cameras will be inside the Court of Session in Edinburgh to cover proceedings brought on by the legal challenge to overturn his election as the MP for Orkney in Shetland. Here in the studio to help us navigate us through the day's proceedings is our panel of guests, all of whom have a keen interest in the case. We'll be hearing from them in a few moments' time, and we'll also be crossing to Westminster and to Orkney. But first to Edinburgh and STV's chief reporter, David Cowan, who's outside the Court of Session. David.
Yes, welcome to the heart of Edinburgh's Old Town, a place positively drenched in Scottish legal and political history. Behind me you have the Supreme Court's, the home until 1707 of the Scottish Parliament. This case, of course, centres on Alistair Carmichael's election to the Parliament at Westminster. It revolves around old-fashioned political skullduggery. Back in April, he denied any involvement in the leaking of a confidential Scotland Office memo designed to discredit the First Minister, Nicola Sturgeon. After his election, a Cabinet Office inquiry found that he had actually authorised that leak. He apologised but refused to resign. Four of his constituents, though, have challenged his election under the Representation of the People Act 1983, leading to this exceptionally rare hearing here at the Court of Session today. Mr Carmichael himself had been expected to attend, but then this morning the Liberal Democrats press office has announced that he's staying in Westminster on parliamentary business. They say his decision not to be here today had been taken on the advice of his solicitors and counsellors. So of course he won't be here to listen to the hearing that will decide his political future. Back to you.
David, thank you very much. There at the Court of Session, well, election court cases are a very rare occurrence. James Chalmers now looks at the circumstances that have led to today's showdown.
Alistair Carmichael is duly elected as the Member of Parliament for the Orkney and Shetland constituency.
The early hours of May the 8th, in one of the most remote parts of Scotland. Further south, the nation's political order is being dramatically upturned, but at the Cleckerman Centre in Lerwick, one MP clings on.
I think I have a small understanding of how Mark Twain felt when he wrote that reports of my death have been greatly exaggerated.
It's not just any MP, of course. Alistair Carmichael was the Scottish Secretary, for a few more hours at least. He won narrowly, beating the SNP by around 800 votes. By the time the dust settled on the general election, he was the only Lib Dem left in Scotland. Now, his re-election could be overturned. To understand why, we need to rewind, back to around 1 month before polling day.
A Cabinet Office-led inquiry has been launched into the leak of a UK government memo accusing Nicola Sturgeon of secretly supporting David Cameron for Prime Minister.
It had all the hallmarks of a political scandal. The secret memo published in the Daily Telegraph quickly ignited a row that became known as NikiLeaks. The First Minister said the newspaper's claims were 100% untrue, and she had some questions of her own.
How does a memo from within the UK, impartial UK civil service, find its way into the hands of the Daily Telegraph?
She demanded an inquiry into the leak, and attention quickly focused on Carmichael. He was asked by reporters what he knew and when.
I told you the first I became aware of this, and this is already on public record, was when I received a phone call on Friday afternoon from a journalist making me aware of it.
Fast forward again to after the election. The inquiry was complete and Carmichael was being questioned once more, but his answer had changed.
Despite having given the appearance that you didn't know very much about this leak, it turns out that you were really behind the leak.
I've accepted full responsibility for what happened here. This happened in my department. It involved my special advisor while I was the Secretary of State for Scotland. I could have stopped it, I should have stopped it. That was clearly an error of judgment on my part. For that I have apologised both to the First Minister and to the French Ambassador.
For some, that apology for sanctioning the leak didn't quite cut it. As the calls on him to quit gathered momentum, a crowdfunding effort was launched with a legal action in mind. The call for cash raised more than £10,000 in the first 24 hours. By the time it closed, the total was more than 60 grand. The money will pay for the lawyers, but that's only half the battle. To oust Carmichael, they need to prove he breached the 1983 Representation of the People Act.
They need to prove that he made a false statement and that it was made for the purposes of affecting the outcome of the election. So those are two things they need to prove. But they also need to prove, critically, that it relates to a candidate's personal character or conduct. Now, I understand that this case is about Alistair Carmichael making a comment about himself. And I anticipate that what he will probably argue is that the legislation is not necessarily about him, it would be about other candidates, because those are the other cases that we've seen from history.
Many people know you most for your Scots writing. But
one of those cases involved this man, the poet Hugh MacDiarmid. In 1964, he stood for the Communist Party in Kinross and West Perthshire. He lost to the Tory Prime Minister Alec Douglas-Home and then tried to have the election overturned, citing a dispute about party political broadcasts. It didn't work. More recently, a case in England was successful. Labour's Phil Willis had his 2010 election in Oldham East and Saddleworth overturned. The election court judges ruled he lied about his Lib Dem rival. So what kind of chance might today's petitioners stand?
I think that it's a difficult case to make out. First of all, the onus of proof is on them. Secondly, under the legislation, there are a number of hurdles that they have to cross. He has a possible safety net in his explanation, and he may well have an innocent explanation. And so I think it will be difficult, but it's not beyond the realms of possibility.
Which brings us to this morning and the Court of Session in Edinburgh. Remember, it's a civil law hearing we're talking about. Nobody's on trial, and there's no jury. But this election court case could carry significant political impact. The reputation of the former Secretary of State has already taken a big hit. Now it's his job as an MP that could hang in the balance.
James Chain there. Well, time now to introduce our guests. We are joined by the Regius Professor of Law at Glasgow University, James Chalmers, the writer and broadcaster, Lesley Riddoch, and the Liberal Democrat councillor and former Holyrood Minister, Robert Brown. Now, it's been claimed that Mr Carmichael breached the Representation of the People Act 1983. Section 159 of that Act states, if a candidate who had been elected is reported by an election court personally guilty or guilty by his agents of any corrupt or illegal practice, his election shall be void. Well, let's look at what the petitioners might need to prove. One, that Mr Carmichael made a false statement of fact, that the statement of fact has to be in relation to a candidate. The statement of fact has to be about the candidate's personal character or conduct. The statement has to be for the purposes of affecting the return of any candidate at the election. Well, let's bring in Professor Chalmers at this point. How do you see this going in terms of the legal debate that we're going to observe this morning?
Well, we've seen in the statement that Alistair Carmichael has issued this morning that he expects, although he won't be there, that the proceedings are going to focus on 3 questions of law, and they tie in with those 4 points you've just outlined. The first one isn't difficult. He made a false statement, and that's not a matter of dispute. But there are then legal problems thereafter. One, does the legislation apply to statements about yourself as opposed to speaking your opponents? Secondly, is the statement here actually one about his personal character, or is it one about his political character, which is something a bit different? And finally, was it a statement for the purpose of influencing the election, and in particular his election in Orkney and Shetland? So all those are tricky.
This might be a key point, because in the case which James referred to in his piece in 1965, the Hugh MacDiarmid in relation to Alec Douglas-Home, this was about party election broadcasts which Hume was making in his position as a national political leader. Now, do you expect that when we listen to the proceedings, Mr Carmichael's team will say that may well all be fine, but this didn't affect the outcome of the election in Orkney and Shetland?
Yes, and we can probably expect that they'll be referring to the Hugh McDiarmid case, which is one of the leading cases on that particular point. It's worth stressing that the petitioners don't have to try and argue that the outcome was actually influenced. The court isn't going to engage in a hypothetical exercise of was this important enough for the voters in Orkney to have gone a different way. If those 4 legal criteria are met out, then regardless whether it would factually make a difference or not, the election is void.
Okay. David Cowan, right at the top of the programme, of course, brought us the news that Mr Carmichael will not be in court. Let me just read to you a little bit about the Liberal Democrat press release which has been issued in the last hour. It says the decision not to be in court was taken on advice from solicitors and counsel. The hearing before the election court is dealing with 3 short questions of law. It is normal for parties not to be present while such legal questions are discussed. Robert Brown, does it surprise you that he's not going to be in court?
No, not in the slightest. In fact, I'm surprised there's ever an expectation he'd be there in the first place. I've done many legal debates in my time in my former capacity as a solicitor. Very, very rarely are the parties, in fact, present in court, largely for the reason that they don't have any function. They're not giving evidence. There's no kind of representation by them. They've got their solicitors or their counsel there to support them. And to be quite honest, it's usually a fairly tedious, legally heavy kind of event. So there's no purpose in their presence. Alistair's in London carrying out his parliamentary duties. That's what he's elected for. That's what he's doing. It's an important issue to do with the debate about refugees today.
Lesley, of course, we will listen to the legal debate. We will reflect on the legal debate. We will reflect on the points which both counsel will make. But this isn't just about law, it's about politics as well.
This is a civic case as much as anything else. I mean, there are 2 people going from the 4 that are the petitioners from Orkney at their own expense. They're taking their day off work because they think it's important enough to be there. And in fact, the whole 4 of them, if the case...
Heritage Roofing and Roughcasting is a family-run business with over 12 years' experience in roofing and roughcasting. We offer services throughout central Scotland, and we are determined to deliver high levels of customer satisfaction as well as competitive prices, like re-roofing from just £3,480. Call now to book your free, no-obligation roofing or roughcasting survey. Heritage Roofing and Roughcasting. Let us take care of yours.
Industry award-winning Saltair Motorcycles is simply the one-stop shop for all your motorcycling needs in Scotland. We have an enormous selection of used bikes, full ranges from Suzuki and Yamaha, and are the only dealer in Scotland selling Indian and Victory motorcycles. We have a huge range of clothing, riding gear and accessories. Our knowledgeable and friendly staff are always here to help, and our training school means that whether you're a novice or an advanced rider, Saltair Motorcycles has everything under one roof. Call us now or visit our showroom in Edinburgh.
Techno.
Jazz.
Techno.
Jazz.
Techno.
Jazz.
Shh. Have your say at scottpulse.com.
So we're agreed?
Looks fantastic. Great reviews. Let's book it. Hang on. Can I easily get travel insurance with my diabetes?
And your high blood pressure.
Sure you can. Stay Sure specialise in travel insurance for pre-existing medical conditions.
Even to the other side of the world?
Sure you can. Stay Sure offer great value travel insurance to suit you, wherever you plan to go.
Hi, Mum. Yes, we're going. Can we get cover for an 84-year-old with arthritis?
Sure you can. Choose from our single trip or annual multi-trip policies.
Let me call you back. So can we take Mum now?
Sure you can.
With 2 weeks comprehensive cover for Spain starting from just $20.75, call our UK contact centre free on 0800 054 2223 or visit staysure.co.uk.
The BT Price Drop brings you an earth-shattering offer for a limited time only on super reliable, super fast fibre optic broadband. Get BT Infinity and unlimited UK weekend calls for £10 a month. That's over 20% off. And it's just a 12-month contract. Plus, BT Infinity now comes with 60% more usage than Sky Fibre. And it's up to 5 times faster than the average speed of standard UK broadband. Order online by the 9th of September and get a £100 Sainsbury's gift card. Don't miss the BT Price Drop offer. Switch to BT today. Call 0800 800 950 or visit bt.com/drop.
Let's find out what's going on. It's our latest STV Edinburgh news.
Or the Isles, and I just feel it's a bit of a witch hunt, really. And I think that it's got to come to the point where there's been many people who have made mistakes and came through it, and I just feel that I think it's to get a total control of Scotland, because there is only Orkney and a couple others, or one other that managed to avoid being on the SNP control, and I fear that that's more like a dominant thing, and it's not uneven for the amount of votes that was cast in Orkney, or the amount of votes that was cast throughout Scotland. It's not totally an SNP country, but that's my thoughts on it.
So, I mean, Robert, I mean, you're listening to what Gordon Keith is saying. I mean, do you agree what he's saying there?
Well, I think people go out and vote on the policies that are presented to them at the time, and obviously the SNP's policies at the moment are talking to the people, and some of the other parties have kind of lost their way. There's a lot of infighting in some of the other parties, and I think that's put people off. So I don't think we want to turn today's issue into really a party political thing. I mean, to me, this is a search for truth, and hopefully at the end of a couple of days we're going to get an answer.
Thank you very much indeed for joining us, Gordon Keith and Robert Lesley. So we're going to be here in Kirkwall throughout the day watching proceedings. Back to you for the moment, Bernard.
Thank you very much indeed, Nicola. Robert Brown, let's pick up one of the points that was made there. One of the guys was saying that there's actually an appetite for this. Do you accept that there are a lot of people in Alistair Carmichael's constituency who are very, very angry by his conduct?
Well, I think there's a lot of people who've got a variety of different sort of motives. It's very difficult to actually deduce and say how many are this, how many are that. I'm told lots of people have been giving support to Alistair on a personal basis, coming up to him in the street, saying stick with it, all of that sort of stuff. I was impressed, I have to say, by the reasonableness of the way in which the two gentlemen from Orkney spoke, as you'd expect in many ways from the island community, and the approach that's been taken on that one. But let's be no doubts about this. There's a heavy element of politics behind this. I think the petitioners are all in various ways people have been associated with yes campaigning. That's the main motivation of all of this. That's what lies behind it.
I'll come on to this in a minute, but wouldn't the easy thing here for Alistair Carmichael, the easy course would have been to say, look, all of this came out after the election. I understand that some of my constituents have a real problem with this, and this could go to the heart of my integrity, but I will allow them to make a judgment on my conduct rather than let it go to court and simply resign and fight a by-election.
I think, to be quite honest, you get into a scene. I mean, this was, I think, a political statement that was made that's at the heart of this matter. Now, I know that's part of the issue we've yet to have determined, but it's manifestly made in his capacity as Secretary of State for Scotland in a situation where there was a political issue that lay behind it, not a personal one. Now, if you started challenging, and it's perfectly open to people to do that, don't get me wrong, if you started challenging every statement made by every MP or every person elected standing as a candidate, I think you'd land in a very considerable situation of challenge. So I don't accept, frankly, that this is the proper way to go about it as far as that's concerned.
I think this plague on all their houses argument is kind of shameful.
Not what I said
And I imagine, well, because what you seem to be suggesting is that there are such continual lies from MPs in the course of an election campaign that you'd be overturning lots of results. You also, I'd like to know what you mean by saying that there are political issues behind the people who have brought forward this complaint. What do you think that political issue is?
It's manifested at the election. The SNP had a major victory in terms of winning most of the seats in Scotland. This is one of the 3 remaining seats that isn't. And one of the political issues that lies behind this, of course, is an attempt to try and win that seat as well.
So why would it be the case then that one of the petitioners is a Green candidate One of the other petitioners is a Labour supporter who's just voted for Jeremy Corbyn, and I'm not too sure whether the other two are party members of anything.
OK, we will come back to one or two of these points, but we're expecting the proceedings in the Court of Session to get underway at about 10:30, so that's just over 10 minutes from now. We can now cross to London and speak to the Herald's Westminster correspondent, Kate Devlin. Kate, thank you very much indeed for joining us this morning. Alistair Carmichael, of course, was a high-profile member of the last government. What effect do you think it's had on him personally that he's now finding himself in an election court this morning?
Well, of course, Alistair Carmichael is not the kind of politician to wear his heart on his sleeve. That's one of the reasons why he was picked as Scottish Secretary for such a kind of crucial stage of the independence referendum. He was seen as very tough and very mentally tough and the right person from the UK government's point of view for the job at that stage. But I think it's fair to say that he would not want to be in this position, especially at such a difficult time for his own party. The Liberal Democrats, of course, are really struggling to kind of rebuild from the ground up after a disastrous election night when they went from more than 50 seats here in the House of Commons to just 8.
What has been the reaction from other MPs to this predicament in which he now finds himself?
Well, of course, it is being watched very closely by the Liberal Democrats. As I said, down to just 8 seats, of which, of course, this is one of them. Were they to face a by-election and perhaps to lose that by-election, they would then become smaller than the DUP, which, of course, only stands in Northern Ireland. So, I mean, it's seen as very much not just an issue for Alistair Carmichael, but an issue for the party as a whole.
And of course, not just a difficult day for him today in the election court, but at Westminster, the Standards Commissioner will be probing this conduct as well. Where do we stand with that investigation today?
That investigation is ongoing, and Alistair Carmichael is helping the Standards Commissioner with her investigation. What tends to happen with these things is that it continues until Catherine Hudson makes the judgment. Now, if you are a politician undergoing this process, it's a fairly rigorous process. It can also be an incredibly lengthy process, and some of these investigations have taken in the past more than a year. So there's probably still quite a long way to go before we would get an answer on that one.
Kate Devlin at Westminster, thank you very much indeed for joining us. Well, the venue for today's hearing is Court 1 in the Court of Session, Scotland's Supreme Civil Court. David Cowan got access to it to explain the setup.
This is Court 1 in the Court of Session in Edinburgh. Constructed in the first half of the 19th century, this beautiful room has witnessed a great many important legal cases over the years. And today, of course, it will witness a bit of television history as well. The two judges who are hearing this case, Lady Paton and Lord Matthews, will be sitting here on the bench. This is the first time they've heard a case involving the election court, because, of course, the last time a Scottish case took place was way back in the 1960s, when Hugh McDermott brought a challenge against Alec Douglas-Hume. The two judges will be facing the two legal teams representing the two parties involved in this case. Here, Jonathan Mitchell QC, the counsel for the petitioners, the people who are bringing this challenge against Alistair Carmichael, and to his left, Roddy Dunlop QC, representing the MP. Beyond them, in the public gallery, more members of the legal teams, members of the media as well. This is bound to be a well-reported case, and members of the public. STV will also have 2 cameras, one at the back of the bench there, the other in the balcony, and 2 more on either side of the judges, broadcasting these proceedings live to a potential audience of tens of thousands.
Well, as David Cowan told us, we'll be hearing from 2 judges and 2 QCs. The 2 judges are Lady Paton and Lord Matthews, and the 2 advocates are Roddy Dunlop and Jonathan Mitchell, and you will be hearing a lot from these gentlemen in the coming hours. Now, as we have mentioned, STV is achieving a broadcasting first with our live coverage of a Scottish court hearing. The station's head of news, Gordon McMillan, explained the thinking behind the move.
This is a unique first in British television and legal history, and we hope this will be a really good service for not just the people of Scotland, but particularly the constituents of Mr Carmichael in Orkney and Shetland, who will be able to watch from the constituency and see the discussion unfold minute by minute. What we've done with the Scottish courts is work very closely to establish a series of operational guidelines for coverage of this court. We've agreed that what can be shown and when the live proceedings will be broadcast and when they won't. We're very keen to work with the court and give them an assurance that we can deliver the coverage responsibly, that it won't be sensationalised, and that it will be a good public service, allowing people to see exactly what's going on in the court.
Well, we should be crossing to the court very, very soon, but let's go back to the panel and to Professor James Chalmers. We talked about just some of the legal issues in your initial contribution. What form will this hearing, once we cross to the court, what are we going to see?
Well, we're not going to see fireworks. This is referred to as the trial of an election petition, but it won't look anything like a trial as it's normally understood. What we can expect to see is actually fairly dry and technical argument, bringing out some of the earlier cases, and your correspondent referred to the Hugh McDiarmid case, which actually the lawyers will probably call Grieve against Douglas Hume, because that's the name under which it was reported. And there will be reference to these sorts of precedents, but the lawyers will probably be trying to tease out exactly what it would mean for the law to apply in this case, and what kind of consequences would that have. So would this mean, for example, that if Alistair Carmichael's election is voided, does that run the risk of the courts really getting drawn into an extent that they wouldn't want in elections in future? The petitioners are going to say no. It's quite likely, I suppose.
And is this also sort of slightly unusual in the sense that normally when you go to court, one of the things that you try to establish in examination and then cross-examination is the facts, but it appears that in this case the facts are almost admitted to. It's whether or not those facts fall within the ambit of the legislation.
Exactly. The facts are more or less agreed. If there's a need for evidence to be heard, that probably won't happen today. In fact, if Alistair Carmichael is going to give evidence, he's not even in the court today. So it's going to be purely legal argument. It won't be a trial as we normally understand that.
And what would you expect the judges to do? Would they go away and consider those arguments? What sort of timescale would you normally expect to see in terms of a judgment here?
Well, we've not got much precedent to go on there, but certainly the judge is going to be aware of the fact there's a lot of public interest in this. The uncertainty can't be left hanging on for too long. So to give you an example, in the Phil Willis case, which was mentioned earlier, the election court there handed down its decision in about 2 weeks after the case being heard. It's not impossible, I suppose, that a decision could be reached today, but I suspect the judges will want to take time to actually think about the reasoning for the decision before issuing that.
OK, before we go over to Lesley, I mean, let me just get a specific response to Robert Brown in his first answer. Did make mention of the fact that there was, in his view, some political motivation behind this. Do you think that this has been driven by politics and that there is a sense in which it is being overstated about the level of concern among Mr Carmichael's constituents?
I don't. Part of my family came from Orkney, so I'm there quite a lot, and I do know some of the folk. I mean, one of the petitioners, Tim Morrison, said to me, dishonesty matters so much here, I don't have a door key. We all look out for each other all the time. Now, Orkney is regularly voted the best place to live in Britain, and that's one of the reasons. It's because there's a really strong sense of community. And his reason for being one of those complainants is that breaking trust undermines something we know is fragile. Carmichael is imposing his lack of values on us, and that I resent. This is about decency. Now, you can say that that's something to do with the SNP trying to rule the entire Scottish political airwaves, or you can say that some people were just black affronted when they heard that. Plain and simple. And because I think activism had been raised by the independence referendum, yes, before it, I don't think anyone would have acted. But people are used to acting now, so that's why it happened.
Robert Brown, isn't it a fair point? Because, I mean, Alistair Carmichael, once he admitted to the behaviour, said that he wouldn't take his severance pay as a minister, and he conceded that he would have to have resigned as Secretary of State for Scotland. So if the offence that he has admitted to is good enough to resign as Secretary of State, why does it make him fit to be a Member of Parliament?
I think these issues arise quite often. So I suppose it's a matter of judgment, isn't it, about people's political actions in particular situations. You know, there is an element of comparison. You know, can you make any comparison with any other sorts of situations? I mean, I recall the furore there was when Alex Salmond had the problem with the European Union legal advice. Now, he spent lots of our money defending the proposition that they shouldn't have to release information about that, only to discover later on that there had been no legal European advice in the first place. Now, I think that's a not terribly different situation.
Didn't occur during an election,
No, of course it
only
didn't.
to be remedied after one.
No, it didn't,
so it's irrelevant.
it didn't occur during an election, but I mean, my point was, Alex Salmond didn't resign. He was a minister in the Scottish government at that particular stage. He didn't take that sort of action. And I think if you're going to be judgmental about Alistair Carmichael, which is entirely fair, I think there's got to be a certain element of comparison. You know, how does it fit in the overall scheme of things with other sorts of political situations?
One might make the argument, though, Robert Brown, that in a democracy, the arbiters of what is acceptable behaviour and unacceptable behaviour are the electors in a constituency, and therefore Mr Carmichael should have gone to his electors and said, I made a mistake, I'm sorry, the conduct was unacceptable, but I will allow you to judge me. But he's not given his constituents that opportunity, so they then have to go to court.
That would be all very well. I think this goes to the heart of one of the issues here. If this had been directed at one of his opponents in the election in Orkney and Shetland, there's a much more general issue as far as I can see. And I think that's actually one of the things, therefore, that's at the heart of this.
Let me pick this up with Lesley, because this might be a really, really key issue as we hear these speeches from the QC, namely that, yes, this is conduct and you can take your view about what that conduct amounts to, but that it's a rather large leap in law to suggest that this conduct actually affected the result in Orkney and Shetland.
Yes, I know they're up against a tough case today, that's absolutely for sure. But whilst the subject matter was something that affected arguably the entire election campaign, which I think is why people were so horrified by it, it's talking about his personal probity. Now, people went into that election thinking he was a straight-up guy, and it turned out he wasn't. He was somebody who thought it was perfectly all right not just to leak something, and that happens all the time. I would kind of agree with Robert with that.
And special advisors
special advisors doing cute things, that happens too. It was the point that he lied about the fact that it was him that did it through the crucial period when people in Orkney and Shetland were making up their minds about whether this was the kind of guy they wanted. And I would suggest that probably there are very few constituencies in which this issue of personal probity and trust matters more.
Okay, I mean, again, but I'll make the point, there's the politics and there's the law. Given the circumstances, Professor Chalmers, from the petitioner's point of view, how arguable a case in law do you think they have?
They have difficulty on all 3 points, and you might think that any one of these points is winnable. Persuading the court on all 3 is a pretty tough task, and also distinguishing this case from others. Now, Lesley mentioned leaks happen all the time, but part of leaks tend to involve actually lying or denying being the source of the leak. Would this mean that any leak in future, if a politician during the election campaign, regardless of when the leak happened, if they're asked a question about being the source of that leak and they deny it, are they then vulnerable to an election petition? And there's an interesting question there in law about how you would distinguish this case, which legally is based not around the leak itself, but purely around the lie during the campaign. How would you distinguish that from others?
We mentioned the Grieve case in '65, we mentioned the Phil Willis case. Can we learn anything from these previous cases, or is it really, as all lawyers like to say, it depends on the facts and circumstances of each individual case?
We can learn a little bit from the Hugh McDiarmid case, because that involved this distinction between the national campaign and the constituency campaign. The Phil Willis one was really rather different. That was a case where there was less doubt about whether or not the facts would have amounted to an illegal practice. There were some interesting suggestions in that case, however, that actually, yes, the legislation, although it wasn't an issue there, one of the judges said the legislation is wide enough potentially to extend to statements about yourself which are positive. So you can expect, I think, to see the petitioners relying on that in support of their arguments.
Well, you probably have noticed that we're at 10:35, so things are running a little late. The wheels of justice do tend to go really rather slowly, but as soon as the macer comes into the court and Judge Court, we will cross over to find out what's being said. Lesley, interestingly, I think I'm correct in saying that legal aid is not available for these kind of petitions. So, I mean, if you really want to bring this, you either have to have deep pockets or you have to have a lot of folk that are very angry.
Yes, and that's exactly the point. I think also there was a Recall of MPs Act passed, but it was not enacted just at the point at which all of this came to light. So the will of the House of Commons is that they want to make it easier for people to be able to question their MPs. And the mechanism, frustratingly, was just a couple of weeks out of functioning for the Orkney and Shetland people. So they are stuck at the tail end of a situation where nobody has been able to question things. And it's a terribly ironic situation they find themselves in, where on the one hand, they have to prove a specific link, in this case, to their own constituency, but the case could all be coloured by the fear by the judiciary that it might impugn all sorts of future occasions in a very general way. You might think that's actually a really unfair set of hurdles to be placed in front of 4 people who stand to lose everything if they lose.
Robert Ryan?
Well, I think the hurdles are placed there by the legislation. It's fair to say, although this is the 1983 Act, that itself is a consolidating act, and it's based essentially on legislation that goes way back to the 1860s.
Okay, let's cross to the court.
Good morning, everyone. This is the petition of Morrison against Carmichael, and today the court will hear legal debate. So the court's going to hear legal debate about the meaning and effect of a statutory provision, Section 106 of the Representation of the People Act, 1983. Now, I want to make it clear at the outset that this legal debate is the only matter before the court today. Nothing else is before the court, and the only persons entitled to address the court today are Mr Mitchell QC on my left here for the petitioners, and Mr Dunlop QC on my right for the first respondent, Mr Carmichael. So I want to warn all of you that if there's any interruption or disturbance by anyone, that person will be escorted out of the courtroom by security staff. Having said that, I should tell you that the court sits between 10:30 and 4 o'clock. There will be a break of 1 hour for lunch. I think the court may allow a short break in proceedings at about 11:30. And having said all that, the legal debate will now begin with Mr Dunlop QC on behalf of Mr Carmichael addressing the bench. Yes, Mr Dunlop.
I'm obliged, my lady. My lady, my lord, I move the court on behalf of Mr Carmichael to dismiss this petition as irrelevant in the Jameson sense, by which of course I mean that even if the petitioners prove all that they aver, the petition is nevertheless bound to fail. The court has in advance seen notes of argument for both parties, and I formally adopt that on behalf of the first respondent. And in what follows, I will largely follow the structure set out in that note. And as your ladyship has already noted, we are, of course, here to discuss 3 discrete issues. The background to those issues is well known and largely undisputed. Shortly after the dissolution of Parliament on the 30th of March 2015, the Daily Telegraph newspaper reported a leaked memorandum which suggested that Nicola Sturgeon, First Minister and leader of the SNP, had indicated to the French ambassador that she would prefer it if the Tories were to win the forthcoming general election. That memorandum had been leaked to the Telegraph by Mr Rodden, Special Advisor to Mr Carmichael, who was at the time the Secretary of State for Scotland. Mr Carmichael had been asked to, and did, assent to the leak. Ms Sturgeon demanded an inquiry into the leak, and one was incepted under the auspices of Sir Jeremy Haywood on the 5th of April. And that same day, Mr Carmichael was interviewed by Channel 4, the interview being broadcast, and he said the words complained of in the petition at Statement 5. In short, he disclaimed any prior knowledge of the leak, and it's accepted that that was not correct. On the 7th of May 2015, the general election took place, and the following day, the 8th, Mr Carmichael was returned as the Member of Parliament for Orkney and Shetland. The petitioners argue that what Mr Carmichael said is such as to offend against Section 106 of the Representation of the People Act 1983, with the consequence that his election is void. And this hearing has, of course, been appointed to determine the three issues crystallised in the notes, and in short, to determine whether there is anything that requires further inquiry by the election court. Now, the court will have seen that Section 106 has a lengthy history, and it is traced back to the Corrupt and Illegal Practices Prevention Act of 1895. Now, that long statutory history is important, but this court is largely relieved from trawling through it because, in my submission, of the authoritative guidance now found in the decision of the Divisional Court in the Woollis case, to which I will take the court shortly. But we should perhaps begin with Section 106.
Based on your note of argument, I think you're going to follow. Just remind me where precisely in the index is the note of argument?
The note of argument, my lord, in the index is at tab. So we have the notes of argument at tab 3 and tab 4, and the note of argument for the first respondent is tab 3.
It's in a slim folder, I think, Mr Dunlop. Part B of the various productions, yes.
I'm obliged, my lady. I am working from the electronic bundle, so I hope that won't cause too much confusion as to what is where.
I've got it now, thank you, yes.
In a similar vein then, Section 106 is found at tab 6. Tab 6.2 of the bundle. And it's page 184. Hopefully the bundle which the court has been, the pages have been sequentially numbered.
They have.
Top right hand,
yes,
top right-hand corner.
Yeah.
Page 184 of the joint bundle is Section 106. And what is provided there is that a person who, or any director or any body or association corporate which, before or during an election, for the purpose of effecting the return of any candidate at the election, makes or publishes any false statement of fact in relation to the candidate's personal character or conduct, shall be guilty of an illegal practice, unless he can show that he had reasonable grounds for believing and did believe the statement to be true. And it's that first subsection on which the majority of the focus will be today.
I think we've lost the feed from the Court of Session. I don't know if we can return. Obviously, the opening submission, which was being made by Roddy Dunlop QC, where the thrust of his argument going to be that this is all irrelevant. Professor Chalmers, very early on in his submission, he said that he would be seeking to ask the judges to dismiss this. We've got it back. Let's go back to the Court of Session.
Or of a body or association corporate. The statement needs to be made before or during an election. The subject of the statement must be a candidate at the election. The statement must be made for the purpose of affecting the return of that candidate at the election. The statement needs to be a statement of fact. The statement needs to be false. And the statement must be in relation to the candidate's personal character or conduct. Now, it's those constituent parts that give rise to the discussion this morning. But before going to the three chapters, if I can just look at certain general principles of interpretation, and in particular highlight 3 points which I say are of assistance in the Court's consideration. The first is that a strict interpretation or a narrow interpretation is appropriate. I say that because Section 106 is plainly penal in its nature. It's penal in the sense of importing a criminal offence. But it's also penal in the sense of deprivation of office, disqualification from sitting as a Member of Parliament, or even voting in a parliamentary or local authority election. Without needing to, I think, presently to take the Court to it, those consequences flow from Section 160 of the Act. And those consequences are extremely serious. Now, there's reference in the notes to what that means with regard to the standard of proof. But given the narrow discussion before this Court today, we can perhaps put that to one side. And the importance of the gravity of the consequences lies more in this need for the Court to adopt a strict or narrow construction. Now, that is a point which comes out from Woolas, and I'll take the Court to Woolas shortly, but first, could I take the Court to Benyon on statutory interpretation, which was lodged as part of the supplementary bundle, should be tab 6.31. and the joint bundle page number, top right-hand corner, is 1080.
Right. Yes, Benyon. Thank you.
And it's part 17 of Benyon, Principle Against Doubtful Penalisation. And I think I can skip the introduction and ask the court just to look at sections 271-282, and then we have section 271, Principle Against Penalisation under Doubtful Law. It is a principle of legal policy that a person should not be penalised except under clear law, in this code called the Principle Against Doubtful Penalisation. The court, when considering, in relation to the facts of the instant case, which of the opposing constructions of the enactment would give effect to the legislative intention, should presume that the legislator intended to observe this principle. It should therefore strive to avoid adopting a construction which penalises a person where the legislator's intention to do so is doubtful, or penalises him or her in a way which was not made clear. In some cases, however, the court may find that the intention to impose the detriment was so strong as to require the doubt to be overridden. And then if the court turns the page, we see at the top of page 750 of Benyon. In this context, the term penal has been treated as a term of art and yet given different meanings. This is misconceived because a law that inflicts hardship or deprivation of any kind is in essence penal. There are degrees of penalisation under statute, but the concept of detriment inflicted through the state's coercive power pervades them all. Accordingly, this code is not concerned with any technical rules about what is or is not a penal enactment. The substance is what matters. The courts have adopted and accepted the following position. The true test is now considered to be whether a particular construction inflicts a detriment or greater detriment on persons affected. A law that inflicts hardship or deprivation of any kind on a person is in essence penal. There are degrees of penalisation, but the concept of detriment inflicted through the state's coercive power pervades them all. The substance, not the form of the penalty, is what matters. The law is concerned that a person should not be put in peril of any kind upon an ambiguity, hence the principle against doubtful penalisation. Lord Justice Chadwick notes that it applies to civil liability as well, and then under the italicised heading nature of the principle, the editors continue. Whenever it can be argued that an enactment may have a legal meaning requiring infliction of a detriment of any kind, the principle against doubtful penalisation comes into play. If the detriment is minor, the principle will carry little weight. If the detriment is severe, the principle will be correspondingly powerful. However it operates, the principle requires that persons should not be subjected by law to any sort of detriment unless this is imposed by clear words. Mr. Justice Brett said, "Those who contend that a penalty may be inflicted must show that the words of the Act distinctly enact that it shall be incurred under the present circumstances. They must fail if the words are merely equally capable of a construction that would and one that would not inflict the penalty." And as I'll come back to stress in my submission, that passage from Mr. Justice Brett, it may be of some moment in the particular circumstances of this case. Just over the page again at 751, the first full paragraph or second full paragraph on that page after the indent, narrow construction. The principle against doubtful penalisation is sometimes expressed by using the words narrowly. Thus Lord Justice Dyson, as he then was, said of a doubtful definition, because there are potential penal consequences, its very obscurity means the words should be construed narrowly. Whether strictly or narrowly is used, the effect is the same, namely that if the case lies within the penumbra of doubt surrounding unclear statutory words, the finding should, in the absence of compelling reasons, be for the accused. Just for completeness, I note that the editors of Benyon include, as embraced within this part of the law, the statutory interference with status or reputation, and that's at page 769.
Yes, I see. Yeah.
And what we have here my lady, my lord, is a very clear case of a very serious deprivation. Because, as I've already sought to stress, it imposes criminality. It causes the loss of a parliamentary seat. It disqualifies the person from standing for election. And it disenfranchises the person for 3 years. When the court thinks back to section 106, can I suggest that two further factors really underline the need for a strict or narrow interpretation? Section 106 strikes at the person who makes or publishes a statement. So it is infringed no matter what currency is given to the statement. There's no need for the impugned statement to be found in electioneering material or in press statements. A false statement made to a small group, even one amongst friends, would infringe section 106, as long as it met the other requirements of the Act. The second point, which I suggest militates in favour of a strict or narrow construction, is that there is no need for the false statement to have any causative effect. The consequence of the making of the statement is the loss of the seat, regardless of whether or not it conceivably could have made any difference. A landslide victory would fall to be annulled by a false statement of complete peripherality. As long as it met the other requirements of the Act. These are extreme results, and the brake that the law applies on those extreme results is the need for a strict or narrow construction.
Just one matter, Mr Dunlop. I think the Act, 1983, makes provision for mitigation and remission of incapacities. Would you accept that in section 174?
It does,
yes,
my lady, but...
So in relation to that last example, say a statement of complete peripherality, when there had been a landslide victory, that might well be a situation where an application could be made to the court.
But it would require that secondary application to be made to the court.
Yes, it would. That's right.
So that by then, the consequences of 160 have passed, and they just have to then be mitigated.
Well.
So, yes, it's of relevance, and of course the court will look at the statute as a whole. But the stark fact is, very serious consequences follow.
Right. Can you just remind me how the criminality comes into play?
Criminality, my Lord, is section 159 of the Act. What page is that? I'll just get your Lordship the page number.
2358, I think.
358, your Lordship has it.
Yes, so where, just echoing Lord Matthews' question, where it certainly talks of an illegal practice and the result being the election will be void, but where's the actual mention of criminality?
160, my lady.
160?
Yes.
Right, thank you.
Yes, 364 for Scotland.
364, right. So just which part of 160, just to be quite clear about this then?
I'm sorry, my lady, I think it's actually section 169.
169.
Yes, it's 169. Prosecution for illegal practices.
No, this is 169 not corrupt?
168 is corrupt, my lady.
All right, so 169, oh yes, I see. Prosecution.
A person guilty of an illegal practice shall on summary conviction be liable to a fine not exceeding level 5 on the standard scale. And a prosecution for illegal practice, it should be sufficient to allege the person charged was guilty of an illegal practice.
So there would be, as you say, the possibility of criminality if the Procurator Fiscal chose to prosecute?
Yes.
Right. Thank you.
Now, my lady, my lord, the second point of general principle, which I suggest is of some assistance, relates to the force of previous interpretations. Where a statute has adopted words that have historically been given a particular meaning by the courts, that meaning is taken as being intended by Parliament. And the authority for that is the decision of the Lords in the case of Barras against the Aberdeen Steam Trawling and Fishing Company, at tab 6.8 in the joint bundle. Page 612 of the joint bundle.
Yes.
Now, this is a very different scenario. We're just considering the meaning of the word wreck in terms of the merchant shipping legislation. But the point which I seek to derive is made by Viscount Buckmaster at page 27 in the report, page 618 in the joint bundle. The background to this case was that there had been a decision of the Court of Appeal in a case called the Olympic on a prior but identically worded statutory provision. The Inner House then required to look at the meaning of that new statutory provision. And the question before the Inner House and subsequently before the House of Lords was, what was the effect of Parliament reenacting the provision in light of the previous decisions? It's the second paragraph on page 27, 6 lines in, where Viscount Buckmaster says, "It has long been a well-established principle to be applied in the consideration of Acts of Parliament that where a word of doubtful meaning has received a clear judicial interpretation, the subsequent statute which incorporates the same word or the same phrase in a similar context must be construed so that the word or phrase is interpreted according to the meaning that has previously been assigned to it." Lord Justice James, in the case of ex parte Campbell, expresses the rule in the following terms: "Where once certain words in an Act of Parliament have received a judicial construction in one of the superior courts, and the legislature has repeated them without alteration in a subsequent statute, I conceive the legislature must be taken to have used them according to the meaning which a court of competent jurisdiction has given to them." And this opinion was expressed in a case where the learned Lord Justice himself said it was difficult to bring the interpretation within the words of the Act. The same opinion was expressed by Lord Halsbury in delivering the judgment of the Judicial Committee in the case of Webb, and I know of no authority that has in any way weakened the effect of this pronouncement. It is, in my opinion, a salutary rule, and one necessary to confer upon Acts of Parliament that certainty which, although it is often lacking, is always to be desired. Now, this is not just a mere guide to interpretation, because when one thinks about the case before the Lords, the prior authority, the Olympic, was a decision of the Court of Appeal. Therefore, it wasn't binding on the Inner House, nor, of course, was it binding on the House of Lords, unless it were the case that Parliament had effectively approved it. And that was what the Lords ruled. And we see the strength of the point from the speech of Lord Warrington of Cliffe, at page 44 in the report, at page 635 in the joint bundle. It's the third paragraph, just above halfway down the page. In the case of the Olympic, it was decided by a majority in the Court of Appeal that the wreck or loss of the ship referred to in the Merchant Shipping Act of 1894 includes any accident occasioned by a peril of the sea which renders the ship unfit or unable to proceed on the voyage. It discusses further the effect of that case. Next paragraph. To return to the first question, the case of the Olympic clearly decided the point. It is, however, a decision of the Court of Appeal and would prima facie be open to review in this House. For myself, I should not, I think, differ from the view of the Court of Appeal, even if I thought myself at liberty to decide the other way. But this is immaterial if it be true that this House is not now at liberty to overrule their decision. The present case is, in my opinion, covered by the judgment of Lord Justice James in ex parte Campbell. And we see, again, the citation from that case and Lord Justice James's dictum. And at the foot of that page, counsel were unable to refer us to any case in which the view of Lord Justice James has been questioned. It's particularly applicable here. So that is the second principle of interpretation that I suggest is helpful, where Parliament legislates against a background of judicial pronouncements. It may be taken to have affirmed those pronouncements. And the final point of principle is almost a corollary of the second. And it is this, that where Parliament legislates against a background of a known practice, unless it expressly outlaws that practice, one should not assume that it does so. That is particularly so when it would have been easy to make express provision for the prohibition which is argued for. I take that proposition from the authority flowing from the last time the election court sat in Scotland, being the decision in Grieve against Douglas Hume, tab 6.10 in the bundle. And I'm looking at page 335, page 672 of the joint bundle. This is in the opinion of Lord Kilbrandon.
Right.
And it's 6 or 7 lines into the final paragraph on that page, where His Lordship says, "We're being asked to construe the intention of Parliament from the terms of section 63, the words of that section not expressly prohibiting the practice complained of, but as it has been submitted, prohibiting it by necessary implication. In these circumstances, it seems to me to be a sensible canon of construction that if a practice is known to Parliament when Parliament is legislating on a question which involves a consideration of the legality of the practice, then unless the resultant statute uses words clearly prohibiting the practice, it ought to be presumed that Parliament does not intend the prohibition of the practice. This is a rule of common sense rather than substantive law. It is clear that section 63 does not expressly prohibit the practice as it easily could have, and that is perhaps all the more remarkable in view of the provisions of section 80, whereby the broadcasting of political propaganda from foreign stations, otherwise in pursuance of arrangements made with the BBC, is expressly made an illegal practice." And again, it will be my submission as we go through this discussion.
This is to do with allegedly unauthorised expenditure.
That's right, yeah. In connection with broadcast, a party political broadcast, in advance of the general election.
How are you saying this could have been achieved by something along the lines of any person who, whether or not a candidate and whether or not he is the candidate to whom the statement refers, something like that?
Absolutely. It would be the easiest thing in the world to make section 106 say expressly that which Mr Mitchell contends it says implicitly. Now, these points of principle in my submission are all reaffirmed by the recent decision to which I've already adverted in the Willis case. And if I could perhaps take the court to Willis just now, tab 6.19 in the bundle, Willis is of particular interest for a number of reasons. It's recent, and many of the cases are not. It's post-Human Rights Act introduction. And it is a decision of a three-bench or three-judge divisional court overruling in part a decision of the election court by way of judicial review. And the court was chaired and the decision delivered by the now Lord Chief Justice of England and Wales. Lord Justice Thomas, as he then was, looks at the questions of interpretation and principles of interpretation, starting at page 30 in the report, page 867 of the joint bundle. Paragraph 82. It is next necessary to consider how Section 106 should be interpreted. We consider there are 5 factors we should take into account. 1. The penal nature of the provision requires certainty. It is a provision which also carries a penal sanction on conviction, as a person convicted before a criminal court of an illegal practice, including making a false statement under Section 106, is liable under Section 169 to a fine. The provision therefore must have the requisite certainty. 2. The imposition of criminal liability for negligent statements. Although findings of dishonesty were made in the present case in respect of 2 of the statements, it is sufficient in the language of the section that the statements were negligent. Indeed, that is why Mr Willis was found to have made a false statement in Choose in relation to Mr Watkins not moving to the constituency. The wording of Section 106, unless he can show that he had reasonable grounds for believing and did believe that statement to be true, is identical in effect to the provision in Section 2.1 of the Misrepresentation Act, unless he proves he had reasonable grounds to believe and did believe, up to the time the contract was made, that the facts represented were true. In short, Section 106 makes it a crime to make or publish the specified statements carelessly, even if they were made or published honestly. 3. The scope of those affected. The section applies to any person who makes or publishes a statement, not just to candidates or their agents. 4. The effect of Parliament's reenactment of the provision in light of decisions on its meaning. The 4th factor is the effect of earlier decisions on the equivalent provision in Section 106 and earlier legislation. On 6 July 1895, Parliament enacted what is now the provision in Section 106 of the 83 Act as to false statements of fact in relation to the personal character or conduct of a candidate by Section 1 of the 1895 Act. This Act amended the 1883 Act. During the passage of that Act, an attempt had been made to include a provision as to false statements, but it had not been included. The provision in the 1895 Act was consolidated into the 1949 Act and retained it in the same form in the 1983 Act. And then a recitation of various cases that had been decided. And just above letter D, it is well established that the presumption is that Parliament has adopted the meaning given by the courts. The principle is established by Barras, the case that the court's already been taken to, and is set out in Benyon. Parliament is normally presumed to legislate in the knowledge of and having regard to relevant judicial decisions. If therefore Parliament has a subsequent opportunity to alter the effect of a decision on the legal meaning of an enactment, but refrains from doing so, the implication may be that Parliament approves of that decision and adopts it. This is an aspect of what may be called tacit legislation. Now, in the same case, I think just before we leave, I'll need to come back to it for a different reason, but on the question of principle, if I can take the court 2 pages on to page 870 of the joint bundle, page 33 of the report, paragraph 89, the effect of Article 10. The 5th factor is the effect of Article 10 of the Human Rights Convention, which guarantees the right of freedom of expression. Any court considering whether there's been a breach of Section 106 is obliged to have regard to it. As was said by the European Court in Bowman, free elections and freedom of expression, particularly freedom of political debate, together form the bedrock of any democratic system. The two rights are interrelated and operate to reinforce each other. For example, as the Court has observed in the past, freedom of expression is one of the conditions necessary to ensure the free expression of the opinion of the people in the choice of the legislature. For this reason, it is particularly important in the period preceding an election that opinions and information of all kinds are permitted to circulate freely. Although we have referred to this decision of the Strasbourg Court, it is important to stress that the principle that elections should be free, far from being introduced into the law of the United Kingdom by the Human Rights Convention, has for centuries been the basis of our democracy. The Statute of Westminster of 1275, elections ought to be free, and Article 8 of the Bill of Rights, election of members of Parliament ought to be free, are both enforced to this day. The 1895 Act was one of a series of measures designed to ensure that elections were conducted in a manner that ensured that elections were free. I think I can skip over the next couple of paragraphs, and if we turn the page to 94, the Court's conclusion on interpretation. At 94, although we agree with the Election Court that Article 10 has to be taken into account, we do not consider the basis upon the Election Court did so was correct. There would, in our view, appear to be little scope for any reading down of the statutory consequences of a finding of an illegal practice under Section 106 to make it compatible with the Convention. As we've explained at paragraphs 31 to 2 above, the function of a parliamentary election court is a limited one. It must determine whether there has been an illegal practice and then certify and report to Parliament. It is not its function to determine the consequences. Those are either for Parliament or flow automatically under the 1983 Act. And that's perhaps a better riposte than the one that I offered to my Lady Paton's question about mitigation of consequences. There are serious consequences and they follow automatically with little scope for the court reading them down. And His Lordship then said, it must therefore follow that as an election court cannot mitigate the consequences of its findings, any disproportionate consequence of the findings of the court must be taken into account at an earlier stage, in particular in the election court's determination of whether or not the court should find that there has been an illegal practice under Section 106. In our view, this goes not merely to the standard of proof determined by the nature of the case, but to the interpretation placed on Section 106. Now, as I say, I'll need to ask the court to come back to Willis in due course, but for present purposes, the important point I ask the court to take from it is recent affirmation at a high level of at least the first two of the 3 points of principle that I urge upon the court, i.e. strict penal construction and the relevance of earlier decisions. Now, Lady and Lords, I'm moving to the first chapter of the submission, so the question about whether or not Section 106 is engaged by self-talking. We are just shy of 11:30. I'm in the court's hand as to whether or not...
No, I think that would be a convenient moment then to break just for 10 minutes. So court will adjourn for 10 minutes and reconvene at about 11:30, thereabouts.
Ready. Court. And so, Lady Paton, adjourning the court for 10 minutes as Roddy Dunlop will go on to the next stage in his submission. Now, what we've heard essentially in that opening 40 minutes of legal submissions, and I will appreciate that you, the audience, like me, are not lawyers, that this is all very, very dry stuff. So let's just try and give some sort of form and some sort of context to the submission that we've just heard. And before we perhaps isolate some of the submissions that Roddy Dunlop made, Professor James Chalmers, Did anything that he say in terms of the general approach surprise you?
No, I don't think there was anything there that was surprising at all. This is a statute which creates a criminal offence, and there's a very clear rule that you interpret any criminal offence narrowly, that you don't assume that Parliament intended to criminalise something unless it's absolutely clear that that was its intention. So I'm not even sure there will be much disagreement. There'll be differences of emphasis between the sides on this. And this makes the case of the petitioners more difficult, but it's not a knocked-down argument in any sense.
OK, well, he set out his case in terms of Section 106 of the Act fairly early on in his submissions. Let's just have a quick look at the first clip.
My Lady, my Lord, I move the court on behalf of Mr Carmichael to dismiss this petition as irrelevant in the Jameson sense, by which of course I mean that even if the petitioners prove all that they aver, the petition is nevertheless bound to fail. The statement needs to be made before or during an election. The subject of the statement must be a candidate at the election. The statement must be made for the purpose of affecting the return of that candidate at the election. The statement needs to be a statement of fact. The statement needs to be false. And the statement must be in relation to the candidate's personal character or conduct.
Robert Brown, he seems to be saying there that the whole issue of relevance is a key one here, and clearly where he's going with this argument is that the statement is not relevant in terms of as it relates to Orkney and Shetland.
I think that's right, and I think he's got a number of general points really for saying that. Very interesting, as a matter of fact, that in the Douglas Hume case back in 1964, which has been referred to, one of the points made there was because the broadcasters, remember there was a Prime Minister broadcasting to the country, if you like, during election broadcasts and so forth, because they were aimed at the whole of the country. They were not aimed at promoting the election of Douglas Hume himself in the constituency in which he was standing. And of course that was a Scottish constituency, as you recall, at that time. So that's, I think well, it'll be interesting if that comes out later on. I'm sure it will be, as one of the key points going forward.
Lesley, you and I are at a distinct disadvantage because we're the two non-lawyers here. What did you make of the opening statement?
Well, I'm sure, I mean, I was just noting we've had tabs, bundles, long pauses, Viscount Buckmeister and the perils of the sea. I mean, it's hard to keep up with it, to try to see how it all fits together. But that last little sentence before we ended, the lawyer, Roddy Dunlop, said there are serious consequences from a verdict here, and they flow automatically with little scope for the court mitigating them. Now, it seems to be this argument is about the penal nature of what might happen if Alistair Carmichael is found to have made a false statement. I'm sure a lot of people watching might just think kind of tough, because there's pretty penal things that happen to people in most walks of life and employment if they're found to have lied in the course of their job, or indeed even as personal, in their personal capacity. So it feels a little bit like, as a non-lawyer sitting in the midst of this, that there's kind of a bit of a, we're on a double standard here, where, of course, this is a serious matter. That's why people have put their livelihoods at risk. That's why 87,000 quid's been raised.
Well, let's just stick with that point, because Roddy Dunlop went on to outline the sanctions and consequences if the case went against Alistair Carmichael, saying that they would be severe.
It imposes criminality. It causes the loss of a parliamentary seat. It disqualifies the person from standing for election. And it disenfranchises the person for 3 years. When the court thinks back to Section 106, can I suggest that two further factors really underline the need for a strict or narrow interpretation. Section 106 strikes at the person who makes or publishes a statement. So it is infringed no matter what currency is given to the statement. There's no need for the impugned statement to be found in electioneering material or in press statements. A false statement made to a small group, even one amongst friends,
So Roddy Dunlop there initially setting out what the sanctions would be should the court find against Alistair Carmichael, but quite a lot of the submission in those early exchanges were about this concept of narrow interpretation. What's he driving at there, Professor Chalmers?
Well, he's driving at the fact that we've already identified there are 3 issues on which the petitioners and Alistair Carmichael are going to dispute what the legislation actually means. And so in every one of these 3 cases, Roddy Dunlop is trying to argue you have to go for the narrow interpretation. This sets out a criminal offence. This causes somebody to lose their position as an MP. It's Parliament. It's the court interfering in the result of an election. So the court can't do that lightly. You err on the side of caution.
Is the argument here that if the court was not to take a narrow interpretation of the law, and it took a very wide interpretation of the law, that it would open up a Pandora's box of potential challenges from candidates raking through what opponents have said in the general sense?
Possibly, although cases of people who are alleged to make false statements about themselves are likely to be relatively few and far between, depending perhaps on the approach that the court takes to what could be included. But generally, of course, the courts are not going to want to get involved in elections. They're not going to want to overturn election results unless the legislation makes it clear that that's their job.
I was going to say that nobody really knows what a judge thinks, and of course you will get an official judgment, but will it be weighing on their mind that there might be not a public interest in taking an interpretation which is not narrow, which would signal that other people could come to court and make challenges?
Well, exactly. I mean, as I've said, they don't want to be hearing election petitions. I'm sure this is not something any judge particularly looks forward to doing, and more of these in the future would not be an attractive prospect.
Well, it might be for democracy.
Well, yeah, it might well be. But I suspect the judges themselves. Well, on the other hand, democracy might suggest that actually these things have to be dealt with at the ballot box. The problem, of course, is you've got to wait 5 years for that to happen. I accept that as a difficulty.
But isn't the wider point here, Lesley, that at the moment it appears to aggrieved constituents the only route that they have is to go down the route of the election court, and that there should be other mechanisms by which constituents who have an aggrievance against an elected member can bring them forward?
Well, quite, and I appreciate this is the legal nuance of this, and it's like a dressage event, this, not a steeplechase run. It's very particular. But, you know, the fact that the Commons has passed a Recall of MPs Act suggests that if you're talking about the will of Parliament, it's most recently been stated as being inclined to want change.
Robert?
Yes, but with great respect, not in all circumstances. The Recall of MPs arrangements, which actually were stimulated by the Liberal Democrats specifically, you are stimulated by certain circumstances. It's not a general open house. Just
what is it for?
Well, it's got to be done in certain circumstances. That's the point. I'm not particularly familiar with the detail of that particular legislation, but it's not just anybody who feels they've got a grievance can raise an issue. It's got to be stimulated by certain things happening. More to the point, you've still got the core point that at the end of the day, these criminal or quasi-criminal sanctions, if you like, that are imposed on an MP in these circumstances, fine to do that in proper circumstances, but it's got to be in accordance with the law. If the legislation allows it, bearing in mind this is stuff that goes back to the 19th century, has been interpreted over many years, and hasn't had this particular aspect raised, as far as I'm aware, before, I think it's reasonably clear that Parliament didn't intend these particular sorts of circumstances to be raised. And that's one of the issues here.
Can I ask you both as lawyers a question then? I mean, if I was found to have lied, to have leaked something that was injurious to other people, and had then lied about my role in it in my ordinary job as anything, would I be sacked?
We will come back to that, but let's go back to the court.
Yes, Mr Dunlop, thank you.
Milady, just before going to Chapter 1, it occurred to me, prompted by Milena Junior, that I should perhaps just address in slightly more detail and very quickly why it is that Section 174, raised by Milady in the chair, doesn't actually affect this in any material fashion.
Right.
Your Ladyship's quite right when she says it deals with mitigation and remission. But when we look at Section 174, page 434 in the bundle, at tab 6.2, page 434.
Yes.
We see from the statutory provisions why it is that Lord Justice Thomas said what he did about there being very little ability in the Act to mitigate. Because 1741 only applies where there has been an imposition of some incapacity by the election court, and then, under subsection B, an acquittal on prosecution. So the consequences of Section 160 have followed on any view. So what the statute is envisaging here is Section 160 has happened, and thereafter there's a prosecution and an acquittal. Then the court can revisit, but only in that situation, and not ab ante, recognising the unfairness. And similarly, subsection 2 and subsection 4 are all about double jeopardy. So what they say is, if you're found guilty by an election court and then found guilty on conviction, you don't suffer an additional incapacity under the Act, and vice versa. If you're convicted and then found guilty by an election court, you don't get punished twice. And subsection 5 deals with a situation where a finding of the election court is tainted by perjury. So again, ex hypothesi, Section 160 has happened. It's difficult to imagine any of these sections being used to reinstate a Member of Parliament who's lost his seat, because by then too much water will have flown under the bridge.
Also, you'd have to be prosecuted, isn't that right? If he wasn't prosecuted, this would never apply.
Precisely so.
Right.
So having, I hope, dealt with Section 174, if I can then move to the first substantive ground upon which I say this petition is irrelevant. And it's heralded by the question, is Section 106 engaged by self-talking? And it's here, of course, that I immediately ask the court to recall the approach of Lord Kilbrandon in Grieve, where Parliament legislates in the face of a known practice, could be presumed not to be outlawing that practice unless it does so expressly. It is hardly unknown for a politician to speak of himself. And that, I dare say, applied as much in 1895 as it does today. Section 106 does not, in terms, address the situation where a candidate speaks of himself and repeating the answer I've already given to my Lord Matthews, it would have been the easiest thing in the world for the statute so to have said. Moreover, my lady, my lord, there is no decision prior to the 1983 Act, notwithstanding, as the court knows, the repeated reenactment of this wording since 1895. There is no decision which envisages self-talking being caught by Section 106. On the contrary, the authorities assume that the speaker and the subject are different persons.
You say the authorities assume that. That's because they were different persons in the authorities referred to, is it not?
Well, that is the case, my lord. But when we see what the authorities have said about what the Act is there for, then we see that the Act is there to stop people disparaging others.
Is it just disparaging?
Well, in my submission, it is all about disparaging.
Well, supposing you say you're an individual and you say that a particular candidate is the best thing since Mother Teresa of Calcutta, with a view to securing that candidate's election, could that not be a false statement of fact, which might affect the election, or might have a...
That is envisaged, at least in the Earlham case, which is the most recent decision, where the Commissioner talks about a statement that a man is a philanthropist, for example. In my submission, when we look at the background to the Act, it is all designed to strike against the disparaging of others. But even if I'm wrong about that, the highest it gets for the petitioners is Earlham, which envisages a laudatory statement made by someone else. There is no authority which envisages self-talking. Prior to the 1983 Act, and notwithstanding the reenactment of the same words. And such dicta as we have point in the other direction. And I'd ask the court to look at, in the first instance, the Cockermouth Division case, which is 6.4. Page 512 of the joint bundle, page 159 of the original report. And this is page 159. At the foot of that page, Mr. Justice Darling, in giving judgment, said, "It was said the respondent had infringed the provisions of the 1895 Act, and that charge arose in this way. It was said that Mr. Falcon had made a speech at a meeting which Mr. Randalls attended, and he had used certain words which were within the mischief of the Act. Now, it must be noted that what the Act forbids is this: You shall not make or publish any false statement of fact in relation to the personal character or conduct of such candidate. If you do, it is an illegal practice. It is not an offence to say something which may be severe about another person, nor which may be unjustifiable, nor which may be derogatory, unless it amounts to a false statement of fact in relation to the personal character or conduct of such candidate. And I think the Act says that there is a great distinction to be drawn between a false statement of fact which affects the personal character or conduct of the candidate and a false statement of fact which deals with the political position or reputation or action of the candidate. If that were not kept in mind, this statute would simply have prohibited at election times all sorts of criticism which was not strictly true relating to the political behaviour and opinions of the candidate. That is why it carefully provides that the false statement, in order to be an illegal practice, must relate to the personal character and personal conduct. One can easily imagine this kind of thing. So he's talking about statements about another person. Those words expressly are used. And he has in mind the disparaging of that other person. And likewise, in the case which follows in the bundle, the Attercliffe case, page 221 of the report, page 519 of the joint bundle. And it's 4 lines in on page 221. It is a great pity that in elections at the present time so many false statements are made and that votes are obtained in that way. But we cannot go beyond the language of the Act, which is limited to false statements made with reference to the personal character or conduct of the candidate, leaving him therefore to be still exposed to unfriendly attacks with regard to his political views. But if his opponent goes beyond that and makes false statement of fact with regard to the private conduct of his rival, then the legislature has said that it is an illegal practice which will vitiate the election. So again, what the judges here have in mind are unfriendly attacks made by someone against another. Now, that this was the policy behind the 1895 Act is recognised in a case which is not before the court, but which is reported in the annotations to Section 106. And if I can take the court back to Section 106, tab 6.2, page 188 in the bundle. So page 188, under the annotations to Section 106 from Westlaw, the second case note. This is from a case called Thomas. There's nothing new about such campaigns of vilification. They have existed throughout history where one or more persons have wished to demonise another, but the internet has made them easier for individuals to conduct. In the 19th century, campaigns of vilification were so commonly used in election campaigns that Parliament enacted in 1895 what has now become Section 106. That section makes a person guilty of an illegal practice if, before or during an election, for the purpose of affecting the return of any candidate at the election, he makes or publishes any false statement of fact in relation to the candidate's personal character or conduct, unless the person can show that he had reasonable grounds for believing and did believe the statement to be true, and there's a reference to Hansard. In recent years, the court's approach to defamation has evolved. The court considers the balance to be struck between public interest and private right. As Lord Nichols stated in Reynolds and repeated in Bonnick, in a passage quoted in Late, reputation is not just a matter of private or individual right. Reputation is an integral and important part of the dignity of the individual. That's all from Reynolds. And then at 411, if those who work in or for public authorities could not defend themselves against the dissemination of falsehoods, the public would be the losers. This is the public policy underlying the provision in the Representation of the People Act. And it's Thompson rather than Thomas, Thompson and James in the High Court. Now, my submission, that is the public policy underlying the Act. It's the protection against vilification. And in the same way as was done in Thompson, I invite the court to look at Hansard, which has been produced in the supplementary bundle. As we'll see, it's evident from what's in Hansard that Willis involved a consideration of it, because the court notes in Willis an attempted amendment to the 1883 Act. And the court was taken to that passage. And likewise, we have the High Court looking at Hansard. And of course, in terms of Pepper and Hart, as long as there's a clear statement from the promoter of the bill, this court can bear that in mind. I'm looking at, firstly, there are two discussions in Hansard before the court, two debates. And I'm looking at the first one from May of 1895, tab 6.29 in the bundle. Page 1059. And it starts with Mr. Bolton, Mr. Thomas Bolton, who was a solicitor and Liberal Member of Parliament, who was the promoter of the bill. Mr. Bolton moved the second reading of the 1883 Amendment Bill, which he said was a non-party measure that appealed for sympathy and support to all quarters of the House. The fact that the bill had been drafted by the Right Honourable and learned gentleman, the member for Bury, Sir H. James, was sufficient guarantee that it had been carefully framed and framed with the attention to the 1883 Act, which it had proposed to amend. That's a reference to Sir Henry James, a QC and MP, who had been responsible for the passage of the 1883 Act. Now, the background of the amendment that was referenced in Willis can be seen in about the middle of the page, just after a reference to the Acts of 46 and 47, Victoria, chapter 51. Mr. Bolton continues, as he had said, some electioneering evils only were dealt with in the Act of 1883. If some of the most influential members of the House had had their way in 1883, that Act would have been made much stronger. On referring to the parliamentary debates of that time, he found the necessity for dealing with false statements at elections had been pressed upon the attention of the House. There was an amendment moved in committee with regard to false statements at elections. Mr. Stanhope, on behalf of Mr. Gibson, moved an amendment that any person who before, during or after an election, by poster, placard, cartoon, caricature or other publication, knowingly publishes any false charge of or against a candidate or any false statement of the withdrawal of the candidate in order to influence any such election shall be guilty of an illegal practice. That amendment was received with great sympathy but was ruled by the late Speaker to be not the subject of an amendment to the clause then under discussion, but a distinct proposition which ought to be brought forward as a separate clause. It was subsequently brought up as a new clause, but in consequence of discussion as to whether caricatures should be omitted, it seemed to have been proposed and ultimately postponed and ultimately withdrawn. So that's the background to the proposed amendment. And as to the target, if we move down 5 lines from where I stopped, he mentioned this to show that at the time the Corrupt Practices Act was passed, the subject of making false and defamatory charges with reference to candidates was under the consideration of the House, and was not from any doubt as to it being an offence that the matter was not embodied in the bill, but because a new offence, namely illegal practices, was being created, it was thought desirable not to go too far in dealing with the particular offences specified. He considered the time had now arrived when they might go a step further in the direction of strengthening the Act and include as an illegal practice an action which, he was sorry to say, was too common in elections, the making of false and libellous statements with regard to the personal character and conduct of candidates. So here we do have a very clear statement from the promoter of the bill as to the target that this is aiming at. And that clarity is really underlined over the page. So I'm now at page 1060. The top of that page, the object of the bill. So here we have the promoter telling us what the object of the bill is. The object of the bill was to prevent the practice at election contests of making utterly false statements affecting the personal character and conduct of a candidate. There were many statements which were unfair, misleading, and probably dictated by a suggestion of falsehood without actual falsehood. He did not propose to deal with such cases, but only with those that could be called absolutely false statements of fact. At present, statements most injurious to a candidate might be circulated at a time when there was no opportunity of contradiction and no remedy for the injury done. The only course open to a candidate was an action for slander, which, however, only lay in the case of this kind, where the libel imputed that a criminal act had been committed or where there was special damage. With regard to the imputing of a criminal act, that was not the more common case of slander, but the more common case would come under the category of an action for which special damage would have to be alleged. And in cases of this kind, it would be found to be an almost insuperable difficulty to prove special damage. He did not know how far the judge and jury would consider the loss of votes as special damage which would sustain an action of this kind. How far, if the election was voided and another election was the consequence, the expenses inflicted on the candidate who came forward again would be special damage was a question he left to acute lawyers to discuss. He believed it would be exceedingly difficult to prove special damage, and in fact it was so doubtful an action that had never yet been brought, and he believed experienced lawyers considered that practically there was no remedy whatever. There was therefore a grievance and no practical remedy for it. The bill proposed to create a new remedy for this evil, and in creating a new offence, it was desirable that great care should be taken not to exceed the limits necessary for repression. The slanderous statements dealt with were confined to those relating to the personal character and conduct of the candidate. Now, this background is, of course, readily understandable when one bears in mind the distinction inherent in the law of England, but not the law of Scotland, between slander and libel. Because, as is referenced by Mr. Bolton, in England, slander is only actionable if the words are actionable per se, which for present purposes may be taken as being an allegation of criminality, or if the claimant can show special damage. And as Mr. Bolton says, very uncertain question whether a loss of votes would count as special damage. So what the promoter is saying is, we've got a problem with people telling lies about candidates. And we've got a problem because the law of defamation is insufficient. So we need a new remedy. Now, the last substantive comment made by Mr. Bolton is at page 1062, when the promoter, as I've said, a Liberal, is asked whether, this is Mr O'Brien just above the halfway down the page, asked whether no false statements were made respecting Mr Wilson, the defeated candidate. Mr Bolton said that he did not claim that lies never emanated from the Conservatives and Liberal Unionist camps. There were no doubt that in those parties, reckless and foolish persons who did wrong things, and it was to prevent such conduct, whether on the Unionist or the Ministerialist side, that he proposed this bill. He was sorry if the illustrations which he had given appeared to suggest that the Liberal Party were chiefly to blame. He disclaimed any idea of making party capital out of the bill. He appealed to every man in that House, whether he had not, within his own experience, come across cases of false, defamatory and unjustifiable statements at elections. The present remedy for such evils was wholly insufficient, and a new, effective and not too drastic remedy ought to be provided. He asked for support not merely from honourable members opposite, but from the government itself. The present leader of the House, speaking at Derby not long ago, said, "I sometimes wonder what kind of man it is who deliberately sits down to write that which he knows to be false, to serve the purpose of the moment and to injure a political opponent. No doubt these creatures should be treated with the contempt which they deserve, but it is a profession which is discreditable, I think, in itself." He would give the gentleman and his colleagues on the Treasury bench credit for being so anxious as he was himself to do away with this unfair mode of conducting political warfare. The only thing to do was to deal with the matter by legislation, and it would be reasonable and practicable to make false and slanderous statements illegal practices, and to visit those who made them with the punishments appropriate to such practices. This was a measure for dealing with an admitted evil, and he confidently recommended it to the consideration of the honourable members. And he moved for the reading of the bill. Now, I'll leave the court to consider the whole of Hansard itself, but when it does, all of the examples given by Mr Bolton relate to previous examples where somebody has said something slanderous about somebody else. There is no envisaging.
What happened to this amendment? Was this amendment passed?
This led to the passing of what is now Section 106. So the purpose of this bill was to amend the 1883 Act by introducing what is now Section 106.
And did it achieve that purpose, did it? Yes. And then became the 1895 Act in due course, effectively.
Yeah, the 1895 Act amended the 1883 Act and then was reenacted in 1949 and was reenacted in 1983. Now, there is mention of laudatory statements, but not by a promoter of the bill and not assented to by anyone. It's page 1070 in the joint bundle. And it's in the comment of Mr Matthews at the foot of that page. Mr Matthews was very glad to hear that. There was therefore no real difference between them. It was because he thought personal character and conduct of the candidate were of great importance in duly and properly influencing the vote of an elector that false attacks made on that character and conduct ought, in his opinion, to be treated as electoral offences. He expected to hear the Attorney-General explain that the bill struck at much as laudatory falsehoods as at defamatory falsehoods. He could well imagine in a constituency in which the temperance vote was powerful, the case of a candidate's agent having supped with the candidate soberly but yet joyously, as befitted the occasion, publishing next day the statement that the candidate was a teetotaler, and thereby winning him a large number of votes. Such false statements of fact in regard to friends were, though intended to be laudatory, struck at very properly by the bill, just as much as false and defamatory statements made in regard to the character and conduct of opponents. So that Mr Matthews is envisaging that which Lord Matthews has suggested to me earlier. But as I say, this is not a statement made by the promoter of the bill. It's not assented to by the Attorney-General who was asked to, or indeed the promoter of the bill. it still doesn't envisage self-talking. It's still envisaging talking about someone else. And indeed, the only riposte which it receives is over the page from Sir Donald McFarlane, the member for Argyll, page 1071, first indent. Sir Donald thought it an entirely new view that laudatory falsehood should be checked in the same way as defamatory falsehood. There was one very substantial reason why it was unnecessary to take any action of this kind. No one believed laudatory statements, and everyone credited defamatory statements. That's the only response that Mr Matthews' comments received. So the whole thrust of this is, in my submission, the attacking of candidates. That's the evil that the Act was brought in to address. The end result of that discussion was the bill being sent to committee and coming back for a final discussion at page 1077 in the joint bundle, tab 6.30.
Sorry, tab?
6 point, should be the next tab in the bundle, my Lord. So this is the debate of the 4th of July on a motion for the consideration of this bill. And the first exchange is of interest. Mr Biles said this bill was regarded in some respects as dangerous. He thought it could not be doubted that the bill contained a dangerous principle. It exposed a poor man to actions at law, and where a poor man opposed a rich man, there would be a petition. With regard to the first clause, there was a provision as to a statement made before a parliamentary election. At any time before, surely that would need amendment. He had hoped the bill would be withdrawn. And then we have this. Then again, any person who makes or publishes any false statements. But a man might make or publish a false statement without having the slightest intention of doing a candidate any injury. So
is this Mr Biles? Is he Biles on Bills Biles?
That I don't know, my Lord. We can look that up. It certainly. Now, I note here, of course, this is not a promoter of the bill, so I might be criticised for looking at this. But it's interesting. Mr Biles says this is dangerous. This could apply to something that was said to help, not to hinder. And the only response to that is, well, that's provided for in the bill. So the raising of a concern that this might bite on laudatory statements seems to be dismissed. And then what follows thereafter is, in one voice, the Commons again looking at the evil of disparaging of others. So we see Sir William Hart Dyke, just after Mr Biles' further comment, regarded the opposition of Mr Biles as an absurd farce. The honourable member had claimed that many members with him objected to this bill. He should like to see the number of members who supported him in opposing. Nothing would delight him more than to put that to the test of a division. The honourable member wanted to know how long before an election the bill would apply. That was a practical question. He assumed that the responsibility would commence when a candidate had issued his address. Charges were often made against many of them after their addresses were issued. He was one who'd suffered very grievously, and many members on both sides had suffered, and this was a practice which they ought to put a stop to. And we go on, I'll just reference a couple of passages. Mr Chamberlain on the following page, talking about statements detrimental and dishonourable to the candidate. And on the final page, I'm sorry, my Lord, that is Mr Chamberlain, his first intervention about halfway through that paragraph. The contingency contemplated was not probable, but it was a common practice at election times to find that some statement detrimental and dishonourable to the candidate was brought forward on the eve of the election, when the candidate might find himself in a position where it was impossible promptly to contradict it. He did not think a more disgraceful practice could be conceived. and he was sure the desire of the House would be to deal with such a scandal. And likewise, over the page, Mr Asquith asks for the passing of the vote because 4 lines from the foot of his intervention, this bill would only be put in operation in cases where the statement was so clearly malicious and its possibility of influencing votes was so dangerous that it could not be treated with absolute indifference. Mr Darling hoped that the honourable gentleman who'd objected would withdraw their objection. It's not necessary to present a petition in order to punish people who might be guilty of slandering a candidate. Such slander would be constituted an illegal practice and would subject the guilty person to immediate prosecution. So the whole sense of the discussion is the disparaging of others. That in my submission is borne out by section 106, subsection 3. That's back to 6.2, tab 6.2, page 184 in the joint bundle. What 106.1 creates the offence, 160 imposes the consequences, 106.3 allows an injunction or an interdict. 106.3, a person making or publishing any false statement of fact as mentioned above may be restrained by interim or perpetual injunction by the High Court or the County Court from any repetition of that false statement or of a similar character in relation to the candidate. Now that simply can't have in mind self-talking. It makes no sense at all to envisage that being self-talking. That is the candidate injuncting or interdicting someone who's disparaging him.
Could another candidate interdict a candidate from talking himself up?
That wouldn't be the ordinary reading of that section, I would suggest, my Lord. Especially when we bear in mind what is said in Hansard about the need for the new remedy. This is part of that new remedy. Now, going back to, well, it would have been easy to say that the candidate himself is caught by this. The petitioners say in their argument, well, there are various parts of the Act where it's plainly talking about self-talking. Well, that's right, but that's a point in my favour, not in theirs. Because if it's easy to say it in one part of the Act, one would expect it to be said again in this part of the Act. There are various sections highlighted in the petitioner's note, but perhaps most evocative is section 65A, page 173 of the joint bundle, still tab 6.2. This is about false statements in nomination papers.
So what page was it again? Sorry?
Page 173.
173, thank you.
(65A 1A). A person is guilty of a corrupt practice if, in the case of any relevant election, he makes in any document in which he gives his consent to nomination as a candidate a statement as to his qualification for being elected, reading on, which he knows to be false in any particular. So this is very much directing attention to what the candidate himself says. And as the petitioners point out, the Act does that in certain instances. Why doesn't it make it clear under Section 106? Really all that the petitioner can say in this regard is, well, an election agent can be guilty or can impose guilt, but an election agent is simply the alter ego of the candidate. So that doesn't really add anything to the analysis. Rather, in my submission, the analysis begins with Hansard. It flows through the statements that we've seen in the early 20th century about what this is about. And it points to self-talking not being such as to engage Section 106. And at worst, for Mr Carmichael, I would suggest we're in a position where, if I'm wrong, and if the words can contemplate that which my learned friend says they mean, we're in the situation of both being possible.
Sorry, situation of?
Both being possible. And that then brings us back to Mr Justice Brett's dictum, which I sought to highlight earlier. Page 750 in Benyon, page 1082 in the joint bundle. The petitioner must show that the words of the Act distinctly enact that this penalty shall be incurred under the present circumstances. They must fail if the words are merely equally capable of a construction that would and one that would not inflict the penalty. So this court doesn't really need to grapple with the question of whether or not laudatory statements can engage it, because that's not my argument. Although I would say that in my submission, Hansard shows that the intention was not to catch laudatory statements. But even if I'm wrong on that, that's not the question. The question is whether or not self-talking is caught. And in my submission, it isn't. Lady and Lords, that's all I want to say on the first ground. I'll happily deal with anything that might arise, but if nothing arises, I'll move to the second chapter.
Right. Have you got any questions? No. No, you move to the second chapter, thank you.
Obliged. So this is the question of whether or not the words that we're all agreed Mr Carmichael said offend Section 106 because they were false statements of fact in relation to the personal character or conduct of Mr Carmichael. The words "in relation to" are central. They require, in my submission, a clear connection between the statement and the personal character or conduct of the candidate. And we cite in support of that proposition the recent decision of the Supreme Court in Martin against Most, tab 6.18 in the joint bundle, and page 813 it's one sentence only. So page 813 of the joint bundle, it's paragraph 49 of Lord Hope's speech. And this was dealing with the analogous expression relates to under the Scotland Act. Paragraph 49. So I come back to the first group of provisions. Its structure appears reasonably straightforward. It prohibits legislation by the Scottish Parliament which, open quotes, relates to reserved matters. That is an expression which is familiar in this sort of context, indicating more than a loose or consequential connection. A loose or consequential connection will not satisfy relates to. And in my submission, that approach is supported by what was said by Lord Ross, albeit not sitting in the election court, but considering these sort of statutory provisions in the Fairbairn case. Tab 6.11 in the bundle. Here Lord Ross was considering whether or not to grant interim interdict under the predecessor to section 106 after allegations that he failed to open his parliamentary mail. And his lordship discussed the approach to the predecessor of section 106. It's in exactly the same wording. Page 396 of the report, 679 of the joint bundle. And it's the final paragraph on that page. The statute makes it plain that the false statement complained of must be in relation to the personal character or conduct of the candidate. In my opinion, a distinction falls to be drawn between a false statement in relation to the personal character or conduct of the candidate on the one hand, and a false statement in relation to the public or official character of the candidate on the other. I accept, as Mr Davidson suggested, that every false statement in relation to the public character of a candidate may, in one sense, reflect upon the candidate's personal character. But before there can be an illegal practice in terms of the statute, the false statement of fact must be directly related to the personal character or conduct of the candidate. I derive support for this view from the judgment of Mr Justice Darling in the Cockermouth case, which the court has already seen. So his lordship, in my submission, correctly addresses attention to whether or not the false statement was directly related to personal character or conduct. And insofar as one asks, well, what does that mean? It's instructive to read on. If we turn the page 397 in the report, having quoted from Mr Justice Darling, Lord Ross says, to apply the language of Mr Justice Darling to the present case, I am inclined to think that the statements complained of related not to the personal character or conduct of the petitioner, but rather to the political position or reputation or action of the petitioner. In the North Luce case, Mr Justice Gibson, under reference to the 1895 Act, stated, the word personal, no doubt in reference to character and conduct, is restrictive, but I doubt if the sole antithesis is political. Public or any other position to which comment and criticism would apply would equally well fit the distinction. Subsequently, Mr Justice Gibson observed, a politician, for his public conduct, may be criticised, held up to obloquy. For that the statute gives no redress. But when the man beneath the politician has his honour, veracity and purity assailed, he is entitled to demand that his constituents shall not be poisoned against him by false statements, containing such unfounded imputations. In the present case, I feel the words complained of reflect on the petitioner's public or political character, but not upon his personal character. They constitute an attack upon his character as a political representative, but to adopt the language of Mr Justice Gibson, the words complained of do not amount to an attack on the petitioner's honour, veracity or purity. Now, in my submission, subject to the subsequent explanation of those words in Willis, this is an appropriate approach to take. Willis did look at Fairbairn and all the other cases, and if I can take the court back to Willis, joint bundle at page 863. That's tab 6.19. Mr Willis had been found guilty of 3 infringements of section 106. The Divisional Court upheld 2 of them. The one which they overruled is summarised at paragraph 70. The first statement was published 21st April in a coloured leaflet entitled Choose. This is, as are the others, appended to the judgment. The leaflet included on the second page the following in a box. Did you know? Interesting facts about our Lib Dem candidate. 3 matters were set out. The text in respect of the second read, he's reneged on his promise to live in the constituency. He had said, I've got my eyes on Lees. You can still get tripe in the co-op. You can't, of course, but he does talk it. The election court was satisfied that this was a statement of fact, that Mr Watkins had reneged on his promise to live in the constituency. It concluded it was a statement in respect of his personal character. It's been submitted on behalf of Mr Willis that this was a criticism of political conduct. His promise to live in the constituency was part of the campaign made to establish his commitment to the constituency and to establish his credibility with the electorate. However, the statement also relates directly to his personal character or conduct. A person who breaks his promise is untrustworthy. To say that someone is not worthy of trust is to attack his honour, veracity and purity. It was described by Mr Willis in evidence as a politician's promise. Whilst we accept that promises made by politicians may not be honoured because of changes in political circumstances, this particular promise cannot fall into any such category. The performance of Mr Watkins' promise was within his control, and so a failure to honour it reflected on his personal trustworthiness. Now, that approach, which was ruled erroneous in law, and I'll take the court to where we see that, that approach is effectively the one which the petitioners here adopt. They say because there was falsity, that redounds on personal character.
So you say that again, because there was falsity?
That redounds upon personal character.
Right.
Now, as I say, that approach was ruled erroneous by the Divisional Court. And if I can take the court forward in Willis to page 31 of the report, 868 in the joint bundle. And I'm picking the discussion up just after the reference to Barris. Paragraph 87. In our view, what is clearly established in relation to the meaning of a statement of fact in relation to the candidate's personal character or conduct by the cases can be summarised as follows. 1. No court has laid down a general definition. 2. A distinction must be drawn between a false statement of fact which relates to the personal character or conduct of the candidate and a false statement which relates to the political or public position, character or conduct of the candidate. In giving judgment in the Cockermouth case, Mr Justice Darling said, I think the Act says there is a great distinction to be drawn between a false statement of fact, and I think the court has seen that dictum already. There's then a reference to the Attercliffe case and the dictum again that I've taken the court to already. And then at letter C on page 32, similarly, Mr Justice Madden said in the Luth case, reading the section, I find that the false statement must relate to personal character or conduct, personal as distinguished from public, and it must be one of fact. In the present instance, the contrast is between personal and political. The primary object of this statute was the protection of the constituency against acts which would be fatal to the freedom of election. There would be no true freedom of election, no real expression of opinion of the constituency if votes were given in consequence of the dissemination of a false statement as to the personal character or conduct of a candidate. 3, the facts of the Cockermouth case illustrate what can clearly be viewed as statements in relation to political conduct. During the election campaign of 1900, in the middle of the Second Boer War, statements were made about a sitting MP who was candidate for re-election, that he did nothing other than taking the part of the Boers, and he had voted against sending money and supplies for the Boer War when the enemy was besieging British towns and wrecking British homes. In the Attercliffe case, statements in respect of a candidate's conduct of hounding a particular councillor by ensuring his prosecution for corruption, which others had tried to hush up, were thought by Mr Justice Walton obviously to relate to public acts and public conduct only. They did not impute any personal advantage to the candidate. 4, some statements may, without much argument, be said to relate to personal character or conduct. In Bailey, the statement alleged that the candidate hypocritically, feeling in his conscience that he was doing wrong, locked his workmen out, not caring whether he starved them, that some time later he found his conscience reproved him and resolved he would not starve them any longer. And a very brief report indicates that the Master of the Rolls' view was that the Act was intended to strike at something derogatory to the personal character of the candidate, and that the statement made was such a statement. It was in fact a statement as to his conduct as a businessman, not as a politician. Similarly, the statements in the Sunderland case related to the conduct of the candidate as a businessman, and thus were in respect of his personal conduct. 5, what may in certain circumstances be perfectly innocent statements may come within the prohibition if spoken about a candidate without reference to a political issue. There's then a reference to Baron Pollock in the Sunderland case. And at 6, it is clear from the Cockermouth case that one cannot simply imply from a statement attacking the political position of a candidate that the statement also reflects on his personal character, i.e. that he was supporting the Queen's enemies. Now, having set those general principles out, it's then of interest to see what the court did under reference to the particular statements under consideration. And having discussed a number of cases, including Fairbairn, they give their conclusion at page 37 of the report, page 874 of the joint bundle. At 107, we see reference to Luth and to Fairbairn. And over the page at A to B, reiteration of Mr Justice Gibson's distinction. The word personal, no doubt, in reference to character and conduct is restrictive, but a doubt if the sole antithesis is political, public would equally well fit the distinction. At 108, they look at Fairbairn. And at 109, this is now page 39 of the report. The court gives its view. Paragraph 109. Although we accept that we must interpret section 106 by applying the principle set out above, that Parliament reenacted it in the light of decisions on meaning, the passages in Luth do not, in our view, justify the adoption by the election court of the construction of section 106 that a false statement can at the same time relate to both a candidate's public and personal character. The judgment in Luth began by drawing a distinction between public and personal character, and on its facts, the conduct complained of plainly related to the personal conduct of the candidate. We agree with Mr Miller, counsel for Mr Willis, that the passage which we have cited, in which Mr Justice Gibson used the phrase "the man beneath the politician," probably means no more than the candidate in his personal character or conduct. Insofar as passages went beyond drawing the distinction between public and personal, they are far from clearly expressed and plainly were not necessary for decision in the case. The passages cannot therefore justify the conclusion that Parliament reenacted the provision in the light of those passages. Nor, in our view, does the observation of Lord Ross in Fairbairn's case support the interpretation adopted by the Election Court. Lord Ross does no more than to make clear that the statement made must relate directly to the personal character or conduct of the candidate. Finally, we consider the better course is to use the statutory language and not to continue to use terms such as honour or purity. In our view, the starting point for the construction of Section 106 must be the distinction which it is plain from the statutory language that Parliament intended to draw between statements as to the political conduct or character or position of a candidate and statements as to his personal character or conduct. It was as self-evident in 1895 as it is today, given the practical experience of politics in a democracy, that unfounded allegations will be made about the political position of candidates in an election. The statutory language makes it clear that Parliament plainly did not intend the Act to apply to such statements. It trusted the good sense of the electorate to discount them. However, statements as to the personal character of a candidate were seen to be quite different. The good sense of the electorate would be unable to discern whether such statements, which might be highly damaging, were untrue. A remedy under the ordinary law in the middle of an election would be difficult to obtain. Thus, the distinction was drawn in the 1895 Act, which is reenacted under Section 106, and which is reflected in the decision which we have referred to. In our judgment, as Parliament clearly intended that such a distinction be made, the Court has to make that distinction and decide whether the statement is one as to the personal character or conduct or a statement as to the political position or character of the candidate. It cannot be both. And that's an important point to stress. It is a binary position. The statement either relates to personal character or conduct, or it does not. Paragraph 112. Statements about a candidate which relate, for example, to his family, religion, sexual conduct, business or finances are generally likely to relate to the personal character of a candidate. In our view, it is of central importance to have regard to the difference between statements of that kind and statements about a candidate which relate to his political position, but which may carry an implication which, if not made in the context of a statement as to political position, impugn the personal character of the candidate. For example, a statement made simply about a candidate's conduct as a businessman might imply he is a hypocrite. As his conduct as a businessman relates to personal conduct, such a statement is within Section 106, subject to possible issues of proportionality under Article 10. However, a statement about a candidate's political position may well imply that he is a hypocrite or untrustworthy because of the political position he is taking. That is not a statement in relation to his personal character or conduct. It is a statement about his political position, though it might cast an imputation on his personal character. And if I can stress those three sentences, because of my submission, here we have the nub of it. A statement about a candidate's political position may well imply he is a hypocrite or untrustworthy because of the political position he is taking. That is not a statement in relation to personal character or conduct. It is a statement about political position, though it might cast an imputation on personal character. We do not consider that Parliament intended that such statements fall within Section 106, particularly bearing in mind the fact that criminal liability attaches for statements made negligently. It would be difficult to see how the ordinary cut and thrust of political debate could properly be carried on if such were the width of the prohibition. In any event, it would also be difficult to reconcile such a broad construction with the balance that Article 10 mandates be achieved. However, a statement about a candidate's political position can go beyond being a statement about political and become a statement that is a statement about personal character. A clear illustration is to accuse him of corruption, even if that corruption involves the conduct of a political or public office. What is being said about the candidate is not a statement in respect of the conduct of public office, but a statement he's personally dishonest in committing a crime. The statement is not to be characterised as one about his political position, but one in relation to personal character. That's all about corruption. There's no suggestion of that here. Before turning to the statements found by the election court to have been made, which illustrate the distinction the court must draw, we must briefly consider the further submission made after conclusion of the hearing by Ms Mountfield, as counsel for the petitioner. She submitted that, unburdened by authority, the correct approach was to treat Section 106 as applying to a candidate as an individual, as distinct from a statement about a political party or a group. As was apparent from the case law and the illustrations discussed in argument, the distinction between personal and political might be viewed as illusory. It was therefore better to consider Section 106 as referring to statements which directly related to the individual candidate from whom the electorate was asked to vote. We cannot accept this submission. It is, in our view, possible to draw a distinction, as the framers of the Act intended, between a statement relating to the personal character or conduct and a statement as to his political character, conduct or position, for the reasons we've set out. The difficulty that has arisen, and which Mountfield has sought to meet, is the confusion originating in the language of the judgment in the Luth case, such as reference to the man beneath the politician and honour and purity, that a statement can at the same time be both as to personal and as to political character or conduct. Once it is clear that a court must choose as to which it is, as we believe it can, and as the facts of this case illustrate, then the difficulties are illusory. To take the example in Fairbairn, criticism of an MP for not opening his constituency post would have been personal on the construction put forward by Ms Mountfield, but on the correct analysis as applied by Lord Ross, it was a criticism of him in his political conduct. In my submission, this is the correct approach. And in my submission, when the court looks to what Mr Carmichael said, it is as clear could be that what was said related to political conduct. If the court looks back, it's conveniently set out in the petition, which would be tab 1, page 7 and 8 of the joint bundle. Statement of Fact 5 in the petition, page 7 in the joint bundle. The context is the Cabinet Secretary ordering a Cabinet Office-led inquiry. Mr Carmichael's interviewed by Channel 4 News. The reporter, surely it's a fair question to ask what you were aware of. Listen, that's why I'm telling you, I'll cooperate fully with Sir Jeremy's inquiry, but it has to be Sir Jeremy's inquiry, and that's why I will answer the questions to him. I told you the first I became aware of this, and this is already in the public record, was when I received a phone call on Friday afternoon from a journalist making me aware of it. Reporter asked, do you accept the buck stops with you when it comes to the Scotland office? Well, of course, as Secretary of State for Scotland, I'm responsible for the Scotland office, but you seem to be making some fairly substantial presumptions about the role of the Scotland office in this. That's why we're having a proper inquiry conducted by the Cabinet Office. Do you think it's embarrassing for you in the Scotland office? No, I mean, look, in the middle of an election campaign, these things happen. I understand the memo in question did actually come from the Scotland Office, but these things are circulated within government. If it turns out that a civil servant embellished and leaked a memo, what do you think should happen to that person? That's why we have the inquiry to be conducted by Sir Jeremy, and so on. Now, that context is very clear and it's very important. Mr Carmichael is being asked questions in his capacity as Secretary of State for Scotland. That's why they've gone to him. Because they understand the leak came from the Scotland office. The context is an inquiry by the Cabinet Secretary. We couldn't get a more public or political context. Thinking back to Lord Ross and to the question of, does it directly relate to Mr Carmichael's personal character or conduct? He didn't say anything about his personal character or conduct. He didn't say, adopting my Lord Matthews' example earlier, I'm the equivalent of Mother Teresa, I'm a philanthropist. He didn't say anything about his his personal character or conduct. And so we have this convoluted attempt by the petitioners to try and make it about private character because it wasn't true. There are two fundamental problems with that attempt. The first is thinking back to Martin against Most and the definition of relating to. The petitioner's approach is a classic example of a loose or consequential connection, if indeed there's any connection at all. Their approach is exactly that which the divisional court said doesn't work in Woolas at paragraph 113. Secondly, and this is crucial, if the petitioners are correct, then the requirement that the statement relate to personal character or conduct is entirely devoid of content. Their approach is, because Mr Carmichael spoke falsely, his private character is engaged. But that ignores the fact that Section 106 already requires the statement to be false. And that Section 106 provides a defence if the statement was not known to be false. So before we even get to private character or conduct, ex hypothesi we have a knowingly false statement. What place is there on the petitioner's analysis for the requirement of personal character or conduct? There is none. Because as soon as a known falsehood is told, that impacts on personal character, and Section 106 is infringed. That in my submission flies in the face of the authorities and is wrong in law. Imagine the most obviously political of situations. A journalist asking an MP how he voted on tax rises. Surely how an MP voted is a matter of public or political effect. But if he lies about it on the petitioner's argument, it becomes private. Likewise, in the Fairbairn case, the allegation that he wasn't opening his mail was a political matter. But if Sir Nicholas had lied about it, apparently that would have become private. And I would suggest that's a good way of testing the matter. Invert the scenario. The allegation, if it had been false, that Mr Carmichael, as Secretary of State, authorised the leak of the memorandum would very obviously have been a public or political matter. It can't be public or political for one purpose and then fall to be private for the other. The petitioner's analysis make it impossible to understand the result in Willis with regard to their overturning of the decision on the breaking the promise point. The election court said, well, it was a political promise, but he broke it, and that impacts on his personal character. Divisional court said that's wrong. From the beginning to the end, this matter was political. The allegation that Miss Sturgeon wanted Mr Cameron to win the election was political. If Miss Sturgeon had falsely denied the allegation, it wouldn't have become private.
Sorry, just say that again, if Miss Sturgeon?
If Miss Sturgeon had falsely denied that allegation, that would not have meant it was no longer political. If my learned friend's right, then this court might expect to get a lot busier. Indeed, it's a wonder that nothing's happened for 50 years. Because on his argument, all that one needs is a factual dispute of any sort in the course of an election, with a false answer given by one of the parties to that dispute. No matter how political or public that dispute is. And I ask the court just to pause and consider the precedent they're being asked to set. Because the combination of issue 1, self-talking, issue 2, falsity equals private, is that henceforth any prospective MP will, in the run-up to an election, effectively be strapped to a lie detector and administered a truth serum?
Not a bad thing. Not a bad thing.
I'm going to answer that very question, my lord, because I knew someone would ask it. And that's because any untruth, no matter how public the subject matter, would engage Section 106. Now, many people, my Lord Matthews included, might say, what's wrong with that? What's wrong with expecting honesty of our politicians? The answer is that for 120 years, it has been thought appropriate by Parliament to distinguish between the public or political on the one hand and the private on the other. If there is to be an elision of that distinction, that is a matter for Parliament. One must not forget the basic premise of separation of powers. The 1983 Act is a limited derogation from the default position whereby the conduct of members of Parliament is regulated by Parliament. This court, as a creature of statute, should not arrogate to itself powers which Parliament did not intend to provide. In the last 120 years, the approach advocated by the petitioners has never been suggested, let alone upheld. And for good reason. Echoing the comments in Woollis, if the cut and thrust of politics is to continue to have vigour, one cannot emasculate that process by creating a situation where every syllable is guarded. The statutory provisions were introduced for clear and good reason to prevent the traducing of private character for political gain. They were not introduced to allow disappointed electors to pore over every utterance of an opponent in an attempt to unseat him.
Now, would that be a convenient moment to break, Mr Dunlop, because I see that it is about 1 o'clock.
My lady, the last thing I had to say on this was just to remind the court that Woollis explains the question before the court is a binary one, and it's one which in my submission is answered in favour of this not being about Mr Carmichael's character or conduct at all, but if it is, certainly not about private character or conduct.
Right.
So, my lady, that only leaves the third aspect, and that will be very short. But if we break now and resume, I think I will have 10 minutes left of my submission.
Well, that's very helpful. Thank you very much, Mr Dunlop. So the court will now adjourn for a lunch break and reconvene at 2 o'clock. Court will now adjourn.
So Roddy Dunlop there saying that he has another small third submission to make. That should take around 10 minutes. So when the court comes back at 2 o'clock, we'll have 10 minutes of his submission before we go on to hear from the petitioners. But when he was, in essence, trying to sum up his points in relation to the petition, he told the court that what the petitioners were seeking to do flies in the face of the legal authorities and is wrong in law. So let's just remind ourselves, as we try to give some context to this session this morning, what it actually is that the petitioners actually have to prove. Well, the first thing is that they have to prove that Mr Carmichael made a false statement of fact. The statement of fact has to be in relation to a candidate, and the statement of fact has to be about the candidate's personal character or conduct, and the statement has to be for the purposes of affecting the return of any candidate at the election. Now, during the course of those submissions, particularly towards the end, what Mr Carmichael's QC was effectively arguing was that Section 106 of the Act is not, in fact, it doesn't in fact catch the words that Mr Carmichael spoke, and that therefore there is no breach of Section 106, and therefore inviting the judges effectively to throw the petition out. Professor James Chalmers, was there anything in those submissions which surprised you?
Nothing terribly surprising, no. I think what we saw, which is quite interesting towards the end, was the suggestion that, well, if you interpret the legislation this way, this turns the law into a lie detector. Any politician who lies during the election campaign could have their election voided. Now, of course, as I think was then recognised in court, people might say, well, what's wrong with that? And the argument that's being made, of course, is this has never been done before. The petitioner's response is likely to be, well, but we think the plain language of the Act says you can do this, so it doesn't matter that it's never been done before, we're doing it now. And
why did he keep going on about the issue of personal conduct as opposed to political conduct? Clearly he's driving here that this was all political conduct and therefore isn't caught by the Act.
Yeah. The legislation does say it's got to be a statement about personal conduct. So one of the examples that came up earlier was an older case involving Nicholas Fairbairn, where the SNP had alleged Fairbairn wasn't collecting constituency mail, and it was argued this was the same sort of illegal practice here, false statements about a candidate's character, and the court said, well, that's a statement about Fairbairn's political character, it's not about his personal character at all. So they're trying to make the same sort of argument here. This is all politics, and for better or for worse, the legislation doesn't capture politics.
Lesley, Riddoch, Roddy Dunlop towards the end was saying from beginning to end this was political. Now, that's obviously from a legal perspective. Perhaps voters might take a different view of it.
Well, to use Mr Dunlop's own phrasing, to invert the situation, what is personal? Once you become a politician, can you say anything? Can you do anything? Can you behave in any way? Because it's all covered by you being political. It's also the case that MPs don't technically have a job. So, you know, comparisons with everyday life, which I was trying to ask our learned colleagues about before, where if I lied, if I leaked, I might well expect to find myself out of a job. Now, we can't even make those comparisons because MPs technically don't have a job. But most people think this should be the same rules for everybody. So I'm just at a loss to see what would ever be personal in this context, or whether you can do just about anything once you're an MP and get away with it.
Of course, the judges have to work with the construction of the law as it is. Was there anything in what Roddy Dunlop said by way of argument that you didn't think was logical or rational given what Section 106 actually says?
Well, yes. The very last thing he said he said for 120 years the Commons have made a distinction between the political and personal aspects of being an MP. But we were just discussing there this good old Recall of MPs Act, which now is the most recent statement of how MPs feel and doesn't make that distinction. The reason it gets triggered is if an MP is jailed or if they're given a 21-day suspension from the Commons. And that could be for a variety of reasons. I suppose it's possible there's no personal reason you get suspended as being an MP either. But if that's the case, you know, it's a difficult thing to see how anyone could ever use this legislation.
James?
One difference we might note there is that the recall legislation explicitly says that being recalled doesn't prevent you standing in the by-election. The court doesn't have that flexibility here, that the court is faced with the choice of either declaring that Alistair Carmichael is guilty of an illegal practice and saying there'll be a by-election and you can't be a candidate, or leaving him at hidden post. So it operates that different way. The court has this very narrow framework to work within, and I think that does pose some difficulty.
Robert, I mean, how do you think the judges will entertain this argument that was made towards the end, where Roddy Dunlop's argument was, if you're going to set aside the logic of over 100 years of election law, and that you're going to say that what is political is in actual fact personal for the subject of the Act, then the election court is going to be flooded with petitions from all sorts of disgruntled politicians.
We're only hearing, of course, one side of the argument so far. We've got to hear the representations for the petitioners in due course. But I'm bound to say I thought the latter part of Roddy Dunlop's contribution was pretty devastating. I think when he made the comment particularly about Section 106 requires there to be a false statement, that deals with the falseness bit, and then the separate issue, whether it's personal or political, is a later issue to be taken on board. Lesley's quite wrong to say that it's difficult to decide instances where the personal wouldn't come into it. It happened in the very last case, the Woollis case, where all sorts of personal, crass political comments were made by Mr Woollis, the then MP, against his political opponent. So, I mean, we've got a recent example of exactly that kind of position.
Okay, well, of course, one of the things that Roddy Dunlop was saying was that the petitioners were effectively trying to conflate this issue of the political and the personal. Let's just give us a flavour of what he said to the court.
Didn't say anything about his his personal character or conduct. And so we have this convoluted attempt by the petitioners to try and make it about private character because it wasn't true. Because on his argument, all that one needs is a factual dispute of any sort in the course of an election, with a false answer given by one of the parties to that dispute. No matter how political or public that dispute is. And I ask the court just to pause and consider the precedent they're being asked to set. Because the combination of issue 1, self-talking, issue 2, falsity equals private, is that henceforth any prospective MP will, in the run-up to an election, effectively be strapped to a lie detector and administered a truth serum.
Not a bad thing. Not a bad thing.
I'm going to answer that very question, my lord, because I knew someone would ask it. And that's because any untruth, no matter how public the subject matter, would engage Section 106.
Okay, back to our panel. Professor James Chalmers, he's saying there that, look, the petitioners are trying to make a convoluted argument here in terms of what the law technically says. Now, ultimately, this will be a matter for Lady Paton and Lord Matthews. Does it sound convoluted to you?
I think in some ways it's actually quite straightforward. The petitioner's argument seems to be, well, or it may be, any lie is caught by this, but then you have a problem that does start to go overbroad. If a politician lies about something which isn't really of significance, of importance, because the court has to disqualify, void the election as soon as the criteria are met, are you applying this in cases where really it oughtn't to be applied? And that's the argument I think he's trying to make.
Isn't that the point, Lesley, that the logic of the petitioner's case is that if you find a candidate says something which is not true, even although it might not be personal, and even though it might not affect the result in an individual constituency, unless, to borrow a phrase from Lord Matthews, your Mother Teresa of Calcutta, it's going to strike at the heart of the cut and thrust of politics.
Well, possibly, but I mean, I've noticed people have been tweeting a lot about this, and one tweeter, Anne from Leith, said, will a not guilty verdict encourage other government ministers to leak false statements at crucial times, knowing they can get away with it.
This is not a matter of guilt or not guilty. It's not a criminal case.
Yes, but the point is, what they're trying to say is it works both ways. You know, of course, there's the possibility that there might be more MPs swept up if they find that constituents can raise £87,000 to take the case. Let's remember, because this is only in court because that amount of money was raised. That's why it hasn't happened before. And you know, people have been mentioning all other sorts of cases that you could get back into. In the Alex Salmond case that was mentioned earlier, he was actually investigated by the Information Commissioner and found to have committed no offence with relation to claims about the EU. So if anybody wants to get in and say other MPs are lying, raise the money. If you feel strongly enough about it, take it to court.
I will come back to Robert in just a minute, but I want to cross over to the court where our chief reporter, David Cowan, is waiting to speak to us. Now, Dave, you cover the courts all the time for STV News. What's your reflections on the 3 or 4 hours we've had this morning?
Well, some court cases are a bit like watching an episode of Jeremy Kyle with lots of shouting and bawling and stramashes in the court, and very occasionally you get that. Sometimes they're utterly sensational. You'll remember, Bernard, the Tommy Sheridan defamation case here at the Court of Session, which had sensational testimony, a very dramatic event. What we're seeing this morning, though, is very much par for the course. It's complicated stuff. It's being explained by clever people who are referring to legal authorities. It might not make the most sensational television, but it is extremely important to the people involved. Alistair Carmichael isn't here, but presumably his political future hangs on this. And also for the petitioners too. 2 of them are in court. They've come all the way down from Orkney for this. And what happens could very much depend on, dictate what happens to them in the future. If they have to pay their costs, the costs of Alistair Carmichael's lawyers and the costs of the court himself. So it might not be Rumpole of the Bailey, but it's, you know, it's a realistic representation of what happens here on a daily basis in this particular case, which is extremely important.
David, people who have been following this all the way through may well have asked themselves a question, which is how does a reporter actually go about distilling all of these representations into something that's manageable? So let me put you on the spot. What did you think in terms of what we've heard so far? What was the top line from your point of view?
The top line, very simply, was their argument that Section 106 doesn't apply to this particular case, that the argument put forward by the petitioners is irrelevant, so it should be thrown out at this stage. Simple as that, really.
Thank you very much, David. Well, let's cross to Orkney and to Nicola McAlley, where local constituents have been listening to the proceedings this morning. Nicola.
Well, that's right. Everybody's just broken here for lunch at the King Street Hall. We've been televising the hearing on a big screen here, and lots of members of the public have been sitting through it, listening intently. And I'm actually joined by one of the petitioners now, Carrie Welling, who is one of the 4 petitioners who actually lodged this petition. Carrie, first of all, what's your thoughts on how things are going today?
It's very much what we expected. Did this law apply or didn't it apply? And that's what Roddy Dunlop, that's exactly what he's addressed.
You must feel very, very strongly to do this, to raise this over £60,000 of donations.
Nearly 88 now, 88,000, yes. And it's going to cost every penny. He's a very expensive kind of lawyer.
Why did you go down this route? What was it about this case and the whole situation that you wanted to pursue this to get to this point?
I was very disappointed that our MP had been dishonest about what he'd done, and the opportunity just arose. Modern technology, you know, social media, people got together, talked about things, discussed the law, and suddenly there was an opportunity, and I thought, yes, I believe that. I believe that we should try to get him to stand for re-election, and that's what I really want. I want him to stand for re-election.
We were hearing, I think I'm correct in saying so, you know, if this does not find in his favour, he can't stand for election again, so that will be out of the window, won't it?
The key thing is, if he resigned, that wouldn't happen to him, and he could stand for re-election. He's asked, well, he's asserted that the people of Orkney and Shetland want him to have a second chance. I want the people of Orkney and Shetland to say that's true, to offer him a second chance.
And we were hearing from his QC today, they feel that this argument is irrelevant. What do you say to that?
this is one side of an argument, and he's trying to interpret the law to make that seem obvious. I think our QC, I'm not entirely sure in Scotland what they call him, advocate, I think he's going to make the opposite case, that the law does apply.
Carrie, thank you very much, Carrie Welling, for joining us, one of the 4 petitioners. We're also joined by another gentleman who is a supporter of Alistair Carmichael, Dennis Gowland. Dennis, tell me what your thoughts are on what you have been hearing today and on the whole situation.
Well, as to what's been happening today, I'm not a lawyer. We've been listening to legal arguments on each side, and the judges will make a decision on that. But I think it is difficult to take this away from the context of events just around about a year ago, when some of the people, I would say the majority of the people behind this campaign, were disappointed when Orkney voted very clearly and decisively no. And in the general election, it certainly was tipped that Alistair could lose his seat to the SNP. As it happened, that didn't happen. And I can understand that the supporters of the SNP would have been very disappointed. And I feel that is the background to this case. It's disappointing, I think, to people in Orkney when a group of people purporting to be the people represent and again purport to represent all the people of the constituency, and people I've spoken to think that really is the wrong stance.
Thank you very much, Dennis. And Dennis was saying, he feels it's a political issue here, and talking in particular about the SNP. But I think I was hearing you saying earlier on, Carrie, you're not an SNP supporter.
No, no, 2 of the 4 aren't. A Green and Labour Party. Actually, 3 of us actually supported the Labour Party just recently. We're all yes voters, though. We all wanted Scotland to be independent.
So you were yes, but not necessarily the Scottish National Party. I mean, what do you make of that then, Dennis?
Well, people will make their own, whatever they say. I wouldn't counteract that, but obviously it does go along back to the whole yes and no campaign, which polarised people in the whole of the country, including Orkney. And I think that is part of the background to that. I believe in when the money was raised, that the people behind that were tried to sort of make sure that they weren't seen to be politically motivated. But I don't think that has been done effectively. I think there is political motivation there, and that's where we'll disagree.
Well, thank you very much, Dennis. Carrie, shaking her head there.
Very strongly shaking my head. The crowdfunder has had over 5,000 people donating money, average about £15 a head. We have no idea where those people come from Orkney, from Scotland, from the UK, maybe even some from overseas. This is not an SNP witch hunt.
Well, Carrie Welling and Dennis Gowland, Dennis speaking in support of Alistair Carmichael, and Carrie, one of the 4 petitioners who have brought this case, this historic case. Everyone watching very keenly here in Orkney and in Shetland to see the outcome of this case, which we won't know immediately, but people will be tuning in again when we join the case again at 2 o'clock. Back to you, Bernard.
Nicola, thank you very much indeed, and we will be joining you later on in the day. This, of course, is a legal case, but it's driven by political circumstances. And let me just pick up on what the petitioner was saying there, because she's saying all 4 petitioners voted yes, but in fact, in terms of their voting preference, 3 out of 4 of them actually voted Labour. Now, for the purposes of viewers who are just joining us who weren't here earlier, Robert Brown, let me put the point to you, because it was the petitioner's point that she said, look, he said he wants a second chance. That's good. That's fair enough. He's entitled to a second chance. He should have that second chance by resigning and allowing the people to sit in judgment.
I don't think I really accept that. I think the bottom line is that these things are driven by process. An election was held, not in just in that constituency, but across the whole of the United Kingdom. Decisions were made, people were elected. there's a process in terms of the Representation of the People Act for dealing with any issues that arise out of that. And I think it's actually quite interesting that Roddy Dunlop, in putting the case for the for Alistair Carmichael, had to invent the concept of self-talking, so to speak, in order to justify or to describe this extraordinary, unusual basis of the case. It's something that has not happened in 120 years. One would imagine if it had been thought to be a remedy that was, people were concerned about, it would have happened at some case in the past. And the reality is it hasn't.
But if we set aside what is essentially a legal argument and deal with this and attack this from the way in which an ordinary voter would look at it, which is not from a legal perspective, it's about conduct of behaviour in politicians and what is acceptable and what is not. Given that Mr Carmichael has already said he would be unfit for cabinet office given what he did, why does it make him fit to be a Member of Parliament?
I think what he said is it would be appropriate for him to have resigned from Cabinet Office had he been in that position.
Well, let me put the question another way. Why would it not be appropriate for him to resign as a Member of Parliament, fight a by-election, fight on his record, apologise and seek to move on?
I go back to what I said before, which is that this is a matter of process. Rightly or wrongly, Parliament, who's determined these things in the round, if you like, over the years, have laid down particular processes which people can avail themselves on in appropriate circumstances to take forward. Now, there's certainly a case that can be made for modernising the legislation. It's one I would actually go along with. I think Lesley perhaps would agree with that. There was an Electoral Commission report back in 2012 which went through, if you like, some of the issues there. But I'd give you any bets that if they do modernise the legislation, this issue of personal and political that lies at the heart of this debate would not be something which would be revisited in that way. And I think quite rightly for a number of the reasons we've been talking about.
Lesley, do you want to respond to that?
You're trying to make a kind of common sense point, which I still think you need to answer, Robert, which is that as far as any viewer is concerned with all of this, it's Alistair Carmichael himself who used that phrase that he wanted to be given a second chance. Now, the people of Orkney and Shetland are saying, actually, we'd like a second chance to decide if we want you as an MP, once we know you told a porky before the election and then got found out after it. Now, just in ordinary circumstances, can't you see that that's why people regard this as a special case?
Well, that's why the case has been brought, of course, because people feel in that respect.
No,
but
I'm specifically not talking about the special points of legal
it's not the
debate
law,
here. I'm asking you just as a straightforward political point.
The law is not there just to define obscure legal points. The law is there, made by Parliament, to define the circumstances where people can challenge particular situations.
Would you have considered resigning? Is this a point of integrity?
Lesley, I mean, you're going to do me out of a job.
Sorry, old habits.
Or they'll be docking my pay because I'm not asking enough questions. I mean, if this is lost, and certainly from what I've read, the balance among the legal commentators is that the petition won't succeed. That doesn't, of course, mean that it's the end of the matter, because there could be a political fallout. It could rumble on to the Scottish parliamentary elections where there are not one Liberal Democrat seat, but two Liberal Democrat seats up for grabs here.
Yes, that's very true. And from what I've learned being in Orkney, it's certainly the case that Tavish Scott and Liam MacArthur must be a bit worried now, because it sort of taints them quite unfairly, I think, actually, by association. But it's very possible. I mean, people are thrown. It's quite possible if Alistair Carmichael had stood down, or even did it yet, that he might get re-elected. I don't know. But that's the point.
I was going to say,
be up to the electorate.
The politics up there is less tribal than it is in the Central Belt. It's not as party political, and there's a tradition, particularly in Highland constituencies represented by Liberals, where they look at the personality of the candidate. The forgiving tendency of the electorate might have been a better route for him than trying to tough it out.
Well, absolutely. And I mean, I see today there are headlines about the late Charles Kennedy talking about the kind of, boozy culture of the House of Commons being a contributory factor to his problems with alcohol and his death. And if we're looking at the acceptance of that by his constituents over a very long period of time, sure, people respond to people in the Highlands and Islands. So I would have thought it would be a much better ploy to have decided to come clean and just tried to sit again as an MP in a fair election.
Professor Chalmers, Robert Brownlee, the good Liberal he is, was reminding us that there is two sides to every argument and that we have to listen to what Jonathan Mitchell is going to say this afternoon. How do you think he may well approach it? Because from the point of view of Roddy Dunlop, he's basically said, it's political, it ain't personal, it's not covered by Section 106, good night. So how does the other side, in a sense, try and approach it?
Well, he spent more time thinking about it than I have, I suspect. But I imagine it's going to be, as I said earlier, a question of the plain wording of the statute. The statute talks about false statements about any candidate. It doesn't say about another candidate. It could do. It doesn't say that. It does say it's got to be a statement about personal character, but surely lying is a matter of personal character. So there are arguments that the petitioners can make on all these points. They've run into the difficulties that we've already heard from Roddy Dunlop, but he's not going to be left without any tunes.
He's talked about Section 106. I mean, is there any other aspect of the Act that the other side might found upon to give the judges some wriggle room to find in their favour?
No, the way this has been presented, they're really restricted to Section 106 because that's how they framed the case. It's not clear they really could have done anything else, in fact, given the facts they had to work with.
But we were talking about this recall of the MPs Act, which it looks like they have just missed the opportunity to use. And that still would have relied upon a 21-day suspension. I don't know, because I'm not an aficionado of suspension times. I don't know what you get for being found to have leaked and lied. Perhaps you wouldn't have made it.
Would these provisions about recall, could they apply after this?
I'm not sure. I'm not particularly familiar with the provisions of the new legislation. I made the point before it was actually brought forward at the instance of the Liberal Democrats. Perhaps ironically, you might say, in these circumstances.
You don't know the details then, Robert.
No. I'm saying I don't know the detail of it. But what we do know is it's triggered by a process in terms of political events in the House of Commons. And I say political. It's a political process. But I think it's unlikely that anybody's going to be jailed for, or for that matter, suspended for things which don't relate to matters of personal character, if you like, things that they've done, things that have done wrong, things which amount to criminal actions.
So you don't think,
I think there'll be a core there, that sort of thing.
Would this potentially have been something that, if Alistair Carmichael had, done what he'd done at a later date when this Act had been enacted? Would it potentially have been something he could have been suspended for?
It's the issue for the House of Commons, isn't it? That's the trouble. I mean, I think we don't know how that would actually play out. All sorts of implications come into play in these sorts of situations when that happens. And the House of Commons is a jury in some ways. It listens to what's been said on the matter, and I guess it makes its own decision. And we know from past experience that some MPs have gone through difficult situations like this, and it's been fine, and people have accepted the position, and others have had a bit more difficulty with it. I think that's just the nature of the way in which these things occur.
OK, well, we're going to pick up that point when we come back, as well as maybe some more general points about what people have made of this from a broadcast point of view. It's probably not going to be the #1 programme that will be watched in Scotland this week, but we'll come back and get some views on that. Well, it's time for a short break. Join us again in a couple of minutes for more analysis of the Carmichael court case.
This is where it happened. A stack of paint cans collapsed and smashed my leg. My lawyer at Slater and Gordon has been amazing. He even got me money when I couldn't earn. Now I can put a date on coming back to work.
If you've been injured in an accident at work, talk to a lawyer who will handle your case with skill, care and commitment. Slater and Gordon, your case is our cause.
Vampires. Werewolves. No, vampires. Werewolves. Vampires. Werewolves.
Lassies!
Have your see at scottpulse.com.
Would it surprise you to learn just how many properties in Edinburgh are let by DJ Alexander? For over 30 years, private landlords and large investors have trusted DJ Alexander to let and manage their properties. From finding you the best tenants to managing all aspects of the tenancy through to reletting again, we'll take great care of you and your tenants. Visit us online or at Dundas Street, Edinburgh. DJ Alexander, where landlords and tenants come first.
At the
next junction, turn left. Now turn left. Calculating new route. At the next junction, turn around when possible. Are you even listening to me? Are hearing problems taking you in the wrong direction? Then visit House of Hearing.
Oh, these car fumes are really horrible. It's making me cough and wheeze. But these cars aren't even going anywhere. They don't need to have their engines running when they're not moving. When an engine is idling, it's just churning out fumes, which causes unnecessary pollution. And these fumes can cause serious health problems. Engine idling is bad for everyone's health. So remember, please switch off when you stop.
Simply stunning kitchens and bathrooms by Duffy McLean are designed and built with love.
Duffy McLean have been first class.
They have given me everything that I wanted and more. Look at the excellence of the design here.
They knew exactly what we wanted even before we did.
They've made the visions for our home come true.
Visit our showroom at Geddes House, Livingston. Duffy McLean. Put your world in our hands.
Let's find out what's going on. It's our latest STV Edinburgh news.
And welcome back to STV's programme covering a landmark moment in Scottish justice and journalism. Throughout the course of today, we're bringing you live coverage of the court hearing of the legal bid to overturn the election of Alistair Carmichael as the MP for Orkney and Shetland. Lesley, we've talked a bit about the legal process here. We've talked a little bit about the politics of it. What we haven't touched on is this is a significant day for people who are interested in the workings of the court. Now, this has been done as part of a public service. It hasn't been riveting, but nevertheless important for those who wish to access these kind of things.
Well, it is, and as Robert was saying, we haven't heard the both sides of this case yet, but it does also open up the difficulties of any lay person being able to follow much in the way of legal argument. I mean, there's probably no way around that, because obviously people are having to tick the boxes of very precise requirements within the law and then contest one another's choice of which things are important. I understand that. But I'm sure a lot of people watching this now will simply feel that for something that feels like just a really important political, moral question, they haven't got traction with that. And perhaps we now expect them to, because we've watched so much court stuff on TV, that we expect to see the big themes in there, and we have had no big themes.
But it's useful, Robert, from the point of view that most people who access news from the courts will access it through TV news reports at night, where the average package is about 2 minutes long and maybe 13 or 14 paragraphs in a newspaper. It may well not be interesting, but at least it gives the citizen an idea of what the process for this election court, at any rate, is all about.
I guess it depends on the sort of cases going forward. I mean, I must confess I'm personally very, very cautious about the televising of, shall we say, criminal proceedings or things of that sort, where quite a lot of pressure is then put on witnesses and accused and people who are giving evidence in these sorts of situations. I think we've got to be very careful about that, because the objective of the exercise is to do justice in the individual case. This is slightly different, because it's judges who one imagines are a bit more immune to being too bothered about the extra publicity involved. And it's obviously not an evidence-giving session, it's a kind of argument session, if you like, on the legal issues. And I think there'll be relatively few cases where probably, therefore, suitability for broadcasting would arise out of the nature of the discussion. I'm bound to say, and I'm sure Jim will confirm this, most debates, legal debates of this kind, I think are extraordinarily tedious to the outsider, and probably not the sort of thing that's going to get, going to outdo casualty.
Because a legal debate in a criminal trial can't even be reported, because it tends to take place out with the context of the jury. Jim Chalmers, what's your reading of where we are in terms of the whole issue of cameras in the courts? We had recently sentences which have been recorded. Is there an appetite to try and demystify the system?
Well, there's always been that appetite, and it's quite some time since the first trial in Scotland was recorded for television broadcast, and I think one reason why things didn't move very quickly after that is it was just a bit dull, and that often is the problem. Court proceedings, even at the trial level, are often not terribly exciting, and there's quite rightly a desire to make sure that what you get broadcast is something representative, possibly the whole thing, rather than just any odd sensational moments you might find. You're probably not even going to find any of them in proceedings like this. So there's an appetite for it to happen, but I suspect that the more that people see of it, the less enthusiastic they might be.
And how important is it that this isn't, I mean, in the case of criminal trials, of course, they can last days, weeks, and if you simply cut together all the juicy bits, what you actually do is that you actually misrepresent what goes on in court. That may well not have been terribly exciting this morning, but at least people got the entire context.
Yes, I think that's absolutely right. I think this issue of misrepresenting what goes on in court is very important. There's often a disconnect between, shall we say, the sentences that criminal judges pass down in criminal cases with what the public believe ought to have happened in that particular case. But I mean, that often arises because of the fact that the public haven't heard the evidence, they haven't heard the representations, and they don't have the full story. And you quite often get nowadays a lot of these, a nasty murder trial, for example. Let's go to the victims' families for comment and so forth afterwards. Was that a good decision? Was it not? And depending on your personality, you say you should have got life sentences been hung, drawn and quartered, or you say, no, I've forgiven him, and the whole position is different. I'm not totally certain that a good bit of that adds too much to the sum of human knowledge, or indeed to an understanding of the court process.
Of course, these are all ultimately a matter for the Lord President, and we'll simply have to wait and see if this is a portent of things to come, or whether or not it's very much a one-off. But of course, this hearing this morning was dealing with legal issues, legal representations on points of law from Roddy Dunlop, who was saying that the petition was irrelevant. Let's just remind ourselves of some of the arguments that he made.
It is hardly unknown for a politician to speak of himself. And that, I dare say, applied as much in 1895 as it does today. Section 106 does not, in terms, address the situation where a candidate speaks of himself and, repeating the answer I've already given to my Lord Matthews, it would have been the easiest thing in the world for the statute so to have said. There is no decision which envisages self-talking being caught by Section 106. On the contrary, the authorities assume that the speaker and the subject are different persons.
When you say the authorities assume that, that's because they were different persons in the authorities referred to, is it not?
Well, that is the case, my Lord. But when we see what the authorities have said about what the Act is there for, then we see that the Act is there to stop people disparaging others.
Is it just disparaging?
Well, in my submission, it is all about disparaging.
Well, supposing you say you're an individual and you say that a particular candidate is the best thing since Mother Teresa of Calcutta, with a view to securing that candidate's election, could that not be a false statement of fact, which might affect the election, or might have a...
That is envisaged, at least in the Earlham case, which is the most recent decision, where the Commissioner talks about a statement that a man is a philanthropist.
OK, that was a flavour of the submissions which were made earlier on. Professor Chalmers, when we go back to what needs to be proven, the false statement, statement of fact in relation to a candidate, personal character or conduct for the purpose of affecting the return of a candidate in election, it's a pretty high bar, is it not?
All these three things are difficult to prove, but none of them are impossible. The petitioners have arguments to make in each one.
Yeah, and I mean, on the first one, made a false statement of fact. I mean, that's admitted to almost, isn't it? But when you get into the other ones in relation to a candidate, now, what kind of argument might they advance there? Because this was certainly an attempt by Mr Carmichael to undermine the First Minister, Nicola Sturgeon, who of course wasn't a candidate in the election.
No, the statement has to be, to fall within the legislation, one about Alistair Carmichael himself. As far as the legislation is concerned, anything he said about Nicola Sturgeon doesn't cut it in terms of Section 106. The argument petitioners have to make is simply, well, OK, the law hasn't been used in this way before, but there's nothing to stop that. It says any candidate. He was a candidate.
So does that mean, in a sense, they take just the polar opposite view of Mr Dunlop, who was arguing that there should be a narrow interpretation of the section?
Well, I think they will have to accept, nonetheless, that because this is a penal statute, it's got to be construed narrowly. So I don't think there will be a dispute about that point, but there will be a dispute about the emphasis that you place on that. And I think they will be saying there's nothing strange or unnatural about the reading we're arguing for here. We're just looking for the legislation to be given its ordinary meaning.
So it's not a lost cause from their point of view. It's arguable, but perhaps difficult.
Yes, very difficult.
Robert, when you listened to the contribution that was made by Alistair Michaels QC, I mean, as a lawyer, where you have to argue things from first principle and evidence which fits principle, were you heartened by the submission that it seemed, on the face of it, robust?
Yes, I made the point earlier on. I thought, particularly in the latter stages, when he got into the kind of the detail of the substance of what had to be established, that I thought his actual argument seemed to me to be pretty devastating. You know, he made quite an interesting comment along the line, which I think said something like, you know, people puffing themselves up, if you like, in a personal sense, are pretty likely to be disbelieved. So this issue of the self-talking thing is rather peculiar, newly defined definitions. It's the core of the petitioner's case. That, I think, is where the main big problem lies, as well as what I thought was actually quite a valid and ultimately, you know, important distinction between political and personal statements. It's very odd, you know, that, I mean, at the core of this is not the actual memo, which is, you know, was a report second-hand of something else. It wasn't an attack on Nicola Sturgeon per se. That wasn't really the core of what's in the case either. Nor indeed was it even the leak. It's simply the denial of the leak, you know, and then the admission of it later on.
Lesley, what are you expecting to hear this afternoon?
Well, sort of just thinking through what's been said here, this construction of self-talk is a description which the lawyer has used to describe what other people might just say is lying about yourself. Now, you know, we were talking before about this distinction between personal and political, and you're quite right. In the Willis case, Willis was slagging off another candidate personally. He was, however, you know, doing that as a person. That's not part of politics, to tell lies about another person. And you can see that that's personal. But what would it be to be being, you know, personal in comments you make about that reflect on yourself? We haven't really gone there yet, so it's hard to see what that would be.
A bit more self-talk from me. Self-talk seems to be the expression of the day. We're now taking our final break before the resumption of the court proceedings. We'll see you again in a couple of minutes.
Industry award-winning Saltair Motorcycles is simply the one-stop shop for all your motorcycling needs in Scotland. We have an enormous selection of used bikes, full ranges from Suzuki and Yamaha, and are the only dealer in Scotland selling Indian and Victory motorcycles. We have a huge range of clothing, riding gear and accessories. Our knowledgeable and friendly staff are always here to help, and our training school means that whether you're a novice or an advanced rider, Saltair Motorcycles has everything under one roof. Call us now or visit our showroom in Edinburgh.
Tea.
Coffee.
Tea.
Coffee.
Tea.
Coffee. Iron Brew.
Have your say at scottpulse.com.
For quality kitchens and bathrooms, it has to be Fair Price Kitchens and Bathrooms. Competitively priced, designed for you, and expertly installed with exceptional customer care. Our team of fully qualified tradesmen offer a prompt turnaround with any installation. Visit our website at fairpriceforyou.co.uk, call us on 0131 552 0029, or come visit us at our recently extended showroom at Granton Park Avenue, Edinburgh. Fair Price Kitchens and Bathrooms. Make your home a better place.
This is where it happened. A stack of paint cans collapsed and smashed my leg. My lawyer at Slater and Gordon has been amazing. He even got me money when I couldn't earn. Now I can put a date on coming back to work.
If you've been injured in an accident at work, talk to a lawyer who will handle your case with skill, care and commitment. Slater and Gordon, your case is our cause.
Had a fun night and need a lift home? Capital Cars is just a phone call away. We'll allocate a car to suit your requirements, be it a 4, 6 or even 8-seater vehicle. Once your booking is confirmed, we'll send you the details so you know which car to look out for. Your driver will notify you upon arrival, and all that's left for us to do is ensure you have a safe journey home. Just dial all 7s or get our app at capitalcarsscotland.co.uk.
Did you know at Peter Vardy you can get 5 years 0% finance with no minimum deposit? Available across the full range of brand new 65 plate Vauxhalls. We're also giving away free servicing with every new car purchased. Up to £2,300 towards your finance and cashback for your existing car. Visit reviews.co.uk to see why our customers think we're the car company worth talking to. petervardy.com. In store, online, mobile.
Let's find out what's going on. It's our latest STV Edinburgh news.
And welcome back to STV's live coverage of the legal bid to oust Alistair Carmichael as the Member of Parliament for Orkney and Shetland. The hearing in Court 1 at the Court of Session in Edinburgh is scheduled to resume in 15 minutes' time at 2 o'clock, and we will be going back for that. Lesley, I noticed that during the course of the submission this morning, you were monitoring social media. There's always a debate, which is a legal debate, partly a political debate, and then there's what the ordinary citizenry will make of this. What are you picking up about what's exercising people about what they've heard?
Well, I suppose there's a frustration, really, between the mismatch between what seems to be an open-closed case of I lied, I leaked, and it was serious enough for me to resign as a cabinet minister, and not for that to be able to immediately result in this case going, one way. So people are finding that mismatch puzzling. So there's things that have come in. Somebody tweeted there is a fit and proper person test for owning a football club. Says a lot about parliamentary standards that we don't have the same thing. Now, you could get into what a fit and proper person is in football, but I think that's probably a dangerous thing to conduct in at the best of times. And there's other people saying if I worked in a bank and leaked false share information, it would be insider trading. So I think people are trying to take this case and analogize it with stuff they understand that's much more straightforward in cases that have been in the public domain. And they're seeing this as somehow analogous, and yet it's a much more pernickety thing to manage to follow it through in the court case.
Robert, there probably is this mismatch about what the court does, which is to follow the law and apply the law to the circumstances, and the citizen in the street who will say, here's a politician who's admitted to doing wrong, and there appears to be no price to be paid. At a sort of basic level, it doesn't seem just or right.
Well, a price has been paid, of course, in terms of giving up the severance payment and things of that kind. But again, you've got to look for parallels to some degree on this. How high up in terms of blameworthiness does all this stand? And I mean, I mentioned earlier on, and Lesley took it up as well, the issue to do with Alex Salmond's non-existent EU advice. Now, I think it's actually not all that dissimilar. There's another instance with the First Minister.
Hang on a minute. That was actually investigated by the Information Commissioner, and they found that he was cleared. And what he'd done, because I just had this tweeted to me by somebody, he, during that interview, which, again, I can't remember if it was Channel 4 that did this
Channel
again.
4.
Yep, they seem to have scooped the lot. In the interview, what Alex Salmond had said was that they had advice, and he discussed it then, what they had to date, and he declined to answer if they were taking any further advice, which is what both UK and Scottish Government ministers do. And that's why he was found not to have had any wrongdoing by the Information Commissioner.
They went on to spend a considerable amount of public money in actually defending a request for information about that. That was the core of the thing.
I don't think you're in a position to talk about wasting public money.
I think it's actually...
When Alistair Carmichael knew he had lied, knew he was the author of the leak, and let a whole ministerial inquiry come on.
I think that I'm trying to see the parallel between the sort of instance we're talking about. I mean, we had a further instance where Nicola Sturgeon herself had to appear before Parliament to apologise for the character reference she gave to some guy that was convicted of fraud. There was an issue to do with that as well. Now, that was a mistaken judgment.
Do you see that as analogous?
I think there's comparison. It was a mistake of judgment. That would be the position I think Alistair would explain about this one.
During an election campaign?
The election campaign, in a sense, is off to one side of the issue. That's to do with the remedy.
Not for people in Orkney and Shetland.
It's to do with the remedy. It's to do with the remedy.
Is there an issue here where some of the cases that you're banding about here are issues of judgment? You mean you've referred to the Nicola Sturgeon reference in the court. That would appear to be an issue of judgment. The Alex Salmond case that you've quoted would be a straightforward issue. Was he in breach of any ministerial code? What we're talking about here is a cabinet minister who has actually deliberately told a lie. That's a different thing altogether, isn't it?
I think it comes into a fairly similar category because Lesley's talking about the disconnect between what the public make of it. Now, many people have made comparisons between the Alex Salmond situation and the one we're talking about here.
But if they were wrong, what does that matter?
The point is, at the end of the day, these things have got to be determined according to the legislation laid down by Parliament to provide a remedy. That's the core issue we have to deal with on this one.
Do you accept the Information Commissioner found him to have had no wrongdoing? Do you accept that?
That's part of that's one
particular
one particular process. I mean, you're making the point here that there's a lack of adequate process according to you in this particular instance.
All the time until it doesn't suit
Process is hugely important. Process lies at the core of this. That's the point.
And I mean, at the end of the day, if the election court find in Mr Carmichael's favour, I mean, at least you can say he has been subject to the court process. The only penalty that will have to be paid is a political one, which would be exercised presumably by his constituents.
Well, yes, and what may well happen then is, all right, then there has already been £87,000 paid in, so it's been paid already to make this case a goer. But there will inevitably be more court costs needing to be paid by these four, so there will have to be yet more money raised, or the prospect of them being bankrupted. Now, does that sound good if you're an MP?
Would that only happen in the circumstances where Mr Carmichael petitions for costs?
Now, that's a good point, lawyers. Could he choose not to?
Could he choose not to petition for costs?
I would imagine he could choose not to. I have no idea what his financial position is, so I'm not going to speculate on what he might choose to do.
Right, so if he does petition for costs, then presumably his constituents could be, at that point, lumbered with the bill.
But is it also the case that the court's own costs could be held against the four complainants?
I don't think so. I think there's a difference between English and Scots law. Jim can maybe correct me on that. I don't think there's the court costs, apart from the fees you pay, to kind of kick the thing off.
Perhaps what this actually does raise is a fundamental point about should there be an alternative mechanism to hold people to account rather than expensive court processes.
The point was made earlier, and I think it's quite a valid one, that there will be political consequences to any particular course of events. So many of these political things end up in a situation where political parties or political individuals in elected office find themselves at the receiving end. Goodness knows we've had a good part of that with regard to our participation in the recent coalition government in London. These things have political consequences, whether right or wrong at the time.
Let me pick up, it was a point that Lesley made actually earlier on, that if Alistair Carmichael comes through this, in a sense, there is no political price that can be paid by him until the next general election, which is almost 5 years away. But if local campaigners are determined to keep this issue on the boil because they think it's one of integrity in public life, which is important, in a strange sort of a way, he'll be doing Tavish Scott and Liam MacArthur no favours whatsoever, will he?
It's very difficult to judge that sort of thing. People, as we've said before, tend in Orkney and Shetland and some of the Highland constituencies in particular to be a bit fairer than they're sometimes given credit for on some of these kind of things. I'm pretty certain the next Scottish elections next year will be determined by issues surrounding the aftermath of the referendum on the one hand, but much more importantly on the record of the SNP government on the other. Not actually a particularly good record, but that's another debate for another time.
Lesley, do you get a sense from the people who have organised this petition, and we heard from one of them in Orkney, that even although it's lost and even although they have these costs and people will no doubt rally to help them financially, that have they ever moved just to forget it, or could they take it on?
I don't know. But I don't think they will thrash this one much further than they get to with this, because it's been hugely nerve-wracking, very expensive, and actually they're fair enough people. That's the point. They're not this kind of swivel-eyed SNP loons that you know, some of the opponents seem to be characterising them as. They're normal people who were just completely annoyed at this outcome. So I suspect they would let it lie. And bear in mind as well, as you were saying, there are, if I get this right, two Labour supporters, one Green to get it right, and one SNP. Now, they're not all going to, you know, automatically have voted for Liam MacArthur and Tavish Scott in the first place. So the people who are, it's definitely people who were brought together by the Yes campaign, who were kind of enlivened by that to act quickly. Now, they were never going to perhaps be Lib Dem voters.
Perhaps they could approach the Labour Party and the SNP and the Conservatives to stand down in Orkney and Shetland next year.
Put up a sort of...
Put up a Liberal Democrat as against a sort of, I don't know, a sort of Martin Bell White Knight candidate. That might be interesting.
It would be interesting, but I somehow can't see that happening, actually. I think people, as you say, actually, I think people are quite fair. Both those MSPs have got, you know, quite a considerable personal following and are considered to be very good constituency MSPs. So I think it will go back to the normal challenges of the Scottish Parliament when it comes to their elections. But I'm sure that they are, that the MSPs themselves are a little uncertain at the moment as to how much collateral damage Alistair Carmichael could cause in what happens next.
Robert, has the party made an assessment about what the likely collateral damage is?
I don't know is the short answer to that. I don't imagine so. I mean, this thing's too unpredictable in the sense of we've got to have decisions on it yet. You know, whether it gets sorted out as a result of a finding that the case is irrelevant. I hope it will be after today's proceedings and maybe continue until tomorrow. Whether it goes to some sort of hearing on the facts at a later point. You know, there's too many imponderables, I think, for anybody to make a
well, we'll be going back to the court in about 5 minutes, where we're going to hear from another 10 minutes from Roddy Dunlop. He'll simply be concluding his submissions before we listen to the submissions which will be made on behalf of the petitioners. But just let's remind ourselves of one or two of the arguments that Mr Dunlop made this morning.
So this is the question of whether or not the words that were all agreed Mr Carmichael said offend Section 106 because they were false statements of fact in relation to the personal character or conduct of Mr Carmichael. The words "in relation to" are central. And they require, in my submission, a clear connection between the statement and the personal character or conduct of the candidate.
Well, let's speak again to Professor James Chalmers, Regius Professor of Law at the University of Glasgow. We sat through all of those submissions this morning. They were very, very long. They were very, very detailed. Just for the purposes of viewers who may well be just joining us for the afternoon session, if you try and sort of crystallise, what were the principal points that he made this morning?
Okay, well, Roddy Dunlop really has 3 main points, and he's made 2 of them so far. One, he's arguing that the legislation does not apply to statements that a candidate makes about themselves. So can't apply to Alistair Carmichael lying about whether or not he leaked a document. Secondly, that the statement was about a matter of political character, and the legislation only applies to statements about personal character. What I think we're going to come on to in the afternoon session now is an argument about whether the statements demonstrated an intention to affect the result of the poll in Orkney and Shetland, because that's what matters for the legislation. It's not enough to show that Alistair Carmichael might have intended to influence the outcome of the general election. It has to be shown that he intended to influence the outcome of the election in his own constituency. Now, that's something where the argument may be there's just not enough of a basis in the papers before the court to actually suggest that.
And for viewers who don't sit through courts or legal arguments, in terms of a legal submission, the kind of length of submission that we had this morning and the detail, is that pretty straightforward? Is that normally what happens?
Well, it all depends on the case, but something as important as high profile as this, you are going to get that level of detail. And what Roddy Dunlop, I think, has been trying to do is just tease out all the background, all the historical detail. So the case that he's making doesn't simply rest on one or two arguments which might be knocked down by the petitioners.
Sure.
There's actually a whole series of different points he's made which they're going to have to try and unpick in their response.
Just on that, again, from the layperson, I mean, I'm watching it, and at one point he said, I'm now coming to the substantive reasons why you should reject the position. And he traced Section 106 back to 1893 and then to a change in 1895. Now, again, from the from my point of view, why would you do that when I would have said, well, the only thing that actually counts here is what Section 106 says today? Why do you need all these historical submissions?
Well, the difficulty for him, I think, why he's going through this history is he's trying to prove the absence of something. So it's more difficult than simply pointing to, like, this is where the law says this. He's trying to argue that the law doesn't say this. The law doesn't apply to statements about yourself. And I can demonstrate this by going through the history and showing at no point has this ever been contemplated, or where it has, it's been very quickly dismissed. So that's why you need that very detailed, layered kind of argument.
So the argument there is not just that Section 106 doesn't apply, but that if the court was to take a different interpretation, they would be changing practice effectively, which is over a century old.
Exactly. Now, my guess would be, and it's just a guess, that you will see less of that legislative history being made in the petitioners' arguments, that they will want to argue much more about just what the plain language of the statutes says. But because Mr Carmichael's position depends on showing that the legislation was never intended to do this, it's never been used in this way, that requires you to show at great length that that's never happened, and hence you get that detailed kind of argument.
Now, before the judges make a determination on this, will they go away and reread every case that was mentioned today in the submissions to double check that the submissions that have been made by Mr Dunlop are as he claims they are?
Well, they'll be relying, I think, in part on the counsel for the petitioners pointing out any points where they disagree, but they have all the materials. They will be going through these in some detail themselves.
The petitioners, I mean, Jonathan Mitchell, does he simply disagree with everything that's been said this morning, or does he have to take the same section and argue why the circumstances fit the section?
Well, he may well agree with some of what's been said. He obviously won't agree with any of the main points, because at that point the petitioner's case would fail. He may agree with some of the background issues that Roddy Dunlop has set out, but then try and suggest, well, despite that argument, the legislation can still be used in the way that we want. So we're unlikely to see an exact mirroring in the form of argument, but it'll be interesting to see exactly how it is presented.
I mean, he stated very early on that this was the first time I think the election court had sat in 50 years. Does the determination of Lady Paton and Lord Matthews, will that create a precedent? Okay, well, we'll go straight back to the court, because I think they're about to start the afternoon session.
Yes, Mr Dunlop. Thank you.
My lady. My lady, just before turning to Chapter 3 of the submission and to answer my Lord Matthews' question, Mr Biles was not Biles of Biles on Bills. It was William Pollard Biles as opposed to Sir John Barnard Biles.
You'll sleep easy tonight.
Then moving to the third and final chapter of my submission, and this arises, of course, because of the requirement in Section 106 that the impugned statement be uttered for the purpose of affecting the return of any candidate at the election. And this is a short point which arises from the way in which the petitioners put their case in Statement 9 of the petition. Page 11 of the joint bundle. And it's the last maybe 10 lines of Statement 9 on page 11. And it's really just one sentence. This is the sentence on which the petitioner's case in this regard is perilled. Against a background of polling which indicated the SNP would gain the majority of votes in each of the 59 constituencies in Scotland, with the result that no Liberal Democrat or any other political party would obtain a Scottish seat at Westminster, it is believed and averred that the statement by Mr Carmichael was for the purpose of effecting the return of the candidates at the election, whether that election is taken to be the constituency or the general election as a whole. Now, the 2 points which we seek to make really arise from that one sentence. First of all, the averment is predicated on the formula believed and averred. Now, against well-known authority, which is referenced in the note of argument, and which I won't detain the court with unless they wish me to do so, it is necessary for that belief to be a justifiable inference from primary facts. The only primary fact advanced is a background of polling which indicated that the SNP would gain the majority of votes in each of the 59 constituencies. Now, that might explain the motivation behind the leaking of the memo in the first place, as it might be said to be harmful to Miss Sturgeon. But the petitioners accept that they cannot complain about the leak itself because Miss Sturgeon was not a candidate in the election. The polling does not give rise to any inference that the denial of the leak was aimed at affecting the result in the election. But the position becomes more acute.
Well, you say it doesn't. You have to go. You have to say it could not. You know.
When I say does not, I mean cannot. Your Lordship's quite right. That must be the test. It does not give rise. It cannot give rise to that inference. But the position becomes more acute when one considers what it is that then follows. Because their belief and averment is that Mr Carmichael denied knowledge of the leak for the purpose of effecting the return of the candidates at the election, whether that election is taken to be in the constituency or the general election as a whole. Now, we've already seen section 106. The statement has to be for the purposes of effecting the return of that candidate. Not to the candidates, and moreover, when one's asking, well, what does the election mean? It is plain that we're talking about the election in which that candidate is standing, and not the general election as a whole. Now, before I go on to make good that proposition, in my submission, this is a very clear case of the weaker alternative rule. The petitioners say that this was for the purpose of effecting one of two things. Either the election for the constituency or the general election as a whole. Now, there are various authorities before the court, all familiar, for present purposes, in my submission, a sufficient distillation of the weaker alternative rule is found in Lord MacPhail's work on Sheriff Court practice, which of course gives general guidance on pleading across the board. That is at tab 6.25 in the bundle. Now, the joint bundle page number, I imagine, will have been obscured, but it's page 307 of the work itself.
Yes, that's right. There is no top right-hand corner in this one, but page 307, yes.
And it's paragraph 9.36, milady.
Right.
Where the learned authors say, in cases where there is an alternative averment of fact, relevancy must depend on the alternative which is weaker in law, that being the only one which the pursuer absolutely offers to prove. And we see that that comment is vouchsafed by Inner House authority, which is in the bundle. So where there are two alternative and inconsistent factual grounds of action, one of which is not supported by relevant averments, the whole action is dismissed. If legal liability arises only on proof that the fact is A, and if all that a pursuer offers to prove is that it is either A or B, his pleadings are irrelevant. The relevancy of the case is tested on the weaker alternative. That's exactly what we have here, because the petitioners only offer to prove either A or B, and B doesn't work. And I say B doesn't work because if the court turns to tab 6.1, they find the definition of parliamentary election. It's in the Interpretation Act of 1978, tab 6.1, joint bundle, page 137. And it's of note, the court will see the square brackets after parliamentary election, which is about halfway down the page, 1889. So this is a direct lift from the Interpretation Act of 1889. This is a definition which has been in place throughout the period with which the court is concerned. And parliamentary election means the election of a member to serve in Parliament for a constituency. So we are talking about the election for the constituency of Orkney and Shetland. We are not talking about the general election as a whole. Judicial affirmation that that is the case can be found in the Grieve against Douglas Hume case, to which I referred earlier, tab 6.10 in the bundle. And as Lord Matthews has already noted, this was a complaint that in some way broadcasts facilitated by the BBC amounted to unlawful financial assistance infringing against certain passages in the 1949 Act. But the question of what was meant by election is touched on, and if the court turns to page 666 of the joint bundle, page 329 of the report. This is Lord Migdale, who along with Lord Kilbrandon made up the election court. And in the central paragraph on that page, we see that Mr Mackenzie Stewart, who was senior counsel for the petitioners there, referred to the Tronach Mines case, a case heard in the Central Criminal Court before Mr Justice McNair after the general election of October 1951. The defendant and its secretary inserted an advertisement in a newspaper criticising the Labour Party's policy to control dividends of companies and inviting electors to vote for Mr Churchill and his government. The charge was breach of Section 63 of the 1949 Act. Mr Justice McNair found the defendants not guilty. He stated that this section and others dealt with election expenses. Election expenses meant expenses incurred in a parliamentary election, and by Section 17(1) of the 1889 Interpretation Act, that meant an election for a particular constituency and not a panoply of elections commonly known as a general election. The real purpose of the expense had been for general political propaganda and not to promote the election of a particular candidate. His Lordship said, "I therefore accept the submission that Section 63 does not prohibit expenditure, the real purpose or effect of which is general political propaganda, even though that general political propaganda does incidentally assist a particular candidate amongst others." Now, that case was criticised by Mr Mackenzie Stewart, and both Lord Migdale and Lord Kilbrandon indicated they thought there was no valid criticism. And we see that with Lord Migdale at page 334, 671 of the joint bundle. The pre-penultimate paragraph of Lord Migdale: "Do not find it necessary to consider the proposition based on the decision in Tronach Mines. I will content myself with saying that I see nothing wrong in that decision." And likewise, Lord Kilbrandon at page 338. At the top of that page, "I see no ground to criticise the reasoning of the learned judge," referring back to the Tronach Mines case, which he dealt with on the preceding page. So, my lady, my lord, the short point made under reference to this third passage is that something done for the purpose of effecting the return of the candidates at the general election as a whole, which is, as MacPhail's work explains, the only thing they absolutely offer to prove, does not engage Section 106. And as that's all they offer to prove on this third and final ground, the petition is irrelevant. Lady, my lords, that is all I wish to say on each of the three aspects. I am, of course, content to deal with any questions that may arise, but ultimately the submission for the respondent is that there being no relevant case set out in this petition, it should at this stage be dismissed with a consequent report in terms of Section 144 of the Act, finding that the respondent was duly elected. And I so move the court.
Well, I just have one question about the last section there, Section 3. What if the statement was for the purpose of affecting the return of Mr. Carmichael himself? I mean, that would be quite valid, would it not?
If I'm wrong on question 1, self-talking.
We're just looking at chapter 3. Yes, chapter 3.
If I'm wrong on 1 and I'm wrong on 2, and if the statement was made for the purpose of affecting the return of Mr Carmichael, that would be relevant.
Yeah.
But that's not what they offer to prove.
Right. I just wanted to clarify that would be relevant. What's averred is perhaps a matter for Mr Mitchell to address us on as well, but as long as the person making the statement had in mind affecting the return of, well, here it would have to be himself as a candidate.
Indeed, at the Orkney and Shetland election.
That's right. But that would be relevant.
That would be. That's what's necessary.
Right.
And that's what's absent because of the weaker alternative route.
Right. And the only other matter I wanted to ask was, it was in connection with Lord Matthews' question about, is it not possible that the statement might be for the benefit of the candidate? And speaking of good qualities about the candidate, and I think you responded with an answer about a philanthropist.
Yes.
Yes, was that a reference to the case of Rahman, perchance?
Erlam, I think.
Well, yes, it's 622.
Oh, yes, no, that's correct. Sorry, you're
yes, could we just have a quick look at that?
Yes, absolutely.
Because I think you were suggesting it had to be detrimental, but if we look at 6.22, paragraph, I think it's 104.
That's correct. This is the philanthropist aspect of it.
That was exactly what you referred to, yes. So it must have been subconsciously a reference back. And this is the Queen's Bench, am I right?
It's Commissioner Murray QC, an electoral commissioner appointed under the Act.
Right. Where do we see that?
I think that's at the beginning.
All right, page 91. Oh yes, I see that. Commissioner Richard Murray.
Yes.
And his view at paragraph 104 is that although section 106 usually refers to statements made to the detriment of a candidate, the wording is wide enough to encompass a false statement made in favour of a candidate, for example, that he is a substantial philanthropist or has been awarded a medal for bravery, which might affect his electoral chances.
Yes.
Albeit positively rather than negatively. Yes. So do you disagree with that?
I say three things about that passage, Millie. The first is that the Commissioner begins his commentary by saying that the wording is deliberately wide.
Yeah.
That does not sit well with the comments from Willis that one must interpret this narrowly.
Right. Yeah.
The second is that the Commissioner only has in mind laudatory statements. And this is why when I was addressing Lord Matthews' point, I said, well, I disagree with that, but ultimately the court doesn't need to battle with that because it's not about laudatory or non-laudatory statements. It's about self-talking.
Well, you could have a self-talking laudatory statement.
Yes,
yes.
Yes, but all that the Commissioner is talking about is laudatory statements. He's not dealing with self-talking.
Right. Well, that, yes, obviously that issue has never been ruled upon,
Yes,
I think, the
that's
self-talking bit.
That's right.
But the laudatory bit has, on one view, been ruled upon by the Commissioner.
Well, he says it's wide enough, and I say, well, how does that fit with the narrow construction that Willis tells us to use?
Right.
And the third thing I say is, there is no indication that, and doubtless because it wasn't an issue in this, there's no indication that the Commissioner has looked back at the genesis of the 1895 Act and at Hansard in the way that was done in the Thompson case, where it's described as the public policy behind the Act is protecting against vilification. And I suppose I said I had three things to say. The fourth thing I would say is, well, if he's right to say that it is wide enough to include it still come back to Mr. Justice Brett's comment, as quoted in Benyon, that that isn't enough unless the policy of the statute is clear. Because if you're in a situation where it could mean A or it could mean B, that doesn't work. Because we're in the ambiguity situation discussed by Mr. Justice Brett at page 750 of Benyon.
Page 750, yeah. And then I just have one final question. I think in the case of Woollis, if we could just look at that again, remind me, is that 6.19?
6.19, lady,
Yeah.
yes, that's right.
If we look at page 27, I may not be able to find it immediately.
Page 27, my
Page
lady, is
27.
864 of the joint bundle.
Right, got that. Yes, just the quote, which in fact you read to us this morning, just before lunch. That quote between B and D.
Yes.
There's a sentence right in the middle there. To say that someone is not worthy of trust is to attack his honour, veracity and purity. Well, all that I want to ask in relation to that is, supposing the leak is one compartment, as it were, and you just put that to one side, as you say, it's not the leak as such which is the issue, but you move on to the next compartment, which is the candidate making a false statement which, in effect, distances himself from the leak. And so, subsequently, it's discovered that that distancing is not true. You don't think that that statement there about to say that someone is not worthy of trust might be applicable?
The statement between B and D
Yeah.
is the pursuer's case, the petitioner's case.
Right.
The statement between B and D is that which the divisional court held to be erroneous in law.
So you just...
This is the reasoning of the election court on the first of the three grounds upon which Mr. Woollis was convicted. And it is the one that is overturned by the divisional court as being erroneous in law.
Yeah. Well, obviously, a degree of trust, it will depend upon what has been said and what is the event which gave rise to the trust or lack of trust. Reneging on a promise to move to the constituency is one thing. Perhaps saying that you have not been contributory to or involved with a decision which is important, very important in the campaign, might be another matter. Might it not be a question of circumstances in every case?
Well, each case has to be judged on its own. That's
Yes,
very clear.
yeah.
But, my lady, what we have here is the reason why Woollis in the divisional court overturned the election court is the passage at page 40 that I sought to stress earlier. So page 877 in the joint bundle.
Yes, page 40, right.
And it's actually, it starts the preceding
paragraph
page.
113, is that right?
It actually starts at 112.
112,
The last few words of page 876 of page 39 of the report, in our view, it is of central importance to have regard to the difference between statements of that kind.
I'm sorry, just where are you reading from?
So right at the bottom
Right at the
of
bottom.
page 39.
Page 39, right. Oh, in our view, I've got it. Yes, thanks.
To have regard to the difference between statements of that kind and statements about a candidate which relate to his political position, but which may carry an implication which, if not made in the context of a statement as to political position, impugn the personal character of the candidate. And then just above letter C, in 113, a statement about a candidate's political position may well imply that he is a hypocrite or untrustworthy because of the political position he is taking. That is not a statement in relation to his personal character or conduct. It is a statement about his political position, though it might cast an imputation on his personal character. That's what we have here, and that doesn't work. And that's why the passage that my lady refers to in the decision of the election court was ruled to be erroneous in law.
In the circumstances of that case, I have to say, yeah. Right, well thank you very much. Any questions? No. Right, I think no further questions. We're very grateful to you. Thank you, Mr Dunlop.
Pleasure.
Yes, Mr Mitchell, when you're ready, thank you.
Yes, I think I should first say that it looks likely that we're going to go into tomorrow morning at this,
yes,
at this stage.
I would agree.
Yes, so I'm not going to attempt to hurry through this so as to be through by 4.
So we'll just carry on, rise at 4 o'clock and then begin again tomorrow at 10:30.
Absolutely, and we'll see how far we've got. Can I begin by making some short preliminary points? The first is simply as to the running order of what I am going to say, so that the court can see where we're at. What I propose to do is firstly to address the nature of this hearing in this court, and that I propose to do largely by reference to the supplementary note that went in on Friday, which I believe the court should have had before the weekend.
Indeed, we've got that as number 7.
Yes,
I think.
Yes, in that bundle. Yes. The second chapter that I'll be addressing is aspects of the factual context of this, which has taken some prominence in Mr. Dunlop's address, quite rightly. The third is the issues which are before the court in terms of my lady's note of, I think it was the 8th of July. And I'll take those in the order in which they're given.
I think it was the 6th of July.
6th, yes.
Oh, no, maybe not. No, it may have been the 8th. You're right. The hearing was on the 7th.
The hearing was, yes, I think my lady's note was on the 8th. It doesn't matter.
Right.
We all know what the issues are. Yes. But that is when they were fixed. And finally, I will make some general comments as to the proper approach to be taken, which could be described in a way as background comments, but they seemed to fall more neatly into the end part of my submission. And I'll also deal with the orders that might properly be made by this court. That's my first preliminary point, was just the running order. The second point was this, and I don't remember ever saying it to a court before, but I thought I ought to. There were some discussions as to this. In the nature of this case and its public interest, I take it that there's no objection from the court to the notes by parties, and I'm distinguishing that from the appendix material, to these notes going into the public domain. Clearly they are, as a matter of law, in the public domain anyway, but I'm simply concerned that we don't have to, that the public doesn't have to hang around not understanding what it was that was said.
So, are you referring to the notes of argument by counsel? Or?
Yes, there's the 2 notes of argument, and there's also my supplementary note. I should say, I don't think it's for me, I don't think it's for us, the petitioners, to put the respondent's note into the public domain, and we don't propose to do anything about that. But there are our 2 notes which substantially set out our stall upon why we are here today.
Yes, that's right. Well, if you just give me a moment, I take it you've got no problem. Yes, that's quite acceptable, Mr. Mitchell, that your note of argument, and indeed Mr. Dunlop, if he feels like distributing his note of argument, there's no objection from the court.
No.
Yeah.
I suppose you could stand up and read it out anyway if you wanted to, then it would be in public.
Well, exactly, but that's time wasting, and it's in the nature of a case such as this that one, to a large extent, does not deal with the matters that are spelt out in the note of argument.
I think there has been some discussion in the press, obviously, and it's helpful for the press, I think, to know precisely what the real issues are rather than speculate on what they might be.
Well, absolutely, and not surprisingly, there's been a number of queries from the press, both to the Petition Department and the press office, and also to those instructing asking me about whether they could see these. Yeah. We didn't ultimately think that we ought to do this without the agreement of the court.
The court's permission, yes. Well, you have the court's permission.
But we do now, yes. The question that I have then is as to the nature of these proceedings. Now, that bites particularly on the third submission that is made for the respondent, the argument as to, as it's put, the relevancy of the averments. And that is a matter which is dealt with substantially in my supplementary note. It's a matter of, I think, novelty in the nature of these proceedings.
Sorry to interrupt, Mr Mitchell. What tab is your supplementary notes?
That's tab 7 in the supplementary bundle.
So it follows, I think, Mr Mitchell, from your final production, which was lodged there, 6.31.
Well, final authorities, rather, yes.
Sorry, final
yes,
authority,
yes.
And so that would be at the back of... Yes.
Be at the very back, yes.
Yep.
The court has been addressed upon this matter as if it was an old-fashioned procedural debate upon the relevancy of the pleadings, by reference to Jimison. Now, with all respect, that is an approach which has no basis whatsoever in the election court, which is not indeed a Scottish court at all. We have headed our notes that this is the election court of the United Kingdom. And that is correct. My Lord and my Lady do not sit as judges of the Court of Session. This court is indeed subject, as we know from Wallace, and I don't think there's been any dispute on this in Scotland, are subject to judicial review by the Court of Session. More profoundly, the court sits as something almost akin to a committee of Parliament, a committee of the House of Commons. In 1868, when the election court was founded, it took over a jurisdiction of the House of Commons. And as the court has seen from the Act, I don't want to spend time on this, ultimately what it does is it reports to the House of Commons. Now that's a function which, so far as I'm aware, is unique in the court system. In the ordinary way, courts make operative judgments. Here what we have is a reporting to the ultimate judicatory body, the House of Commons. And the court which does this is nowhere said to be a Scottish, English, or Irish, now Northern Irish court. It is simply composed of a rota of judges who are drawn from the different parts of the United Kingdom. And in the nature of the case, Scottish cases are heard by Scottish judges, and so on. In UK terms, possibly the closest analogy is the Employment Appeal Tribunal. There are implications which don't really matter for today's purpose, such as this. It is well established that there's no exclusive right of audience in the election court for counsel in the manner that it would be if this was in the Court of Session. Solicitors may appear on behalf of their clients, as they formerly did when committees of the House of Commons dealt with this matter. With a single exception, which I will just come to, it has never been suggested before that the approach of the judges to the petition should be taken from the approach the court would take to an ordinary petition to the Court of Session. If the Court will just go to Chapter 69 of the Rules of Court. It's anomalous in itself that they form part of the Rules of Court of Session, but there we are. 69.2 deals with the election petition. And it says what the petition must say. It specifies the name, designation and address of the petitioner and the actual or deemed respondents. That is why, incidentally, the returning officer was called, because the rules told us we had to, although we had no complaint against him. 2b, it must set out in numbered paragraphs the title of the petitioner, the proceedings at and the result of the election. 3, the facts relied on in support of the prayer of the petition. That in isolation might be taken as being the facts which the petitioner sets out to prove. But it is not, because if we then go on to later rules, at 69.11, there is a rule dealing with the lodging of a list of voters who it is intended will be objected to and what those objections are. And in that context, no evidence shall be allowed to be given in support of any objection or against any vote which is not specified in the list, not in a petition. And 69.12 is the flip side, where the respondent wishes to put in a list. That is how, I should say, the rules stood in 1868, when the election court first came into being. And in the very first case that came to the court later that year, it was noticed that that did not deal with all matters that might be put in evidence. And the ancestor of Rule 69.13 was added. I'll come to the 1868-69 rules, but just looking at rules as they stand now. 69.13 provides for the lodging of a statement of the evidence to be led. Any party shall, not less than 6 days before the date of the trial, lodge a statement of the matters on which he intends to lead evidence. We've done that, the respondent hasn't. And then 69.14, no evidence shall be led at the trial of an election petition other than matters contained in A, the list lodged, doesn't affect this case, B, the statement lodged, or C, matters which have been sufficiently set out in the petition. Not the answers. If the respondent wants to put anything into evidence, they have to do so by way of statement, except with the leave of the election court. And what one immediately sees from this, B, the statement, or C, the petition, is that something may be the subject of evidence, although it's not in the petition, it's in the statement. That rule, as I've said, was added in 1869, in fact, at the beginning of the year, in consequence of the problem emerging in a case which is in the supplementary bundle, Christie against Grieve, which is 626, page 1035.
Just to make sure I'm following you here, Mr Mitchell, you say 69.14 has A, B and C.
Yes.
That is the list, the statement and matters sufficiently set out in the petition. So you're saying, in effect, that if you disregarded C, you're still entitled to lead evidence under A and B?
Yes, it is plain from Rule 69.14 as a whole that evidence may be led either upon the basis of the list. Lists are about the old-fashioned sort of case where it was objected that so-and-so was a Hungarian citizen and so-and-so had not been qualified to vote or was too young, that sort of thing. It doesn't matter here. B is what we have, the statement lodged under 69.13, for which there was a mandatory time limit. We've complied. Or C, matters which have been sufficiently set out in the petition.
So you say that that in itself shows that this is not the same sort of test of relevancy as you apply in an ordinary action?
Absolutely. There is, in a sense, a test of relevancy when one looks at the statement, because clearly, ultimately, it's a matter of fair notice. What one is looking for, and one immediately reflects that that's the only reason why we have relevancy tests of fact at all, opposed to relevancy in law, is fair notice to the opposing party and to the court of what it's considering. But if one can produce this material only when it's only under B, it's not in the petition, it becomes apparent that it doesn't really matter whether or not it's in the petition at all. And there is sound reason for that, because the petition must be submitted at extremely short notice. The court has no power to extend the statutory time limits as opposed to time limits in the rules. But the submission that I'm making is in truth something which was decided in 1868 to 69 in the first petition in Scotland, certainly, to the election court, which is Christie at tab 620. Oh, I'm sorry, I'm misreading it, 626.
Sorry, 626?
626.
Yes, 626, right.
This was an election petition on grounds of bribery, treating, and undue influence. The reports of the election cases of that period typically commence with the sentence, the usual allegations were made. The 1868 Act is quoted. It is the same as we now have. An election petition shall be in such form and state such matters as may be prescribed, so it leaves it to the rules. And it there says that the judges, for the time being on the rota, may from time to time make rules. Now, of course, it's a court of session. The judges on the rota at that time were Lords Cowan and Jerviswood, and they framed certain regulations. As they stood at that point, they did not contain an equivalent to Rule 69.13. That is quoted at the top of page 379 of the report. A condescendence, according to the rules and practice of the Court of Session and ordinary proceedings, including the facts relied on in support of the prayer of the petition. So it's slightly closer to the argument that Mr Dunlop makes as to what it is that's before the court. A couple of paragraphs down, the respondent presented a note to Lord Cowan to have the petition dismissed in respect that it did not set forth with sufficient specification the facts relied upon in support of the petition. I should just note at this point that this is a case in which there was considerable confusion as to what was within the powers of the election court and what was within the powers of the Court of Session. But that does not matter, except that it caused, as I say, some confusion, which is reflected in much of what is said in the report. Lord Cowan then, on the 28th of December, pronounced an interlocutor in the Court of Session in which he refused the prayer for dismissal under a declaration that the petitioner shall lodge a written statement setting forth articulately the names and designations of the person or persons alleged to have been bribed and so on, with such particulars as to the alleged acts as shall afford to the respondent fair information in reference thereto. So by his interlocutor, it is obvious that he did not regard the petition as having done that. Put it another way, he would regard the petition under ordinary principles as being irrelevant. But here is the remedy, further particulars. And there was further provision made. The respondent reclaimed, and we then have the opinions in the Court of Session of the Lord Justice Clerk and then of Lord Cowan. At the foot of the page, Lord Justice Clerk notes that the petition is said to be wanting in that which is necessary in a petition framed according to the rules of court. He deals with this at some length. And halfway down page 380, he notes that this is a matter for the election court. Lord Cowan is not in this matter a Lord Ordinary. We have no jurisdiction of review at common law over the judgment of one of our brethren acting under special statutory authority. He then deals with the merits. That is to say, the merits of the plea for dismissal. He notes the argument for the respondent, which is the same as the argument presented today. He says that the Act only requires the petition should be in the form of a condescendence. We have here a statement of facts, not certainly a statement of such individual fact which is to be proved, which would seem to be very much a statement of the evidence of the general fact. I've looked at the session papers, and that was really all that was said, was that there had been extensive bribery. What would be sufficient specification? He asks the question. He says, this is all very unreasonable. I do not think it is necessary to set out the details in the petition. I have nothing to do, that's qua Court of Session, with annexing a condition to the interlocutor as to specification of particulars. That falls within the province of the judges on the rota. Lord Cowan deals with this. The question seemed to me one of considerable difficulty and doubt. Over the page, having dealt with this question, whether this was a proper appeal in the Inner House at all, paragraph that begins, as to the question whether the application is well founded on its merits, I've already explained my views. The fallacy of the respondent's argument, reasoning, lies in the mistaken construction of the expressions employed. He asks to have the petition dismissed. In respect, it does not. In terms of section 22, that's a typo for 2 of the rules. Set forth the facts relied on. He then says that they do not, the rules do not say that they need to. The form of the condescendence is adopted. Nothing more is intended than what's required by the English rules as to this matter. He then notes the peculiarity in the next paragraph of the jurisdiction, and it seems to be forgotten that it's simply to transfer a House of Commons jurisdiction, and where no provision otherwise is made, the principles and practice of the House of Commons committees are to be observed. Hence, the statute will be found to be full of apparently inconsistent provisions if we judge it merely by the law of Scotland. The great object has been to endeavour to assimilate procedure to that adopted in England. This having been the principle, we should be careful to depart as little as possible in the course of procedure. It would be strange if a petition which should be sustained in England under the statute should be rejected here. The principle on which the judges have gone in framing the rules of procedure have been to proceed in unison. Now, that interlocutor, that resulted in the interlocutor at 382 of the 12th of January. That date's significant, slightly significant. The matter is really a matter for the election court. The next day, on the 13th of January, Lord Cowan and Lord Jarviswood made supplementary rules, which correspond to the current rules. That is at tab 628. Now, given there the rules as they stood in 1868, when they didn't have the equivalent to the modern rule as the statement of particulars, but we've added at the end, the last 2 pages, the additional rules of 1869. Evidence need not be stated in the petition.
Sorry, no, you're right.
I'm sorry, it's the last 2 pages, last two sheets rather,
yeah.
of this. I'm sorry, it's sideways.
And you're reading from, I see you have a page 16, page 17, then
page numbers aren't on mine, I'm afraid, but
right.
certainly it's the last 2 sheets in this divider.
In this divider, which is 6.28, yes?
Yes. Parliamentary Elections Act of 1868.
Right, and well, unfortunately I have a Schedule F, a Schedule E and a Schedule F, which are notices of, they're pro forma notices which parties give each other.
What I think my lady should have, the last sheet in this, 1058.
Right. Wait, let's just take this item from the beginning. Is it headed Parliamentary Elections Act 1868?
Yes, but there are 2 parts within that. The first is 1048. It's the first page in the divider, and I'm not concerned with that.
Right. Oh, yes.
At the end of the divider.
Right, so I have now 1049, 1050...
1057.
1057, right, thank you. Right, 1057, yes, I have it, thank you. You got that?
The Parliamentary Elections Act 1868.
Thank you, yes.
I'm sorry, it's just the way it's possible to print these days.
Indeed. But we have it now, yes.
Yes. So that's the modern rule. And it's added to deal with the problem which had been brought up in the Christie case. As I say, the day after the inner house interlocutor. Evidence need not be stated in the petition, but the court may order the petitioner to lodge a written statement of such particulars as may be necessary to prevent surprise and unnecessary expense and to ensure a fair and effectual trial. And 2, no evidence shall be received at the trial except as to matters within the written statement, ordered as aforesaid and tending to support the same, or matters which have been already sufficiently set forth in the petition. So what we have here is a quite separate code of procedure in this British court to the procedure of a traditional Scottish court, court of session or sheriff court. And there's no more room for a debate on the pleadings than there would be in the Employment Appeal Tribunal. Now, I'll come to what we have set out in our note of argument and statement of particulars. But I should just say that the identical approach has been adopted in England, and I don't want to spend time on this, but the matter is described in one of the two produced Earlham against Rachman decisions. My lady pointed earlier to the ultimate decision in that case, which is not yet reported. But this is at this one is tab 66.23, so yes, at page 1014. And we see from the rubric there was an attempt to dismiss that petition. As we already know, of course, that didn't succeed, and it was ultimately that the petition was ultimately successful. The attempt there was to dismiss it on the basis that there were extremely serious allegations which were almost wholly unparticularized. The election petition rules of England are referred to. The petitioners accepted that the successful candidate and the returning officer, against whom in that case allegations were also made, were entitled to more detailed particulars, but contended that the petition was not a nullity, and in accordance with traditional practice, the court could order further particulars to be provided. That argument for the petitioners was accepted. The petitioners were ordered to serve further particulars, and it was pointed out that while this is just opposite F, E to F, it would always be clear whether the petition stated a permissible ground on which a petition could be brought, but the facts relied on would be infinitely variable, so that what constituted sufficient particularity would vary according to the circumstances of the individual case. The traditional practice of ordering further particulars to be given when required had not changed. And there we have it. Now, what we have here accordingly, as stated in my supplementary note of Friday, is not a debate on relevancy at all. It is a part of the trial which is devoted to legal issues to be addressed in that context. I don't dispute that if this court didn't have before it an allegation that came under the Act at all, the court could deal with this as a matter of law. That's why we're here. But the court does so in the factual context. And I'll now come on to that. So far as factual context is concerned, albeit this part of the trial is not a proof of facts at which evidence is led, it is common ground between the parties, and has been so since draft notes were exchanged, that the factual context might be looked at. And I say that because the draft notes and the final notes on each side spell it out to some extent. More fully on ours, I would like to think. But it's there in the respondents as well. And so far as the respondents are concerned, if my lady and my lord will look at their note of argument, which is tab, I think, 3, it's page 25. At paragraph 1, having made the motion, they then say this: the background is largely undisputed, although certain matters, such as motive, which I think is there being used by mistake for purpose, but still, certain matters would require proof were the petition otherwise relevant. I should say they're clearly correct to say that it's largely undisputed, although there do seem to be differences as to some details of the fact and to a certain extent as to inferences. At page 31 in paragraph 21,
just give me these references again. Paragraph?
It's paragraph 21 at page 31 of the bundle. They say the context in which the first respondent made the statement, which has just been quoted, is important. Again, we don't disagree with that in the least. We certainly don't accept that a full statement, a proper statement of the context is then given. We certainly agree it's important to ask what is the context. Now, in our note of argument, the matter has gone into, if I may say so with all respect, substantially more fully. And a complaint was made about that last week, which the court will recall, which prompted my supplementary note as to the identification of what were called extraneous matters. But that's not been advanced today. Our note of argument at page 39 of the bundle, paragraph 4, begins with this sentence: the factual background to the case should be substantially uncontroversial and is here summarized. I don't want to go through the paragraph as a whole, but a description is given which is fully sourced. And then, paragraph 16, well, I should say perhaps the end of paragraph 15, page 47. We begin that paragraph by some rhetorical questions, which we point out the respondent has not attempted to answer. We'll come back to this when it arises under the question of what was his purpose. We say that an obvious inference, as we describe it, could be made. We say that the question is necessarily one of inference. We say, as did the respondents, that the context in which the impugned statement was made is of central importance. And we say that while the context is largely factual, it is not understood to be disputed or said to be materially incomplete by the first respondent. If it was, he would have said so in his note of argument, where he says, however, it is largely undisputed. Of course, we could quote it because we had drafts exchanged. Then paragraphs 16, 17, 18, 19, together with footnotes 38 to 51, all of which, I think, are in the appendix. We set out what these facts are.
So 16, 17, 18, 19, and footnotes.
The footnotes there too, pages.
There too, right, footnotes
yes,
as well, yes.
So is this document the statement envisaged by the rules?
Yes, it's both. If my Lord will look at the first page, paragraph 1, page 37.
Ah, yeah, I do see that, yes.
Yes. I should say that behind that, there are difficulties as to these rules. And I might just say in parentheses that it is well known that this is an area of law which requires extensive modernisation and reform. There's a joint law commission's project as to that at the moment, which has issued papers, and I'm not going to go to them. There are difficulties even as to the rules of court themselves, which have really stood as they are at the moment since 1869, with a single exception that the power to make them has moved from the judges on the rota to the Court of Session. Apart from that, there's just some rewordings. The rules clearly contemplate that the trial will be a trial of evidence, and so they call, as I've said, for the statement, which we have here. The rules are mandatory in providing that such a statement must be lodged 6 days before today of any matters upon which a party seeks to lead evidence ultimately. And after some, I have to admit, humming and hawing on our side, we thought that we were bound under the rules to lodge that statement by last Monday. But that's why it is done in this way. And for obvious reasons, we saw no advantage to anyone and no requirement to do this by way of a separate statement to the note of argument itself. But this is the statement, it says so. Now, the facts, we say, are really uncontroversial to a large extent. The inferences to be made therefrom may not be. But we say that on the facts as placed before the court in our note of argument stroke statement under the rules, the court could really answer these questions, all the questions before it today, at this stage. But it is clearly within the powers of this court to take the view that it would require a further hearing and evidence. Of that I'll come to, as I've said at the end, I propose to address the orders that might properly be made. What I propose to do at this point, by way of introduction to the three issues put before the court, is to observe, under reference to section 106(1), which can be seen, in fact, quoted in full, just in our note of argument at page 38, for convenience. It's obviously in the bundle as well. terms of section 1061, these are the matters which seem to be agreed and which don't seem to be agreed. First, underlining a person who. Mr. Carmichael says that he's not a person within the meaning of the Act. So he disputes that. A person who makes or publishes any false statement of fact. He does not dispute that he made certain statements. He does not dispute that he made the statements we rely upon, the Channel 4 and the Daily Record. He does not dispute that these statements were statements of fact. And he does not dispute that they were false. He doesn't admit the word false in terms. The euphemism used in his answers was a misstatement of awareness. But he has described them elsewhere. We footnote these and refer them to it later in the history as dishonest and untruthful. And he's certainly not come before this court claiming that somehow or other they are not false within the meaning of the Act. He does not dispute that this was before or during an election. He does dispute that this was for the purpose that he made them, that is to say, for the purpose of affecting the return of any candidate at the election. Our position being that his purpose was to affect his own return, and by obvious logic, the return of the other candidates in Orkney and Shetland.
Sorry, just say that again. Your position is that his purpose was to affect his own return, and then what was the final bit?
By obvious logic, the return of any other candidate in Orkney and Shetland.
Right, right. You mean if he succeeded, others wouldn't?
Exactly.
Right.
This goes back. There's a rather, I might say, optimistic argument put forward in some of the earlier cases that if somebody said, I don't care who wins so long as it is not X, thus in Tron Mine, somebody said, I don't care who wins so long as it's not the Conservative, that wasn't for the purpose of affecting the return of the Conservative candidate. It was pointed out, of anyone but the Conservative candidate, it was pointed out logically, it's all or none. The truth is, in a competitive election, it's all the candidates. But we don't need that. It's for the return of himself.
I think your petition goes on to refer to candidates in the general election.
Yes, we do. That's simply an error in law. And I should just say on this question of the weaker alternative, that just jumping ahead, perhaps, rather, but it comes in at this point. The test of the weaker alternative has always been about averments of fact. It's never been about arguments in law. What you see in the petition, and this we have to take responsibility for, I suppose. It's a hurried petition, and we didn't at that stage feel able to commit to a view as to what a parliamentary election was. We hadn't at that stage seen the Interpretation Act. So we're keeping our options open at that stage as to the law, but the statement of facts makes it all perfectly plain. But it's no more a weaker alternative than if somebody says, well, this is either a defective piece of machinery or it wasn't properly guarded.
So just say that again. It's either...
I'm sorry, I'm putting it badly. This is something which either comes under the section dealing with defective machinery or it comes under a section dealing with proper guarding. It's probably bad to go into analogies at all.
Yes, I think so.
Yes.
Could be
I think my lady
difficult.
has the point. This is about the test of the weaker alternative is about averments of fact.
Yeah.
What we have in the petition is something about law, but the whole matter is cleared up anyway.
Is it really? I mean, I just wonder, because the averment, there was one factual averment is that his motive was to affect his own return, and another factual averment is that it was to affect the return of people in the general election as a whole. So these are not two averments of fact rather than questions
Well,
of law.
ultimately, his motive or his purpose, whichever word one uses, is a matter of inference from primary facts.
Yeah.
So just point us to the part of the petition where, just so that we can clarify that. I mean, it just strikes one that, as you're acknowledging that candidates throughout the country had nothing to do with it, perhaps that should be deleted. But sure is the averment.
Well, if there were provisions for amendment of a petition...
you would do that, but you don't think there are?
I have to say I don't know.
Oh, right.
And the reason I say I don't know is that I do not know, looking at Chapter 69 of the Rules of Court, reading them and rereading them, it is not clear to me whether they incorporate the chapter of the Rules of Court dealing with amendment.
Right.
What we do say in the immediately following sentence, however, is all we needed to say. The recitation of the allegation.
Yes, so I'm looking, what paragraph of the petition is it?
That's paragraph 9 on page
Paragraph
11.
9.
The first respondent, having before an election,
yes, I see,
and for the purpose of effecting the return of a candidate at the election, made an admittedly false statement of fact in relation to his personal character as a candidate. That's following the language of the section. The words, the two lines immediately above, whether that election is taken to be, is simply a reflection of our uncertainty at that point as to how, as a matter of law, this cut. Mr. Dunlop's absolutely correct in saying, as a matter of law, it becomes plain on reflection that this is constituency specific. All of this is in our note of argument and statement of facts, in which we set out at length and with sourcing material from which we say that the only reasonable inference that might be drawn is that this was for the purpose of effecting the return of the candidates in Orkney and Shetland. Now, there's a fallback, of course. It may be that it's not the only reasonable inference, it is one among others. But it is striking that nothing which we put forward on this is contradicted. I'll be saying under issue 3 that it's particularly striking that no other purpose is suggested. And it's the easier to take an inference that something was the respondent's purpose when he doesn't suggest anything else was. But returning to factual context, so far as we can see, there are no issues arising for this court other than the issues arising at this hearing. If the respondent loses on these issues, we win. There's no suggestion that there's any fallback position.
Although you're going to address us on the possibility of the need for proof in respect of the third chapter, is that not right?
I don't know, I have to say, quite what the respondent's position is on this. They do seem to accept that Chapter 3, at least, is a matter of the factual context of the inferences that can be drawn. They have their argument on relevancy, which I've taken at the beginning because it's really a preface to the whole way this court approaches its task. And of course, if they're right on relevancy, that will be an end of the matter against us. But if they're wrong on it, there's really only two possibilities. One is, as we've suggested, that the only reasonable inference is what we say. And the other might be if it was suggested that there was, however, something more. But the latter is not suggested at this stage by the respondent. Now, that deals with the factual context, which is the background to this case. And I can now proceed to go to the first issue, which has been described as the self-talking issue, although it now seems really to have, in a sense, two parts. There's the laudatory versus defamatory point, and there's the candidate himself versus the rest of the world, or possibly his team, him and his team, as opposed to the rest of the world. I'm not quite sure, but I think it's the former. Now, these are separate points in a way which perhaps doesn't fully emerge from the notes of argument, but Mr. Dunlop is quite right to address them distinctly, because they do require different issues to be looked at, different questions. We've dealt in our note of argument pretty fully with both. And I will be saying that it is evident on a proper construction of section 106(1) that it doesn't matter whether a comment is laudatory or defamatory or neither or even both. That a statement may be both was actually brought out in the Hansard debate pointed to. And I will further be saying on the candidate question that the words with which the section begins, a person, simply mean what they say. Mr. Carmichael is a person. Now, I propose to begin, it's not in our note of argument at all, with the genesis of the section and the Hansard references which are in the supplementary bundle. At 6:29, I don't want to spend too long on this because the court's already read through this. We see Hansard's note of Mr. Bolton. Hansard at that time, I should say, did not take the precise form that it does, that it began to take in the early 20th century, and the court will see that this is not using the exact words, but that doesn't matter. Mr. Bolton moves this, as he says, as a non-party measure. He said that the fact that it was drafted by Sir Henry James was a sufficient guarantee that it had been carefully framed. And then he notes the evils which he describes, and he notes the prior parliamentary history. Interestingly, he notes the amendment about halfway down the page, the second tag. The 1883 proposal had been very different. Any person who before, during, or after an election, after, of course, went out, by poster, placard, cartoon, caricature, or other publication, that all went out, it just becomes makes or publishes, knowingly publishes, that, of course, then became a statement as to what reasonable belief. And then, importantly, this: any false charge of or against a candidate, or the false statement or withdrawal. Now, I don't think we'd be in court if we had to say that what Mr. Carmichael did was a false charge of or against a candidate. That's clearly directed at what he says the later language of 1895 was all about.
And just tell me exactly where is that on the page, this false charge?
I have it as about 2/3 of the way down the page.
Oh yes, I've got it now,
Yes.
thank you. Yes, yes.
The line begins
Right.
Gibson.
Yeah, no, I see it. Thank you.
Yes. But it was decided, apparently on Sir Henry James' advice, that wouldn't really do the job. And so the language which we have today is what's used. Mr. Bolton, who I appreciate was an English solicitor, said this is fine because it deals with what he sees the real problem, the making of false and libelous and defamatory statements. It's quite clear when one reads the whole tone of the debate that many members of the House of Commons at that stage felt very angry about what was said about them by their opponents in a more exuberant age than we have today. And there is debate thereon. There are many anecdotes, counter-anecdotes, explanations of the anecdotes, and so on. At page 1070, however, moving away from anecdote, the question of principle of drafting is discussed by Mr. Henry Matthews, who was a distinguished QC and a former Home Secretary in the outgoing Unionist administration, who first makes the point about how this ought to be looked at as a matter of principle and electoral theory. There's then a discussion with the Attorney General, and then importantly Mr. Matthews says this: it is because he thought the personal character and conduct of the candidate were of great importance in duly and properly influencing the vote of an elector that false attacks made on that character and conduct ought, in his opinion, to be treated as electoral offences. He expected to hear the Attorney-General explain that the bill struck as much at laudatory falsehoods as at defamatory falsehoods. He could well imagine, in a constituency in which temperance vote was powerful, the case of a candidate's agent having supped with the candidate soberly but yet joyously, publishing next day the statement that the candidate was a teetotaler and thereby winning him a large number of votes. Such false statements of fact in regard to friends were, though intended to be laudatory, struck at very properly by the bill just as much as false and defamatory statements. The word friends, of course, is simply 19th century usage that covers political allies and agents. And it's clear from any reading of the political history of the time that, in fact, candidates tended to stay very quiet. Many of them, of course, didn't even visit their constituencies. The comment made in North Louth by-election that Mr Hazelton, who lost his seat, hadn't even been in the country during the election period. But people left this to others, and that's why perhaps it didn't really matter whether it's a candidate or somebody else. Anyway, that is Mr Matthews. Now, the only point that then brings this up in this debate, Sir Donald Macfarlane of Argyll then comes out with another of these entertaining anecdotes about accusations made against a crew of his yacht found one Sunday poaching for salmon. And that's about a third of the way down 1071. That's then commented upon, just for completeness. Mr Henry Labouchere, at 1073, in a rather light-hearted speech, over the page 1074, notes this and says, interestingly, that he thinks this is all rather exaggerated. In fact, he had always thought that a little suspicion of poaching did no harm to a radical candidate. I should say Mr Labouchere was himself a radical. Which makes the point, I think, quite well. You cannot make a clean division between laudatory and hostile. Just as with the temperance statement. Perhaps. But certainly, a claim that somebody's associated with, as he puts it, poaching on a Sunday, would no doubt lose some votes and gain others. So matters stand at the end of second reading, and on the following page, as an issue as to further procedure, Mr Bolton moved the bill be referred to the Grand Committee on Law. There's a question about that, but that's what's done. Now, the next tab notes that at third reading, the motion was for the consideration of this bill as amended by the Standing Committee. Now, until 1907, the debates in Standing Committee were not noted as debates in the Commons were. And all that we have been able to obtain on that is the report from the Standing Committee, which I can hand up.
And do you have copies? Yes, you do. Yes. All right, thank you. Thanks very much.
Now, our researches and those of the Advocates' Library have certainly satisfied me that there is nothing more that can reasonably be obtained as to what was said in Standing Committee. And what we have, however, is if one goes in that, the page numbers begin at 489 in the top right. to 494 to 5, Friday the 24th of May of 1895, on the left-hand.
So what are the page numbers of reference?
I'm sorry?
The page numbers, where do they fit
Oh,
in?
yes, well, yes, it's page 6 in terms of the internal pagination.
Yeah, I just wonder how you get the figure. Why do we have a 489 up there? That's just, I just wonder, should this be called something? It's like 32 or something like that, or 8?
It will have to be. I mean, perhaps it's easiest because we are 20 to 4. We can do that after the this afternoon. But certainly for present purposes, it's the Standing Committee minutes. At the internal page is 6. The hearing of Friday the 24th of May, members present. Discussion on amendments as to the Corrupt and Illegal Practice Prevention Act, and a number of questions. There are some amendments on that page. And then on the next page, the right-hand page, another amendment proposed after the word make to insert the words or publish, put and agreed to unanimously.
Sorry, where are you reading from?
That's from the top of the right-hand page. It begins another amendment proposed.
Yes, but top of right-hand page being page, internal page?
Internal page 7.
7, right, thank you.
Next paragraph, amendment proposed after the word false to insert the words and injurious, Mr. Henry Hobhouse, who'd spoken at second reading. Question put, that the words and injurious be there inserted. The committee divided, yes, 9, no, 10. And among the 9 was the promoter of the bill, Mr. Thomas Bolton. So one sees that the issue Henry Matthews had raised, that this struck at laudatory falsehoods as well as injurious, had struck home. And one sees that Mr. Bolton's view that the matter should be restricted so as to cut them out was not the view of the Standing Committee. Now, much is said, and can always be said, of how if Parliament meant to show that something was the proper interpretation, it could have done that more easily. But this is the easiest way of doing it, and it's simply rejected. So what we have in my submission is a clear rejection of the proposition which had been put forward by Mr. Bolton, and he'd been voted down in committee, that this should deal only with the injurious statements, the vilification.
Sorry, I'm maybe losing the plot a wee bit. The proposal was to insert the words and injurious.
Yes, into, if the Lord has the section, it would be any false and injurious statement.
And Mr. Bolton was in favour of inserting those words.
Mr. Bolton wanted that inserted. That's his own bill. And of course, the only reason why he wanted it inserted was so that the bill would do what, as Mr. Dunlop has said, he wanted. And the committee didn't.
Are we to deduce from that then that Parliament was in favour of striking at laudatory statements or mixed statements, if you like?
It's difficult to make very much of this for a number of reasons, and the first is asking, if I may say so, Mr. Dunlop slightly skated over this, how one applies Pepper and Hart to this at all. One has to have he said the condition, there's a clear statement by the promoter of the bill. Whether minister or private member doesn't matter. There's a second requirement, of course, that there has to be an ambiguity or obscurity which can only be resolved by looking at that. But the third requirement is, of course, that the person who makes that statement in promoting the bill actually gets his or her way. Mr. Bolton didn't. Now, one can't, I think, ultimately make a great deal out of this in either direction. But what I would say is this, that Parliament was fully aware that the issue raised by Henry Matthews QC was a real one. And it was a real question as to whether that would be good law if enacted or not.
So just again to clarify for me, the issue raised by Mr. Henry
Matthews.
And it was Matthews, was it?
Yes.
It wasn't Henry Hobhouse, was it?
No, Henry Hobhouse had been he was a Liberal MP who supported Mr. Bolton in this regard.
Oh, right.
And indeed, he made a speech at second reading, but it was he who then moved this amendment at committee.
Yes, Mr. Matthews at 1070, I think you're referring to.
Yes. I'm sorry, I didn't catch.
Mr. Matthews at the bottom paragraph of 1070 is it?
Yes, that's right. Yes.
Paragraph.
Right. Thank you.
He wasn't on the committee.
And his name is Henry Matthews, is it? Is that right?
Yes.
Just to be quite clear.
Yeah, just up.
I'm sorry, if perhaps.
Oh yes, that's right. It is. Yes, that's quite right, Henry. It's on page 1070. Yeah.
1070, the first point.
The first entry.
Yes, he's the Conservative MP for East.
Yeah. So it was his suggestion, but it was a Mr. Henry Hobhouse who put it to the committee. Is that right?
Well, put it to the committee, in effect, that the bill should be limited to false and injurious.
Right.
Which only makes sense, of course, if one's accepted the point as to what the bill does without that that's made by Mr. Matthews.
So you're really saying your answer to Mr. Dunlop's argument about look at what the promoter wanted is, well, the promoter may have wanted that, but he didn't get his way.
Exactly.
Right.
And further, that Parliament was fully conscious, both at second reading and in committee, of the effect of language. Now, so matters stood in 1895. The Act has been twice consolidated in the representation of the people legislation. But the language that we saw in 1895, which is now subsection 1 of section 106, has stayed. As a matter of history, there was a fairly substantial quantity of litigation upon this until the First World War. One can see that from O'Malley and Hardcastle's election reports. And then it ended, it would appear. some of the most vicious campaigns, it seems, described there were fought in 1910, a very close election. Both of them were. One can only reflect that elections became cleaner after then. One way or the other, not much use was made of the matter. Thus, as has been already pointed out, the paucity of Scottish litigation, also a paucity of English and Northern Irish litigation on it as well. It seems to become more of an issue in the last few years. Woollis, of course, was identified as rather of a shock when it came out. Among others, by Mr. Carmichael himself in an article which we quoted. There was Rachman, in which the false statements were really just part of a system of exuberant corruption across Tower Hamlets. But apart from that, it doesn't seem to be much of a problem. Very, very few cases. Now that then takes me to the question of the judicial reception. The very, very few cases I mentioned have not had before them the question in this case. It's said in a respondent's note of argument that it's always been supposed that this case couldn't have come up. That is simply wrong, and one could no more take that from the comments of the judges which he founds upon. That one could take an argument that the words "a person" carried the old 19th century implication that one saw ran as far as Nairn against the University, that the word person did not include woman.
Yes, that's the Elsie Ingalls case, isn't it?
I think it was.
Yes. 6 candidates seeking to be able to take part in the election.
Yes.
Or not 6 candidates, but 6 graduates of St Andrews University.
Under the university vote.
That's right.
Yes.
And the legislation held not to allow, well, the word person didn't include woman.
Yes.
That's right.
Yes.
Yeah.
One might as well run the same argument now on this consolidated legislation.
Well, the word person
didn't include women. Just because it has, to use Mr. Dunlop's phrase, been supposed that it didn't. The truth is that there are 2 cases only in which the matter has come up. And then there are cases, which Woollis is actually probably the best example, where it's been pointed out that a person just means a person, any person. And of the 2 cases, neither is binding upon this court. The matter is simply open and fresh.
So you say it's never come before the courts before?
It's come before the court. It's been brought up expressly before the court once, and I'll come to that. But not in an enormously helpful manner. It certainly supports me as far as it goes. It was taken for granted that my argument on this was correct. And it's been commented upon by Mr. Commissioner Murray in Erlam, which was addressed. In parentheses, I should say this. Mr. Murray's status is a Deputy High Court judge, but of course he sits in the election court, not as a High Court judge, because we see the analysis in Woollis. What can be said is that there is probably nobody in the United Kingdom with more experience of election law cases. One sees his name on every significant trial in England in recent years pretty well. The authorities that I will be pointing to are limited, but in my submission they are supportive of me. And the first is the case of Banks against Lewis, which is in the bundle. Yes, 6/12 at page 684. And I think I'll just have time to deal with this
That
before.
one case, yes.
Yes.
Right.
That will then be a
An
proper
appropriate
break.
moment. Right.
Sorry? 6.12.
Just looking for it. Right, yes.
It's an unreported decision of the Court of Appeal. Tony Banks against Arthur Lewis. There's no representation for the respondent, only from the appellant. What had happened here was that Tony Banks was the Labour Party candidate for Newham North West. A non-party independent candidate, one sees this on the first page in the indented paragraph numbered 3, called Arthur Lewis, claimed that he was the official Labour Party candidate 38 years. I should say that at that point it had come to be realised that there was a potentially very effective abuse of the statute by people claiming a misleading or false party identification. The classic example was someone who stood, and I think got 14,000 votes, claiming to be the literal Democrat candidate in the southwest of England, with the luck to have his name at the top of the ballot paper.
People can make up a new name with everything beginning with A to get on the top of it, that kind of thing.
That's been done too.
Yeah.
Yes. But so far as party descriptions are concerned, a problem which has since been struck at is people who simply assert falsely that they are the candidate of a particular party or that they have a particular description. And that's what Mr. Lewis did. There's a description then given as to the facts. Then over the page, Mr. Watkinson, who's appeared on behalf of Mr. Tony Banks, has relied upon section 106(1) of the Act, which is quoted. The only other relevant provision is subsection 3, which provides expressly that the High Court or a county court may issue an injunction. Mr. Watkinson puts his case in two ways. He says that Mr. Lewis's statement, which of course I assume to have been made since the matter is being considered ex parte, that Mr. Lewis's statement, "This is Arthur Lewis, your official Labour Party candidate," amounts to a false statement by Mr. Arthur Lewis in relation to Mr. Arthur Lewis's own personal conduct. So that's the first one. And the second one is taking it the other way, saying it's an innuendo about Mr. Banks. Now, the first one is the significant one, the self-talking. And incidentally also, I suppose, in Newham North West in those days, a laudatory statement, because presumably the reason Mr. Lewis does this is because he sees it as a pat on his own back. The language is pointed to And the court then says this: what has to be established is the making or publishing of a false statement of fact in relation to the candidate's personal conduct. For my part, I am not satisfied that for Mr Lewis to state that he is the official Labour Party candidate constitutes a statement in relation to his personal conduct as opposed to his personal qualification. It is arguable there's a distinction between qualification and conduct. Now, with great respect to the argument for the appellant in this case, I would have thought that there could be no stronger example of something which is a political statement rather than personal than a statement that one was the official candidate of such and such a party. And I don't understand how it could seriously be asserted that that was a personal statement. But for immediate purposes, the self-talking issue, the court seems to have taken it for granted. Other members agreed. Albeit ex parte, without argument, the court seems to have taken it for granted that in principle self-talking was struck at.
Interdict or an injunction granted?
No.
No.
Because the court took the view, and as I've said, I would, with all respect to Mr Watkinson, I would have seen this as absolutely inevitable, that this was not a statement. Mr Lewis was not making a statement about his personal character or conduct.
Right.
They then deal with the other argument that this was an innuendo against Mr Banks, but that doesn't affect the case today.
Yeah. So really you're drawing our attention to the fact that the court just took it for granted that Section 106 applied.
Yes.
Right.
Now, as I say, I don't make much of it. The court itself points out that it's not had full argument. It's an ex parte application. There is no argument for the respondent. But in the light of that, it cannot be said that the authorities have supposed or assumed that self-talking is excluded.
Well, now in that particular case then, would it be an appropriate moment to break?
Yes.
And reconvene tomorrow at 10:30?
10:30, certainly, yes.
Well, that's, I think, what we'll do.
I think, my lady and my lord, have my song sheet for tomorrow morning. Yeah. I'll go straight into Earlham, fairly obviously, quite briefly. I'll deal with other aspects which are largely as brought out by our note of argument.
Right.
And I will then pass to the question of personal character or conduct, and I'll then pass to the question of purpose and what the court might do.
Well, that's very helpful. Thank you very much, Mr Mitchell. So we'll adjourn for today, reconvene at 10:30 tomorrow.
Well, that brings us to the end of the first day of the court hearing into the legal bid to overturn the election of Alistair Carmichael as the MP for Orkney and Shetland. Let's return to our panel, composed of the Professor of Law at Glasgow University, James Chalmers, the writer and broadcaster, Lesley Riddoch, and the Liberal Democrat councillor and former Holyrood Minister, Robert Brown. Now, before I sort of tease out one or two of the issues that were raised there by Jonathan Mitchell and get you to respond specifically to them, in a general sense, what did you make of the arguments that he advanced, Professor Chalmers?
I think by and large these were the arguments that we expected. What I didn't anticipate was there being quite so much argument initially about the procedure involved here, and he quite properly pointed out this is not the Court of Session. It's taking place in the Court of Session, but it's a different court. That has certain procedural consequences which I think came across as being very dry, but could actually be very, very important, because part of what the Mr Dunlop has been trying to do here is suggest the case should be dismissed because the evidence that the petitioners might need in certain points is not excuse me, highlighted in the petition. But this being an election court, we're not restricted, or the court's not restricted in quite the same way, and it can look for evidence.
He did actually make that point, that this is a UK court. Yes. This is not the Court of Session. So what are the consequences for how this might proceed, given that it is an election court? Is it to do with the fact that the procedures, the law of evidence is different?
Well, it's not so much the law of evidence is different, but that it opens up more of a prospect of Alistair Carmichael being called to give evidence at a later stage. Now, it's too early to judge whether that's likely at all, but perhaps after that argument looks slightly more likely than it did earlier on.
Robert, it did take him an awful long time to get to the meat of what Mr Dunlop had argued, which was all in relation to Section 106 of the 83 Act. What was your take on these sort of procedural issues that he was raising right at the beginning? Where did you think he was going with all of this?
I found it very difficult to find out where he was going. I mean, if Mr Dunlop was fairly slow in getting into his argument, he was Speedy Gonzales by comparison with Mr Mitchell. I'm not sure that I totally agree with Jim on this one, because it seems to me that there's two possibilities here that I think Mr Mitchell was arguing for, if you like. One certainly is that there might have to be some evidence at a later point. But he did rather suggest as well that it would be possible, because of the narrowness of the dispute on fact, to actually dispose of the case more or less on the arguments. And I'm not quite sure which horse he's actually given himself to there. Well, that was the kind of main sort of theme of where we went, and fairly overriding issue. Really.
Before I come to Lesley, let me just ask Professor Chalmers. One of the things that he did say, and it followed on from his line about this is a UK court. He said this is not a debate on relevancy at all. It is part of the trial to be debated in that context. So is he driving here a line of argument that, depending on what the judges decide, Alistair Carmichael might have to come to court and give evidence?
Well, the Scottish courts have always taken a very strict approach to the relevancy of the written pleadings in a case, and you don't get to found in things that you haven't highlighted in your pleadings. What he's suggesting is that doesn't quite work in exactly the same way in the election court. It doesn't work in quite the same way in England either, and that there are other documents that they've lodged that provide a basis for potentially calling against later on. Now, as Robert said, it may not get to that stage, and I agree, I'm not quite clear what horse is being ridden here either. There was some suggestion that, well, actually this could be dealt with simply on the basis of the papers. There was also suggestion, though, that there was a possibility there which Mr Dunlop, I think, was objecting to, or suggesting was unlikely, that Alistair Carmichael might be called to give evidence. But at this stage, I don't think we know whether that's likely or not.
Lesley, like me, you're a non-lawyer here. I learned rather a lot about the history of the Representation of the People Act and why Parliament framed things the way that they did. I suspect for a lot of viewers, they're sitting there scratching their heads saying, and what specific relevance does this have to Mr Carmichael?
Well, and they might not be alone. I mean, at one point, Lord Hugh Matthews said, I'm losing the plot. I think we all said amen to that, but clearly he's losing it in a more specific way than perhaps the rest of us. But sure, I mean, we've basically spent a long time back in 1895 and thereabouts looking at the kind of circumstances that provoked the Act, and then trying to sort of read from that, whether it can be narrowly or more extendedly kind of considered. But I think for probably the average viewer, it's a bit like reading a newspaper without headlines. There's an argument begun and you just aren't quite sure what the overall point is. I mean, we find ourselves here regularly having to ask the legal guys, where is this really going? And I think clearly that's the way court can operate. But I find it surprising that if it's a complete cul-de-sac, the judges can't basically smack it down. But there you go, that's me.
Yeah, Robert.
So I was going to say, one other small point. I mean, I noticed that Mr Mitchell made the suggestion on the whole business of whether it was Orkney and Shetland or the whole election, if you like, that he was surprised that the respondent, i.e. Alistair Carmichael, hadn't suggested some other purpose for what took place. Now, I'm not sure that I see where he's going on that one, because it's up to the petitioners to prove their case, as I understand it. I don't think it's actually up to Alistair Carmichael as such to prove anything. Obviously, things admitted and things agreed. And that might itself have some implication, I think, on what evidence was given, because although the suggestions we made, Alistair might be forced to give evidence, that's actually a choice for him at the end of the day, presumably on the advice of his lawyers, if there's anything to be added by him giving evidence.
Well, I'd taken a note of that as well. It came at a point when, with this rather quaint expression, misstatement of awareness. That's an interesting one. And he said that the purpose, this was what Mr Mitchell was arguing before the court, the purpose of the misstatement was to affect his own election return. He then went on to say that the only reasonable inference that can be drawn is it was to affect his position. I have to say I wasn't particularly persuaded like that. That just seemed to me to be assertion on his part rather than assertion based on evidence.
I think certainly another natural reading of it is that whatever Alistair Carmichael said was more about influencing the national election campaign. Now, whether you then want to argue that, well, if you're talking about influencing the national campaign, you must be talking about influencing your own as well, so you can't separate this out. I don't know if that argument will feature. But the Hugh McDermott case, which was mentioned earlier on, does suggest you can draw that distinction between here is something which is about the national campaign, here is something which is about the campaign in the constituency. So I'm not, like you, persuaded by the argument that this is the only possible interpretation of what was said.
OK, well, what did Mr Carmichael's constituents make of today's proceedings? Let's go back to Nicola McAlley.
Well, yes, Bernard, we're still here at the King's Hall in Kirkwall. Most of our audience have dissipated now for the rest of the day, now that the legal proceedings are over for today. Certainly a lot of interest here. People have been coming in because STV has a big screen here for Mr Carmichael's constituents to come in and watch these proceedings live in a historic situation. And I'm delighted to be joined by one of the petitioners for the case, Carrie Welling. Now, Carrie, you've sat through, we saw your representation start to be made there this afternoon. Obviously, we've adjourned until tomorrow, but what do you make of things this afternoon, and you're getting the chance to get your point put across?
It's very difficult to recognise our point because the guy's like a legal historian, our QC. But I'm just hoping that the judges are really up with the law too and they understand what he's saying. I'm just about hanging in there. I can understand what he's saying, and I think he's refuted all of the beginning of Roddy Dunlop's kind of case against. And he certainly started to make good points, like why self-talking is actually included in this law, should be actually recognised as the law pertaining,
And you're happy with how things are going for yourselves? I mean, just recap for us why it was so important for you and the other petitioners to bring this case.
Speaking for the other three people probably isn't fair. For myself, I really wanted him to stand for re-election. I wanted him to resign straight away and give the electorate a chance to kind of say, yeah, have another chance. Because he's really popular here, And I think there might be a backlash. I think if he was to sort of resign now and stand again, I think he'd get back in.
That's what we think at the moment, Carrie. Thank you very much. I might come back to you in a wee second. I'm also joined by Dennis Gowland, who is a supporter of Mr Carmichael's. What have you made of this afternoon's submissions?
Well, as a layperson, I found it extremely difficult to follow, but that's the nature of these legal arguments. Sometimes people think that people are going to be cross-examined and it's going to be all fireworks and things in the court, and it's not really like that. My reflections are really on the democratic process as demonstrated in this constituency, Orkney and Shetland, both on September the 18th and then on May the 7th. And I feel there's been a lack of respect for what's been demonstrated after the ballots. And I feel very much that that's the background to this whole case, why this case was brought. And I feel disappointed that some people feel that the democratic process isn't enough.
We were hearing from both sides, really, it's not about the political, it's not about the personal, all these kind of things, but surely the constituents here are saying, well, we feel our MP did not tell us the truth when we went to the ballot box.
Well, I suppose the best people to answer that are those that actually voted for Alistair Carmichael, and have since decided, well, they made a mistake because they were relying on particular aspects of his personality or however. I think what the petitioners have failed to do, even in their background to this and in their various demonstrations, silent demonstrations outside the cathedral within a few days of the announcement of this, really lost sight of ordinary people in the constituency. And they haven't really given any evidence of people like me who voted for Alistair Carmichael and would not change their view and feel that this is really a kind of is a flim-flam.
Well, thank you very much indeed, Dennis Gowland and Carrie Welling, who is one of the petitioners. We'll be back here tomorrow, and hopefully lots more of Mr Carmichael's constituents will be joining us here in Kirkwall. For the moment, back to you, Bernard.
Thank you very much indeed, Nicola. Let's pick up, Lesley, on a point that Carrie Welling made. She said she found it difficult to recognise her points in the submissions that were being said. I suspect that that's actually that will be a common view. And it really does indicate, doesn't it, that you can have circumstances out there, once they're into a court of law and it's in the hands of lawyers debating points of law, it's the points of law that it turns on.
It is, and it seems that it very much turns on what the roots of this bit of legislation are, and therefore what you can extrapolate from them. So we've gone very much back into history for half of this, which I don't think any of us expected. But then she also said that perhaps unexpected thing, where she said it's very possible if there was a re-election, actually, Alistair Carmichael would win because he's very popular. But this is the point I think we've been trying to make all along. That's the view of an awful lot of people in Orkney, and that's kind of why they were annoyed he didn't just do that and let everybody have a second go, because he would have possibly had quite a mandate. Yeah, it was an interesting point that she made indeed. Well, at the start of the afternoon session, Mr Carmichael's QC, Roddy Dunlop, put forward the final chapter of his submission.
Moving to the third and final chapter of my submission, and this arises, of course, because of the requirement in section 106 that the impugned statement be uttered for the purpose of affecting the return of any candidate at the election. This is the sentence on which the petitioner's case in this regard is perilled. Against a background of polling which indicated the SNP would gain the majority of votes in each of the 59 constituencies in Scotland, with the result that no Liberal Democrat or any other political party would obtain a Scottish seat at Westminster, it is believed and averred that the statement by Mr Carmichael was for the purpose of affecting the return of the candidates at the election, whether that election is taken to be the constituency or the general election as a whole. Now, the 2 points which we seek to make really arise from that one sentence. First of all, the averment is predicated on the formula believed and averred. It is necessary for that belief to be a justifiable inference from primary facts. The only primary fact advanced is a background of polling which indicated that the SNP would gain the majority of votes in each of the 59 constituencies. Now, that might explain the motivation behind the leaking of the memo in the first place, as it might be said to be harmful to Ms Sturgeon, but the petitioners accept that they cannot complain about the leak itself because Ms Sturgeon was not a candidate in the election.
Well, that was the final point that Roddy Dunlop QC made in his submission, but he started that submission way back at 10:30 this morning, and if we look at that submission in totality, summing up his arguments, he was saying that the petition was irrelevant, that in terms of the interpretation of the law to the circumstances that are complained about, that the judges should take a narrow interpretation, because he said if they took anything other than a narrow interpretation, then the floodgates could open with all sorts of candidates coming forward with petitions complaining about what opponents were saying. He also said that the legal authorities that we've had beforehand, we'd heard about the case back in 1965 and then the most recent case of Phil Willis, the authorities bore this out, and critically in relation to section 106 of the 1983 Act, that the conduct complained about was political, not personal, and therefore the ambit of the Act didn't deal with that particular conduct. Let's now look at some of what Jonathan Mitchell QC had to say.
He does not dispute that he made certain statements. He does not dispute that he made the statements we rely upon, the Channel 4 and the Daily Record. He does not dispute that these statements were statements of fact, and he does not dispute that they were false. He doesn't admit the word false in terms. The euphemism used in his answers was a misstatement of awareness. But he has described them elsewhere. We footnote these and refer them to it later in the history as dishonest and untruthful. And he's certainly not come before this court claiming that somehow or other they are not false within the meaning of the Act. He does not dispute that this was before or during an election. He does dispute that this was for the purpose that he made them, that is to say, for the purpose of affecting the return of any candidate at the election. Our position being that his purpose was to affect his own return, and by obvious logic, the return of the other candidates in Orkney and Shetland.
Sorry, just say that again. Your position is that his purpose was to affect his own return, and then what was the final bit?
By obvious logic, the return of any other candidate in Orkney and Shetland.
Right, right. You mean if he succeeded, others wouldn't?
Exactly.
Right.
This goes back. There's a rather, I might say, optimistic argument put forward in some of the earlier cases that if somebody said, I don't care who wins so long as it is not X, thus in Tron Mines, somebody said, I don't care who wins so long as it's not the Conservative, that wasn't for the purpose of affecting the return of the Conservative candidate. It was pointed out, of anyone but the Conservative candidate, it was pointed out logically, it's all or none. That the only reasonable inference that might be drawn is that this was for the purpose of affecting the return of the candidates in Orkney and Shetland. Now, there's a fallback, of course. It may be that it's not the only reasonable inference, it is one among others. But it is striking that nothing which we put forward on this is contradicted. I'll be saying under issue 3 that it's particularly striking that no other purpose is suggested. That it doesn't matter whether a comment is laudatory or defamatory or neither or even both. That a statement may be both was actually brought out in the Hansard debate pointed to. And I will further be saying on the candidate question that the words with which the section begins, a person, simply mean what they say. Mr. Carmichael is a person.
Well, that's a flavour of a statement of the obvious, that Mr. Carmichael is indeed a person, a flavour of what was said there for the petitioners. James Chalmers, just talk us through, once he finishes his submissions tomorrow, what are the options that the judges have, and what are the consequences of the decisions that they could reach?
Well, there are two obvious possibilities. One is that the judges will feel they are able to decide the case on the basis of the arguments alone. I would be surprised if they announced that decision there and then, but they'd be more likely to take time to issue judgment later on. They may feel that they need to hear evidence from Alistair Carmichael, or potentially from elsewhere, but it's difficult to see where that would be in order to make a final decision. They may even feel they need a bit of time to decide whether they need to take that decision. So we're not likely to get a final resolution tomorrow.
And if they decide that they wanted to take evidence, they want to revisit this issue, presumably this has a pretty significant consequence for costs.
And actually, so we've already seen just how much money has had to be raised to set up this two-day hearing. So another day, I mean, I don't imagine the evidence would be any longer than that. It's obviously going to add significant costs and to the delay in the process, that a date would need to be found when both judges were free to hear evidence. So it could be then some time before the case is resolved.
Lesley, for viewers that are just joining us, just talk us through or remind us about how this action has been funded and what the consequences may well be if this process goes on longer than the 2 days.
Well, it was funded by 4 complainants who were able to put in their petition before the deadline on the 29th of May, which was 3 weeks after the election, to make a complaint. They were warned at the time that they would have to find the money to prove that they could conduct their side of the case. That was first of all £60,000. Then it was increased, so they've now got £87,000 raised by crowdsourcing. So I think 5,000 people roughly have contributed to this. And if it goes on, they may, if they lose, they may have to find the costs of the other side of Alistair Carmichael. If he chooses to ask for it, we established earlier that he could, if he was feeling flush and generous, he could decide not to ask for costs. But if he does, which he's perfectly entitled to do, if he wins, they could be having to find the same money again.
Robert, you are a qualified solicitor. You've heard many legal arguments over the years. Are you reassured by what you've heard in court today?
Well, I have to confess I've not been involved in election petition before, so I don't have a background to go on in that regard. On the whole, I think I'm reasonably pleased with the way the thing has gone, but I think this uncertainty about what the procedure will be is the big question mark that hangs over it, you know, if it goes to proof, if it can be decided now. And bear in mind, if I may, that the costs issue plays both ways. You know, I mean, whoever loses on this, and bearing in mind it was the petitioners who brought it, you know, have got landed in quite significant costs.
And a reasonable point to make. Well, we have come to the end of our STV News special covering the first day of a court hearing of the legal bid to oust Alistair Carmichael as the MP for Orkney and Shetland. We'll be back here at 10:20 tomorrow morning for the conclusion of the proceedings. In the meantime, for more analysis, log on to stv.tv/news and tune into our news bulletins on STV. And Scotland Tonight, of course, at 10:30. From all of us here in the studio, goodbye.